Okay, the audit committee will come to order. Can you take the roll?
Sure. Broughton,
Here.
Dellen. Here. Duran. Here. LeBron. Here. Lee. Here. Manning. Here. Bertula.
Here.
Everyone's here.
Okay, thank you. Just a reminder that this is being webcast, so we would ask that you turn on your mics if you're going to be speaking. We're going to be talking about agenda item 3A, and there is very little, at least for me, to present you at this point, so I'm going to turn this over to John that will discuss the item.
Public comment.
Oh, excuse me, that's right. It wasn't on my list. Is there any public comment on this item?
Seeing none.
Okay, hearing none, now I'll turn it over to John.
All right. Good morning, everyone. So I'm going to present item 3A, which is the adoption of the 2019 audit work plan. And as you know, that staff prepared really just an overall summary specifically related to the accomplishments in 2018. A lot of the items on the audit work plan are routine or regular from year to year related to overseeing the financial audit, reviewing travel expense reports, and working on other audit-related projects. Last year, this committee did recommend to the board the new auditors, which is Macinas, Genie, and O'Connell, and also completed and oversaw the 5-year internal control audit. For 2019, many of the items still remain from 2018, except that there's really two that have been, or three, I should say, that have been sort of added. One that started in October, which is the state auditor's audit, which we would anticipate seeing a draft, hopefully in March or April, with the final report being completed in May. This committee will be reviewing those recommendations and then making any recommendations to the board or responses to the auditors. The other item that's going on is the LAO review for the Legislative Analyst's Office, which would be completed in July. Really the big change for this year, and this is in comparison to last year, there were ORIA performance audits were on the work plan. And as we started that process, it was really sort of turned a little to really focus on compliance reviews. And this really stems from things like the fingerprinting that was not being done by the state bar. And so ORIA had started putting together a listing of compliance items that the state bar should be monitoring and ensuring compliance on. That list is approximately 240 items in which ORIA is looking at individually with each of the offices to ensure compliance. Based on those reviews and identifying items to ensure that we're in compliance, if there's areas that are of concern, ORIA would do performance reviews and audits on those such items. And so that really is one of the major items for the 2019 work plan. The work plan is attached on page 4. And I won't go through it all, but it really just identifies the major items of the work plan, expectations as far as dates to the committee and to the board, and then any reference to strategic plan initiatives or goals and objectives. So with that, staff is available for any questions. No, she's not. No, okay.
I'm sorry?
We're good.
Okay.
Items deemed approved. Motion's approved.
Thank you very much. With yep.
Should we not have any discussion? Okay, we're adjourned.
Yeah, thank you. I appreciate that.
Hello, this is San Francisco. Shall I go ahead and call the person?
Tom, no, not yet. We'll let you know when.
Okay, thank you.
Hey, Tom, who is the person in San Francisco that we're supposed to call in? Is that a public comment or a member of the staff? Oh, okay.
Not for finance and planning.
No.
I was like, what?
Okay.
Just so everyone is aware, we're required by the agenda to wait until the 9:15 start time. So, yep. Okay, we're going to go ahead and begin our webcast for the Finance and Planning Committee. Could we have roll, please?
Broughton. Chen. Here. Dallin. Here. LeBron. Here. Lee.
Here.
Mendoza.
Here.
Stallings. Here. Steinbreaker.
Here.
Okay, we'll begin if there's any public comment. I don't see anybody banging down our doors, so we'll go ahead and proceed. There is no chair's report. Let's go ahead and move to business item A, the annual review of debt collection efforts and a request to modify debt collection process. And Linda Katz will be presenting on that. Go ahead, Linda.
I'm Linda Katz with the Office of Research and Institutional Accountability, and I've submitted a report providing a summary of the debt collection efforts. And as I'm not going to go over it in detail, but I'm going to point out in Table 1, what we see is that the bar currently has about $237 million in outstanding debt. However, almost 75% of that is really hard to collect because it's CSF payouts that are not included in a Supreme Court order. So the debt that we can get an automatic judgment on is the discipline costs, because those are always included in a Supreme Court order, as well as a CSF payout where there is a related restitution order in the discipline order. And for those two types of debt, we do reduce those to a Superior Court judgment. And with those judgments, we file a lien with the county recorder, where the last known residence that we have for the attorney. And so we have not been very successful, as Table 2 shows. The amount that we collected altogether in 2018 was just under $380,000. Since 2008, we've collected a total of $1.4 million from these different types of collections efforts. And so, and the average that we've collected since 2008 from collections agencies has been about $28,000. From bankruptcy filings, when there's excess funds after all the bankruptcy has been discharged, it's been an average of $37,000 per year since 2008, although in 2018 we had one bankruptcy filing where we got almost $107,000. That was just from one filing. And from the title companies, we've gotten about, from these liens on judgments, we've gotten about an average of $48,000 per year. And so we looked into better ways for collecting debt. The challenge we've had with the collections agencies is because they're in a position of a third-party collector, and so they can't do things like levy bank accounts and garnish wages. We pursued statutory amendment to the Franchise Tax Board's court-ordered debt program, and which went into effect this year, which allows the state bar to participate in this program, which is separate from the tax intercept program. We've been participating in the tax intercept program since 2014, and we've been very successful in that. That's actually been a good source of revenue. We've gotten $175,000 in 2018. That is limited to tax refunds and lottery winnings, and so that's why it's not a full collections effort. And all of the revenue that comes in from that source has to go to legal services program, even though it's costs from the discipline system. It has to statutorily go to legal services programs. And so with this new court-ordered debt program, the Franchise Tax Board pursues that debt as if it were delinquent taxes. And so they have much more teeth in the collections efforts. They can garnish wages and levy bank accounts. So we do expect to see more robust collections in those efforts. It won't include the vast majority, the 75%, that's the CSF payouts that don't have a related court order, because it can only collect court-ordered debt. Yes.
Hi, Renee LeBron. But have you, is there any kind of estimate, like how much potential there is? I mean, it sounds like a lot of these people just file bankruptcy and there's no assets to pay what's owed anyway, regardless of who goes after them. But do you have any idea how many people that's not the case for? Like, what's the potential?
Well, it's really hard to estimate. So the potential is the total amount of debt. So,
Well, right, but is it your sense that 80% of these people are bankrupt and have no assets anyway, or?
I don't
just
think
don't
we
know.
have any way of knowing that.
You could probably just do some kind of sample and see, you know, pull a sample and see how many filed bankruptcy and, had no, I
We
mean,
could,
because you realize, you find out after bankruptcy what's left over, right? Because you said you get some amount. So you probably have some idea of how many bankruptcies were reported to you. And you could look and see how many of those were, and, that was 300 of our 500 cases, and we got $3 for that, or, whatever. I mean, you do have some data that you could roughly extrapolate from. It would just be useful to know before we think about how much effort we're putting into this, really what's there. I mean, if there's a lot of people who aren't fully bankrupt, like, that's a lot of money.
right, and I expect that with the participation in this franchise tax board court order debt program, we will be more successful in collecting. But we can certainly look into that. One of the things that we looked at was the cost of collections, as you mentioned. And most of the costs, table 3 shows the costs, and we estimated that it was about $190,000 in terms of mostly in staff resources that were spent on the collections program in 2018. Most of that work is in pursuing these superior court judgments, whereas we were collected about $90,000 in those judgments during 2018. So it's not been the most cost-effective effort, but there was a suggestion that rather than pursuing judgments against all in all these cases, that we instead do a search, a LexisNexis search, to find whether people have property, and only file the judgments when we find that property. And so that still is only going to result in success if the property, if there's a sale or a refinancing. But so that is what we'd like to do, and that's what's on the proposal for you to approve, that we change that process and only pursue judgments against people who have, where we find property.
And I want to clarify why this is coming to the board, because this is a subject, our overall collections program, or our efforts or lack thereof, has been the subject of a review by the state auditors. And we have been subject to criticism in years past for having lax collection efforts. And at one point, there was a decision made several years ago to just cease pursuing judgments at all because of this cost-benefit analysis. We, about 3 years ago, reinitiated the entirety of the collections program. We began to pursue judgments. We contracted with a new collections agency and sort of really gave it our all in terms of seeing what is the maximum amount of revenue that we can generate from this system as it currently exists. As Linda indicates, it's not very much, and the actual cost-benefit analysis does not suggest that we should be pursuing judgments at all. But there is sort of an overlay here, or a bit of context that I want to make sure you understand, that when we scale back our collections efforts, it makes sense from a pure fiscal perspective. But there may be other reasons, policy reasons, why to consider with respect to whether or not to scale back the collections effort. We certainly are recommending that we do so, but it's important that the committee understands that it has been an area that the bar has been scrutinized for in the past.
Renee, and then Jason.
Yeah, I would think you certainly would not want to give people the impression that, hey, don't worry if you get fined a lot by the bar, because they'll never come after you, right? So I think you want to make sure that you have some kind of collection effort, but that you're able to segment the cases in a way that you're putting the appropriate amount of effort. So you're doing a bunch of cases in a way that has very low cost, and the ones where you can get something, as you've alluded to, So people are clear, like, yeah, we're going to come after you, and this isn't, get off scot-free. And the other risk, which I think you're alluding to, is people see that number and go like, oh, that solves your problem, just get that money, right? So as long as you're showing that you've got this $125 million you could go after, people might not be sympathetic to our needs.
Jason Lee. I do remember the discussion about the collection efforts several years back when I first joined the board. Do we ever consider just outright selling the receivable at a discount? Can we do that? Is that
Collections agencies, you mean?
or to some other? I mean, there are professional folks who take that off your hands at a fraction or discount, and then they engage in their own pursuit, and they are very good at doing that. And it's sort of
I'll let Linda
that's what
tell
their
you why
business is.
that hasn't worked for us.
Okay.
Why-
It's different
well,
than just
we
hiring a debt collection. It's literally
Right.
taking your whole block of receivables, selling it after an evaluation to professional companies that then go and pursue those receivables.
We haven't pursued that, just selling it, and I actually don't know why we haven't pursued just selling it to a separate vendor, because that's been the reason the collections vendors we've contracted with haven't been that successful, is because they don't own the debt, and so that's why they're limited in terms of what they can pursue. I think that I don't know how attractive our debt would be to someone who wanted to just buy it outright. They would have to do that evaluation and determine if it was worth paying anything for it.
Yeah, I mean, I think there's always some value. I think at this point, there's going to be a lot of receivables that are quite aged. But then if you think forward, as we do accumulate that debt, I think that will be a little more attractive because they'll own it, and then it'll be more recent. But just another way to approach what seems to be a vexing problem.
Do you think, Linda, even our debt where there's no associated underlying judgment, which is the vast majority of our debt, and I mean, I just don't know the answer to this. My understanding is that that's not collectible as it currently exists.
It's not collectible absent actually filing a case in a court.
And
Because
that's
there is
been the
no
issue.
court order related to most of the CSF debt. It's 90% of the CSF debt. There's no associated court order. So I think that would be expensive to pursue relative to the other debt.
It would seem to be maybe on its face, especially the way we operate, but these debt collection agencies, they're mills. I mean, they just have everything down to just a process. And the one debt I needed to have collected, I just assigned the full debt to them, and then they just, they give a percentage of whatever they collect. So there's really no risk in it for them. It is something we should be looking at with respect, but I'm not sure how the Franchise Tax Board collection effort is going to impact our ability to get more money or the attractiveness of that debt. Would a collection agency be able to get the Franchise Tax Board money if we assign
Our
the debt?
experience with collections agencies has been the least effective, and it's not for a lack of trying. I had some involvement in it in OGC before Linda, took it over, in Araya. Some of it is water from a rock, and then the collections agencies, pretty shortly thereafter, don't want to be doing it anymore.
Well, we didn't assign the debt to them, correct?
No. Well, I think
Some of them wanted us to front money for attorneys. It became
Right, well, there's
out
a
of
difference
control.
between having them collect the debt and essentially
Understood.
selling the debt.
So you're
assigning
talking
it.
So
about
I think we should look into it.
Yeah.
I would say that I think it's different when there is no underlying judgment. Even for a collections agency, they have to have a basis upon which to collect the debt. But my suggestion is we enter into, or we may have already begun, the arrangement with the Franchise Tax Board
Yeah.
because our authority went into effect at the beginning of the year to do that. And then in 6 months, we come back to the committee. We see what has been generated through the Franchise Tax Board, and in the interim period, we can look into our ability to sell part or all of the debt.
And what we might do is look into selling the debt that the Franchise Tax Board cannot pursue. So we could segment that debt off and try to sell that. I think that's a good idea.
Yeah, I think it would be helpful to know whether or not that's an option and what we could get for that.
Having been in this situation in my last job, ultimately, various state agencies started going over to the tax intercept program at the Franchise Tax Board. That just became, after they tried all of the same thing, trying to get water from Iraq, they went over to the tax. I just said that I think the FTB tax intercept program became the go-to source for many government agencies, including the one I worked for before, under the very similar circumstances of a lot of effort to get assets or to collect from people who didn't have assets.
Sonia?
In the meantime, though, Sonia Dellen. In the meantime, though, can you revisit the staff resources? It's truly a large amount of money as with vis-a-vis the amount that we are able to collect. I mean, could it be through technology that you can lower the cost of the staff resources while we are determining whether to be selling or assigning?
Well, I think the beauty of the FTB approach is that there will be virtually no staff resources, or very little staff resources associated with that. And then the recommendation you have before you today really limits our pursuit of judgments, and that is very staff intensive. Well, it potentially limits. I mean, we're not sure when we do the LexisNexis search how many of these folks will in fact have property, but it will limit it from what it is today. So that's the current proposal, to reduce the amount of staff time spent based on limiting our pursuit of judgments to only those cases where, or those situations where a respondent does own property.
I recommend that the staff come back in 6 months. Let us know if this proposal we're looking at, assuming it passes, has in fact reduced the amount of workload on behalf of staff, what the Franchise Tax Board collections are looking like, and whether or not it's even an option to assign the debt that we can't collect through the Franchise Tax Board. So before the end of the year, that would be helpful for us to look at that, see how things are going. We have a proposed resolution. Do I have a motion? Mark moved, Jason seconded. Any objection to substituting the roll call? Hearing none, it passes. Thank you. Thank you, Linda. Next item for business is item 3B, discussion and adoption of the 2019 Finance and Planning Committee Work Plan. And that's going to be presented by John Adams.
Thank you. Good morning, everyone. So item 3B is the adoption of the 2019 Finance and Planning Committee Work Plan. Similar to the audit, certain items are pretty routine, including the quarterly financial report review, participate in the state bar budget process, review of financial policies and procedures, which there'll be several coming up this next year for review and implementation, and then assisting in the planning of the strategic plan session. The two new items, or at least two areas I want to focus on, is just the monitoring of the progress on the strategic plan and monitoring our new state bar performance metrics that Leah had talked about yesterday. Those will be two new areas for the 2019 work plan. The work plan is attached, and just going through it, the top two, monitoring progress on strategic plan and state bar performance metrics, are listed. I do list the finance policies within the work plan. Two of the areas hopefully will be brought in March, if not May, are the cost allocation policy and the cost recovery policy, which are new policies recommended by prior reviews and the state auditor. And then anything else I want to highlight? Everything else is relatively routine. So with that, I don't know, Leah, if you want to talk about performance metrics or strategic planning monitoring. No? All right.
Well, I just, real quick, on those, since they're new items and this committee hasn't really done this before, Highland and I will work with John to find a way to present that those issues to the committee in an efficient manner. We'll determine what we really need to be focusing on, and if anybody has a preference for how it's done, they should contact John and let him know. But we'll have a chance to talk about it going forward. Hopefully at the March meeting, we'll have something to kind of kick it off and see what everyone thinks about how we're doing it.
Yeah, for the March meeting, you'll have your first set of report on the metrics, those metrics that are monthly in nature.
So,
We have a proposed resolution. Do I have a motion?
So moved.
Moved by Alan, seconded by Jason. Any objection to substituting the roll call? Seeing none, it's passed. Thank you, everybody, and we're adjourned.
Good morning, everyone. I'm Sean Seleg, co-chair of the Regulation and Discipline Committee, and I'm ready to call our committee to order. Can we take the roll, please?
No.
No.
Broad? Here. Ellen?
Here.
Durant?
Here.
LeBron?
Here.
Lee? Here. Mendoza? Here. Bertula? Here. Selleck.
Here.
Collins.
Steinberg.
Here.
First, I'd like to call for public comment. I understand we have someone in San Francisco who wishes to comment by phone. Let me first ask if there's anyone present here in Los Angeles who would like to offer public comment. Hearing none, I will ask the person in San Francisco who would like to speak. Please, we're glad to hear from you. Please keep your comments to no more than 3 to 5 minutes.
Actually, we're gonna have to call Bernadette Spade.
Okay.
Thomas is gonna. Tom, can you poll please?
Hello, this is Tom. I'm going to put the conference call in right now. Hello, this is San Francisco. I just conferenced in Bernadette Spade.
Good morning. Are you there?
Yes. Hello, Ms. Spade. Thank you for joining our meeting this morning and offering public comment. We're glad to hear from you. Please limit your comments to 3 to 5 minutes and go right ahead.
Thank you. Good morning. My name is Bernadette Spade. I'm speaking to you today because you have a predator attorney on your hands who has victimized at least 5 clients in the last 3 years. Her MO is consistent, deliberate, calculated, and intentional. She preys on young single mothers who need their child support payments and seniors like me. She takes clients' retainers, then misses hearings, doesn't respond to phone calls, makes her clients beg for invoices which arrive months late. In my case, it was 6 months after we fired her, and which invoices are in direct violation of California bar standards for invoicing. She also refuses to refund any monies unless and not until she is forced to do so. All the information I'm providing today has been documented and can be provided if requested. I want to note that I was informed just yesterday that I would have the opportunity to address you regarding this matter, so I'll apologize in advance for any inaccuracies or misstatements regarding your current policies of which I may not yet be aware. Having said that, I did learn also just yesterday that complaints can now be filed online, so kudos to the California Bar for having implemented that convenience. That was not the case when I filed my complaint in January 2017. My story, which is only atypical regarding my age, not my circumstance, is that I am a 60-year-old retired legal professional from Florida, having moved to Los Angeles in October 2015 to help my divorced, single-parent, 50-year-old nephew care for his 5-year-old son. 6 months later, my nephew died, and I was thrust into the legal battle of my life. I have also become disabled, which disability and timing, in my humble opinion, is no coincidence. My family hired Tamara Benefield in September 2017 for each a probate and a child custody matter. After accepting my family's representation for a fee of $25,000, Benefield attended the first probate hearing and then disappeared. She was a no-show at 2 subsequent hearings, after which we immediately fired her, November 2017. I finally got one invoice in May of 2018. I received a refund of about $15,000 shortly after termination, filed a complaint with the California Bar, and for an additional $450 filing fee, filed for fee arbitration to get the rest of my money back. So here I am now, over a year later, still waiting for resolution of my complaint and still fighting for the remaining $9,000. That $9,000 is 1/3 of my annual income she's withholding fraudulently and yet sanctioned by your current policies. In order to survive here in LA, where I'm virtually being held hostage if I have any chance of getting my money back, I've had to take a job to survive, and in spite of my physical disability, am working at an Amazon warehouse, the only place that would hire me. There are no words to describe the physical pain I endure each and every shift that I work. So I address you today, having also discovered, thanks to internet reviews, that there are at least 5 other Benefield victims, hoping to initiate a change to your system. 3 of her victims have filed complaints with the California Bar, and 2 more are in the process of compiling their information. And just to show how egregiously Benefield's behavior has impacted our lives, one of her victims is a single working mom now getting chemotherapy and radiation treatments, coping with a condition which is a direct result of the stress she suffered because of Benefield's behavior. All of us victims have waited months and are still waiting to be made whole by a system that is very broken. This calculated predatory behavior is happening on your watch. Lee Wilson, your executive director, states on your website, quote, "Our job is to protect Californians. We value transparency, accountability, and excellence," end quote. If that were the case, why was my public records request for merely quantitative information for the number of complaints filed against Benefield denied, deemed, quote, exempt from disclosure? And how difficult would it be to implement a simple monitoring system of the number of hearings any one attorney misses, which would red flag repetitive offenders, and then make that information available to the public so we can make informed decisions regarding substantial required retainers? It's a stacked deck we're facing, and you are the only entity in a position to make a change. Please honor your commitment to the public, to protect us, and to value transparency by actually providing it. Thank you for your time.
Thank you, Ms. Spade, for your comments. I'm very sorry to hear about your situation. I do want to let you know that our committee is a policy-making committee, and we don't have jurisdiction over individual cases such as yours. We will make sure that our staff puts you in contact with the Office of Chief Trial Counsel, which is responsible for assessing complaints like yours, and can update you on the status if that's appropriate. And as for your Public Records Act, that's within the purview of our general counsel, and we will check with her regarding your request. But we appreciate your public comment, and now we will move on to our next item, which
Well,
is...
I just need to interrupt, please, if I may. I am in touch with the Chief Trial Counsel, and I need to understand, if you would, please, and if someone wants to call me about it, that's fine, why a simple policy of red flagging no-show appearances in courtrooms cannot be monitored, or is not monitored, and who has jurisdiction over that. That seems like a policy issue to me, but, I don't know.
That's a fair point. We'll look into that with the staff. It's not something we have on our agenda today for discussion, but it's something that can be looked into.
Okay, may I have your name, please?
Yes, Sean Seleg.
Spell the last name?
S-E-L-E-G-U-E. So, ma'am, we need to move along now to our agenda.
I understand.
Thank you for participating.
Thank you.
All right. Now we're going to move to the oral report, and I'm going to give a few comments about what we have planned for the year ahead, which, of course, is also the subject of item 3F on our business agenda, the work plan. And so when I'm done with the oral report of the co-chair, I will take that item out of order and ask for its approval. So RAD has a busy year ahead of it, overseeing our disciplinary system. The work plan's on our agenda, and you can see what we have in store for us. I want to highlight a few of the more important things. We have some significant innovations underway. As our public commenter mentioned, the online attorney complaint system is online now, both in English and Spanish, and it is turning out to be very successful in providing a means for the public to make complaints about attorneys in a convenient and efficient way. The CMS implementation is ready to go live within a matter of weeks, and that's going to enhance our operations and efficiencies in a number of ways, including the collection of data to help us evaluate how the system is working, and the elimination of manual processes that make that quite burdensome on our staff. In addition, planning is underway for a case file review to assess in an objective fashion various issues including charges filed as compared to charges on which culpability is found, possible implicit bias in the system, and other issues that are to be determined before that review gets underway. Finally, on our agenda today is an important proposal from the State Bar Court about protecting confidentiality. Witnesses, children, financial information, and the like, in light of the fact that our CMS system is soon going to allow state bar courts to be made available online, which creates some policy trade-offs between transparency and protection of privacy. So with that, I will conclude the co-chair's report and take up item 3F on our business agenda and ask if there's any discussion of our work plan. Joanna.
Joanna Mendoza. The question I had is, during one of our prior meetings recently, it was decided we wouldn't change the structure of RAD, but we had talked about, instead of doing that, we would move a number of items that normally fall within RAD over to the full board. And I'm curious, I don't see that on the work plan. Is there any progress on that? What's the plan for us to do that?
The Office of General Counsel is still looking into that, and we'll come back with something in March.
Okay, great, thank you.
Okay. Any more discussion? May I have a motion to approve the work plan? Thank you. May I substitute the roll call? Hearing no objection, item 3F is approved. I will now move to our consent agenda. There's one item on the consent agenda relating to conviction proceedings. Does anyone wish to remove that from the consent agenda? Hearing no request, item 2A is deemed approved. We'll next move to the remainder of our business agenda, and item 3A has been withdrawn. We'll next take up item 3B, which is a proposal from the Office of Chief Trial Counsel regarding amendments to the standards for attorney sanctions. I'll recognize Melanie Lawrence, our interim Chief Trial Counsel here in Los Angeles, and I understand Steve Moad of OCTC is in San Francisco by phone.
We're going to have to call him also. Thomas, can you call Steve, please?
Yes, I'm calling right now. Please hold.
All right, thank you. Well, Melanie, I'll just ask you, is this the amended resolution on the screen?
Hello, this is San Francisco. I just conferenced in Steve Moat.
Thank you. Steve, welcome to the meeting. We're ready to take up item 3B, and I'll allow Melanie to start us off.
Sure. Good morning. So you may recall that we were here in September asking for some items to go out for public comment, and they relate largely to the new rules of professional conduct. And in keeping with those new rules, needing some amendments to our standards guiding levels of discipline related to violations of those new rules. We sent those out. There were a number of them. Again, most of them related to the new rules, with a few others that we attempted to just make some clarifications for. What we did after September is that we engaged in some significant discussions with our discipline partners. So that included the State Bar Court and the defense bar, discussing the proposals. And we've come back now with some requests, including, Steve will highlight some requests in this item, to actually send out for public comment some of the items that, after those discussions, we've made some changes to that we think are material and therefore require some additional opportunities for public comment. Then we'll have another item where we've been able to actually reach agreement on the proposals, some which we've made small changes to that were non-material and that we'll be asking for the board to actually approve. With regard to this particular item, I will note, and Sean, this relates to your question, the resolution itself has not actually changed because it was a generalized resolution that didn't refer specifically to the standards. But since we actually prepared the items, we noted that with regard to standard 2.6, that there was some language in there that really did not need to be there, and frankly probably made it more confusing having it in there. So we have actually asked for 2.6 to be withdrawn from the request for approval and added to this item. So the actual item, and I'll have copies for the board members, the item that you see actually has the amendments, which include the references and changes to 2.6 and the attachment with the changes to 2.6. And I'm going to turn it over to Steve to just go over some highlights for you in terms of the changes that we're looking for.
Steve, before we do that, let me just check procedurally. So we're going to, for the benefit of the committee, we have two items on the agenda today regarding amendment to these standards. Item 3B is asking for final approval of certain amendments, and item 3C, which is not on the table at the moment, is asking to send certain amendments out for public comment. So Melanie, are you deleting 2.6 from item 3B and adding it to 3C? I just want to be sure.
That's correct.
Understanding procedurally
Right, yes.
what we're doing. Okay, and our general counsel, that's acceptable? Okay, thank you. Steve, please go ahead.
Thank you. Yes, as I'm getting some feedback, so I apologize if there's any confusion in my speaking. As Melanie mentioned, we are withdrawing standard 2.6 from item 3B and inserting it into item 3C. So a couple of highlights regarding item 3B. The first is standard 2.10, the unauthorized practice of law. I want to draw your attention to the fact that this standard was not required by a change in the rules of professional conduct, because both the old and new rules prohibit California attorneys from practicing law or holding themselves out to practice law in jurisdictions where they are not authorized to practice. The change instead is proposed to eliminate a source of confusion. Standard 210 currently applies to attorneys who are actually suspended for disciplinary reasons or are on involuntary inactive enrollment under Business and Professions Code Section 6007. Thus, a literal reading of that standard makes it applicable only to UPL in California. The proposed modification makes the standard applicable to UPL by a California lawyer in another jurisdiction as well as in California. Currently, we use standard 2.12 paren A to apply to UPL in a non-California jurisdiction, and we use that through Business and Professions Code 6068 paren A. The proposed change will make standard 2.10 applicable to both, and it is consistent with Rule 5.5 and with case law. The application of different standards to the same conduct based on where the conduct was occurring was confusing, and so we're moving essentially to consolidate that into one standard. I would point out that this does not change the length of discipline, because both 2.10 and 2.12 paren A have the same length of discipline. Both call for disbarment or actual suspension. I will point out that as a result of our extensive discussions with our discipline system partners, there was one outstanding concern, and that is that the standard 2.10 does not track the rule, in that the standard creates two presumed sanctions based on the cause of the attorney's ineligibility to practice law. The rule, however, does not differentiate between the the unauthorized practice of law based on the nature of the ineligibility. However, this differentiation of sanctions was put in place by the task force in 2015, and we believed that a more significant alteration of the standard would result or would represent a major policy shift that was sort of beyond the scope of our authorization for this item. Unless there are any questions on this standard, I'll move on to a couple of other highlights in this agenda item. Not hearing any, I will move on to standard 2.14. And on this, I just want to point out that in the initial item in September, we had made a proposed change to add a specific subparagraph for violations of Rule 9.20, and that change has been withdrawn. During our discussions with the ADDC, they were concerned that many attorneys do not get disbarred for 9.20 violations, and so having a presumed sanction of disbarment was not an apt description of what actually happens. OCTC does not dispute the fact that many attorneys do not, in fact, get disbarred for such violations, but we believe that those cases represent a divergence from the standard rather than an alteration of the standard. Regardless, because this change was not required by a change in the rules, and because we could not reach consensus with the ADDC, which was our goal throughout the conversation, we have withdrawn this proposal. Next is standard 2.20, and this is a new standard that we had proposed. There are a couple of different pieces of this. The first applies to Business and Professions Code section 6131 and has, which states that every attorney who violates that section, quote, is guilty of a misdemeanor and in addition to the punishment prescribed therefore shall be disbarred, close quote. The ADDC's concern about this section was that they believed that the quote, is guilty, close quote, requires a finding of guilt before discipline can be imposed. However, this language is substantially similar to other criminal statutes that set out the elements of a criminal offense, and case law also discusses that no conviction is required. A second objection on the part of the ADDC was that disbarment is too harsh if there is no conviction for that section. However, again, based on case law and statute, disbarment is the presumed sanction. Proposed new paragraphs B and C are for violations of Rule 8.4(b) for criminal acts that are not being prosecuted as a conviction referral matter or for which there is no conviction. The ADDC expressed concern that there was no definition of the phrases criminal act or fitness as a lawyer. However, Rule 8.4(b) uses those phrases, and so we incorporated them into the standard. We do not believe that the standards for attorney discipline for professional misconduct is the appropriate place to define phrases used in the rules. Instead, the court should define the terms used in the rules, and whatever definition is applied by the court to the rules will be applied to the standards. During our discussions, we discussed the possibility of providing a wider range of discipline, along with the list of factors impacting the length of discipline. However, we ultimately rejected that approach. In so doing, we noted that standard 2.20(b), which applies to criminal acts reflecting on the lawyer's honesty, tracks standard 2.12(a), which applies to violations of 6068(a). Similarly, standard 2.20(c), which applies to criminal acts reflecting on the individual's fitness as a lawyer, tracks standard 2.16(b), which applies to criminal convictions not involving moral turpitude, but involving, quote, other conduct warranting discipline. Those are the highlights for item 3B that I wanted to raise to your attention prior to your consideration.
Great, Steve, thank you. Melanie, before we move on to discussion among the committee members, anything more to add?
No,
Thank you. So I also want to say, I want to recognize we actually had two working groups who represented OCTC and Discipline Defense Council and State Bar Court, and maybe other representatives who worked very hard on vetting these recommendations. And I want to thank all of them for their participation and input into this process. With that, let me open it up to discussion among the committee members. Joanna.
I just want to follow up what you just said and thank the Office of Chief Trial Counsel for working with the ADDC and the State Bar Court. And it prevents them from having to come to the board after the fact to bring their concerns. And I think it's really made a difference. It hasn't always been this way. So I'm really pleased how much we're working together to try and come up with the right outcome. So thank you very much for doing that. That's all I wanted to weigh in on.
Any more discussion? All right, is there any objection to substituting the roll call? Is that a motion I hear?
I will move the item.
Thank you. Second? Do I have a second?
Second, clarifying that that's with the change to remove the
2.6?
2.6.
Yes, so this
yes.
is with the item as amended to remove the amendment to
Thank
item
you.
standard 2.6. All right, with that, may I substitute the roll call? All right, let's take the roll then, please.
Ron? Yes. Della?
Yes.
LeBron? Yes. LeBron?
Yes.
Lee? Yes. Mendoza? Yes. Tulip? Yes. Selleck?
Yes.
Stalling?
Yes.
All right, the item is approved. We'll move next to item 3, and Melanie, once again, please take it away.
Okay. This is with regard to the items that we are looking to be approved. And I don't have many more comments. We went through the same exercise with these, and I'll just ask Steve if you have any highlights to share.
I do, thank you. I want to point out a couple of standards or several items that we discussed with the ADDC and the State Bar Court. The first is in relation to standard 2.2 on commingling. Again, this change is required because the new rules require attorneys to place advance fees into a client trust account. Failure to deposit into the client trust account may be a misappropriation or at minimum a commingling. As a result, we proposed adding the requirement to this standard, which is in many senses a lesser of a misappropriation, or at least a less serious offense. The ADDC expressed concern that the presumed sanction for commingling, which includes an actual suspension of 3 months minimum, is more severe than the presumed sanction for misappropriation, which is actual suspension without a 3-month minimum. This perceived incongruity exists in the standards as they are currently drafted, however, and is not the product of OCTC's proposed changes. The ADDC also was concerned that failure to deposit advance fees into the client trust account might result in discipline even where the deposit went into the wrong account as the result of mere negligence. However, attorneys are generally not subject to discipline for mere negligence, according to State Bar case law. If, however, the attorney fails to reconcile his or her accounts and does not discover an erroneous deposit in the wrong account, such conduct would be considered reckless or grossly negligent. So if there's an extended period of time where that erroneous deposit is not detected and corrected, that at that point may be disciplinable. Following our discussion with the court and the ADDC, we altered our proposal in 2 ways. The first is to clarify that standard 2.2a would not apply where there is evidence of misappropriation. If evidence of misappropriation exists, standard 2.1 would be used. We also clarified which violations of the new rule would be subject to standard 2.2 paren B. As a result of these changes, which we deem to be material from the prior version of our proposal, we are asking that this standard be recirculated for public comment. The next is standard 2.5 regarding conflict. And this proposal aligns standard 2.5 per NA with violations of Rule 1.7 per NA, Rule 1.7 per NB, and Rule 1.7 per ND. Proposed paragraph B of standard 2.5 covers rules 1.9 per NA, 1.9 per NB, and other conflicts that are materially adverse to former clients, especially those where confidential information may be used. In our discussions with the ADDC, they expressed concern that the former version of our proposal included current clients and that they should not be included in standard 2.5 per NB because Rule 1.9 of the new rules of professional conduct only applies to former clients. We do not disagree, but we were attempting to craft the rule to cover both violations of the new rule, 1.9, and the former conflict rules. To address the concern of the ADDC, we created the subdivision D to cover violations of the former rules. In time, violations of the old rules will no longer be charged, and paragraph D can be deleted. We have proposed new paragraph C of standard 2.5 addresses all other conflicts and the breach of common law duty of loyalty, for example, aggregate settlements, so on and so forth. There's an additional change that in our initial proposal, we included violations of Rule 1.9 per C and Standard 2.5 per C. However, following our discussion with the State Bar Court and the ADDC, we removed Rule 1.9 per C because we agreed that it was more properly considered a breach of confidentiality under Standard 2.6. Again, we deem these changes to be substantial or material, and as a result, we are asking that this standard be sent back out for public comment. The next is Standard 2.6 regarding the misuse of confidential information. Again, we have some substantive changes, including altering paragraphs A and B to cover rules 1.82, 1.18 per NB. We also proposed new paragraph C to address new Rule 4.4. Following our discussions with the discipline system partners, we removed, quote, the magnitude of, end quote, from subdivisions A and B in its analysis of harm because it was deemed to be unnecessary. Following the submission of the original Board of Trustees and RAD committee agenda items, we determined that including, quote, unless the current, former, or prospective client gives informed consent, end quote, at the end of subdivisions A and B was unduly confusing because there are other circumstances that may warrant revealing confidential information. As a result, we are eliminating that clause from those two subdivisions. While this change appears to eliminate an exception to the applicability of the standard, the change will not broaden the application of the standard because before the standard can be applied, a rule or statute violation must be established. In essence, if there is legal authority allowing the disclosure of confidential information, the standard would not be applicable. Because of this final change, we believe this standard should be sent out for public comment again. I also would like to point out Standard 2.13, sexual relations with clients. An earlier amendment to Standard 2.13 was previously circulated for public comment. Following our discussions with discipline system partners, we have significantly altered the proposal. We initially attempted to minimize modification of the standard, so we simply added, quote, requests, end quote, to the standard where it said, quote, requires or demands sexual relations with a client incident to or as a condition of professional representation, end quote. This was done to incorporate the implied coercion associated with a request that is, quote, incident to or as a condition of professional representation, close quote. However, during our discussions with the ADDC, we became convinced that this language was too vague. As a result, we have modified the proposal to directly track the relevant language of Business and Professions Code Section 6106.9. Paragraph A now parallels parts of Business and Professions Code 6106.9, paren A, paren 1, 6106.9, paren A, paren 2, and old rule 3-120, and involve outrageous and overreaching misconduct. The new rule 1.8.10 prohibits all sex with clients except for spouses and people already in a relationship prior to the representation. Violations of Business and Professions Code 6106.9 that do not fall within paragraph A are not as egregious. As a result, paragraph B should be sufficient to deal with both 1.8.10 and those other lesser violations of 6106.9. As a result of the substantial changes here, we are again asking it be sent out for public comment. Standard 2.15 involves criminal convictions involving moral turpitude. I want to highlight for the board that this proposed change was not part of our original proposal in September. However, it was a topic of discussion in our meetings with discipline system partners. The proposal is not required by a change in the rules of professional conduct. Instead, this proposed change is due to a change in Business and Professions Code 6102, which had not been passed at the time the other standards were sent out for public comment. We have proposed changes so the standard tracks the statute because the same sanction now applies to crimes where the facts and circumstances of the crime involve moral turpitude. The last one is Standard 2.20, involving conduct prejudicial to the administration of justice. This proposed new standard is to address violations of Rule 8.4 paren D. This rule is similar to Business and Professions Code 6106, moral turpitude. Therefore, the proposed new standard is also similar. But the purpose of having a separate standard is to allow the case law to develop separately and to minimize confusion between this moral turpitude standard and this new standard for 8.4 paren D. The ADDC, during our discussions, expressed concern about the definition of prejudicial to the administration of justice. Initially, we sought to allay their concerns by dividing the standard up into different subdivisions for intentional or reckless conduct versus aberrational and negligent conduct. However, there were a couple of issues with that, and we ended up rejecting that approach. The first reason is that, as I mentioned before, really the state bar does not punish for mere negligent conduct. And so we moved away from that approach. We also want to point out that Rule 8.4 paren D utilizes the phrase prejudicial to the administration of justice, and just like the prior standard in the other item, we feel that it is more appropriate for the state bar court to define those terms rather than defining them in the standards. I want to highlight for the board again that this standard has not actually changed since we proposed it in September. However, in light of our discussions with the ADDC and our initial attempts to modify the standard and our ultimate rejection of that approach, we felt it appropriate to send it out for public comment again.
Great. Steve, thank you very much. And just for clarity, I think when you were discussing the conduct prejudicial to the administration of justice, it's standard 2.21, actually. I think you might have misspoken and said 2.20. I want to highlight one thing for the committee, which is, again, and offer thanks to those who participated in the extensive discussions about these standards, that Standard 2.13 about sexual relations with clients relates to one of the most significant policy changes that the board and the Supreme Court made to the rules of professional conduct, which is, with certain quite narrow exceptions, to bar sex with clients altogether. And I think that's a very important change for public protection. It required a more nuanced discussion of what level of discipline is appropriate, because previously the rule covered only sex with clients in limited circumstances, such as when coercion was obtained. And the presumed sanction for that is disbarment. And as a result of the vetting process of this rule, we now have a more nuanced rule that distinguishes between what I would call more aggravated or egregious violations of this rule versus ones that may be not as egregious and therefore warrant a level of discipline lower than disbarment. So again, thanks to all of those who participated in those discussions and came up with what I think is a very good policy in this area. With that, Melanie, any additional comments before we open it up for discussion of the committee members?
No, thank you.
All right. Discussion. Mark.
Steve or Melanie, I don't know if this is included, or I just want to ask this question. There was a new statute that was passed within the last few months dealing with a mental health diversion of certain crimes. Actually, there's only a few that are specifically eliminated. And ultimately, that would allow for a dismissal of a criminal action if the person successfully completed diversion and if the mental illness, if you will, was a substantial factor in contributing to the crime. Has that been analyzed in terms of if an attorney was admitted to diversion under that statute, how the rules would apply to such a person?
Well, not in the context of these standards and these changes, and not generally speaking either.
Given to looking into that statute and how it might apply to the rules?
I can't say that there has, but given the fact that you're raising it, we can certainly do that.
Any more discussion? All right, may I have a motion to approve item 3C in its amended form that has been distributed to you and now includes proposed amendments to standard 2.6 to be circulated for public comment? May I substitute the roll call? Hearing no objection, item 3C is approved. I'm going to pass item 3D and return to it. I will next take up item 3E, which is proposed changes to the rules of procedure from the State Bar Court, and Tony Darling is going to present that to us.
Good morning.
Good morning.
The State Bar Court, in moving forward to an electronic age, has sort of engaged and identified a few problems that we want to solve before they become actual problems or potential problems. Currently, the State Bar Court has no rules of procedure that require any parties to protect confidential information in documents that are filed with the State Bar Court. Because we're going to start putting every document online once we get the electronic system up, that creates some problems. In the past, I know the board and the executive director have gotten complaints from people that confidential information was included in pleadings, and they didn't like it, obviously. In order to balance the State Bar Court's desire for transparency in all of our proceedings and our mandate that all of our proceedings are public, all our disciplinary proceedings are public, but also to provide proper protection for confidential information, we proposed a couple of new rules. The first two are changes to definitions, because we don't really have a definition of anything as to what's confidential. So we've added a definition of what is confidential information, which means any sensitive, personally identifiable information of an individual, not limited to social security number, date of birth, home address, driver license numbers, names of minor children, medical information, including information regarding mental health and substance abuse, and also personally identifiable financial information such as bank or other financial account numbers, routing numbers, and in that definition it says that such information should be redacted in any document filed with the court, including pleadings and exhibits. It also mentions that numbers can be redacted to the last 4 digits. The second definition we've added is what is a confidential proceeding. And that means any proceeding so defined by rule or statute as being confidential. Confidential proceedings will not appear on the State Bar Court's publicly accessible portal or docket. This is in the matter of really being transparent in the fact that we're not going to share this information so that people will know it's there. They're just not going to be able to see it. We'll be able to mask it. We've been able to do that previously because no one can access any of the documents anyway. Now they'll be able to access them, and they might be misled into thinking they don't exist simply because they can't see them. So this was an attempt to say, yes, the stuff's here, you just can't have access to it. So if people felt they needed it for some reason, they were aware it was there. We also proposed an amendment to the general rules of pleading, which simply was A before. Each assertion in a pleading must be simple, concise, and direct. And then we added a whole bunch more subsections to talk about that documents shouldn't include confidential information, as previously defined, unless it was relevant and necessary. So that's the first screen, is don't put it in if you don't need it. You know, you don't have to put the wife's name in. You can just say, you know, a significant family member. You don't have to put in the name of the hospital someone's being treated in. You can say, you know, a medical facility in such and such a city. You know, so just don't put the specifics in. So that's our first way of weeding out confidential and private information. The second is, if such information is necessary and you are going to include it, then the next level is to simply redact that information. If for some reason you need an account number in order to tie where money's going, just use the last 4 digits. It's not such a big difference. Or, you know, just blank it out. And then if a party is redacting information, they're instructed to file the redacted version with the court, but then to provide an unredacted copy to the other side and to the court itself, so the judges would have access to it. And then the last step is the most draconian, which is if you can't redact it for some reason, then you should, and you're filing a document that has this confidential information, then you should file it under seal. So we have trying to minimize the amount of information that is sealed so that we have as much transparency as possible while still balancing it with the need to not have people's private information just thrown out there. I've read some old pleadings and I kind of was horrified at the level of personal detail that was included. Mental health diagnoses, names of minor children, diagnosis of a guy's spouse. I mean, we just don't need that information to be out there and publicly exposing people to that. So that is Rule 5.40 on the general rules of pleading. 5.9, we simply threw sort of another shot at transparency into this one. It says that, except as otherwise provided by law, state bar proceedings were public except settlement conferences, portions of the record sealed by the court, and then we added, or determined by the court to be confidential. And Sean had pointed out that that seems to create some new process. I think, in fact, we weren't planning on, this wasn't intended to create a new process, but to simply just, again, more about transparency. If the court, for some reason, rules that something's confidential, then it's not going to be public. Let's say someone doesn't redact information. The other side comes into the court and moves to have it either redacted or sealed or deemed confidential so they can like order the party to redact it, then that also will be not available. If, however, it confused Sean, who is an incredibly astute reader of the rules, we may, after the public comment period, want to revise how that's worded and not have it create its own appearance of being a procedure. And then 5.10, we simply added that other confidential proceedings include American with Disability Act requests. We're getting a lot of those. It's, you know, somehow the pipeline has gotten out there and people are just making ADA requests so often. And they are confidential. Even OCTC doesn't get the specifics. They don't even see the final order. They just get an order saying, so-and-so's getting 20 more days to file their pleading. They don't know why. But we just, again, in the nature of transparency, wanted to put in there that those matters were things that the public and the other side may not even see. So we proposed these rules. Again, I so appreciate that Sean really reads these. He came back and said, you know, there's no provision in here for a procedure to challenge if someone over-redacts. And our initial shot was, well, if one party over-redacts, the other side is offended by it, they have a remedy, they can come in. But in fact, a third party doesn't have a remedy. And that third party is probably either going to be the press or the victim. And so Brady Dewar and I, who were working on this together, discussed, and we thought, you know, that probably calls for another rule. That we need to draft a different rule that sets out the procedures, how one challenges. There already is a procedure for challenging, you know, accessing sealed information We might want to do a different one, set forth specific standards, what you have to prove in order to get access to this information. And so I think it's a fabulous suggestion. It's the kind of information we hope we're going to get from the public comment period too. We've had a few discussions at Bench Bar about the needs for confidentiality, but I don't know that a lot of people have focused and put a lot of energy into it. So we thought the best way to start this discussion was to throw out some rules. So we're asking that you approve that we send them out for comment. And we may actually, from comments, decide to redraft them and send them out again, just as OCTC did. But this will get the conversation going. Any questions?
Great, thank you, Tony. Any discussion? Thank you. A motion from Brandon to approve. May I substitute the roll call? Hearing no objection, item 3E is approved. That leaves on our agenda only item 3D, which I am not going to participate in, and Alan will chair the meeting, the remainder of the meeting.
So 3D, this is not going to be the presentation of a proposed rule to send out, but I am going to give you a status update so that you know it's coming for March. We have encountered the filing, excessive filing by some complaining witnesses of complaints that have bogged down and required the expenditure of extraordinary resources by OCTC and OGC in the second look process. So we did some looking into this and have found that other discipline systems and other bars have what's known as a vexatious, either complainant or grievant. In civil court, it'd be a vexatious litigant situation. So just so you know, we're going to be drafting a rule for your consideration to send out to public comment for March.
All right. Are there any other questions or comments from the committee? We are adjourned. Okay, the programs chair informs me that there'll be a 5-minute recess, and then the programs committee will begin at about 10:40.
I think we can, I don't, I think we can do it. I don't need to waste my time. Okay, thanks, yeah. Definitely better, yes. I was no, I was not, it's been a tough week, so, but I think I'm recovering, so I just need some sleep. I had to leave here and go teach this class at UCLA. Yeah, that's why my class, well, I had like office hours 6:30 to 7, just had a short one, and then the class is 7 to 10. So, and then I had to drive home. Oh, God. At that hour, though? No, 20. Oh, yeah, yeah. From here to UCLA is probably 12.
Testing one.
I'm probably like 11. It took me, it was at 33 minutes. I made it all the way from UCLA home in less time than it took me to get from here to UCLA.
right, I'm going to call the Programs Committee meeting to order. Our trustee Dag is here, so if you could call roll, please.
Chen. Here.
Helen.
Here.
Duran.
Here.
Lee. Here, Lee. Manning.
Here.
Mendoza.
Here.
Tula. Here. Saleg. Here. Steinbrecher. Here. And Stallman.
Here.
I'll mark Lee as
Okay.
when he arrives.
Perfect. All right, we look forward to a fun and exciting discussion, but before we get to that, I'm going to call for any members who wish to make public comment on any agenda items. So I don't see anybody here in the audience coming to the podium. Is there anybody on our call who wishes to make public comment? All right, hearing none, I will move on to the chair's oral report. Yesterday we had a scintillating discussion on all of the activities that the bar has partnered with and continues to partner with in regards to access and diversity issues. As our chair has proclaimed in the past and as recently as yesterday, the heart and soul of the State Bar revolve around access and diversity issues. These aspirational goals continue to motivate leaders in the State Bar and other legal organizations to devote their own time and resources to ensuring our profession reflects the people that we serve. The legal profession is replete with stories of lawyers who selflessly give of themselves to volunteer in civic projects, educational endeavors, and community strengthening initiatives. The legal community is strong because individual lawyers care about the communities they practice in and work to make those communities as tightly woven together as possible. A firmly knit community necessarily involves an individual's right to access the justice system and access to a justice system that reflects the diversity found in our great state. To that end, we look forward to our discussions involving working with the California Commission on access to justice in a collaborative way to study access issues and implement an effective plan to best serve the residents of California. Access and diversity discussions rely necessarily on accurate data and analysis. Yesterday, we heard from various pipeline and affinity partners who work tirelessly to equip young people who have a desire to better the legal profession. Today, our discussions will touch on these programs and how the State Bar can continue to support the pursuit of excellence taking place every day in classrooms and offices across the state and ensure that the appropriate data is collected so the efficacy of our partnerships can be monitored and supported appropriately. Our discussion should revolve around a best practice review where we identify what works and identify what is important. It is part of a continuing dialogue that moves forward and learns from the past and pushes towards a future where our profession serves our ethnically and geographically diverse state in innovative ways through studying the effect of rule changes involving technology and legal paraprofessionals. To borrow a phrase used last year, with the wind of technology and innovation behind us, the State Bar stands ready to meet the challenges that the coming years will bring. An adroit, strong, and diverse legal profession serves as a pipeline to ensure that our judiciary continues to work towards reflecting the diverse individuals found in our communities. Our historical partnership with the Judicial Council has shown progress in diversity, and we look forward to working with the judiciary on common goals. The staff and trustees have worked together to synthesize what was discussed yesterday and direct our board discussions on changes to the bar's strategic plan and goals regarding access and diversity issues. And we will get into that in items B and C. So before we get to that, though, we are going to move on to our consent agenda. So does anybody wish to take any items off the consent agenda? Okay, seeing none, it will be deemed approved. On to business under 3A, revisions to the lawyer referral service certification rules. Return from public comment. We have Donna, I think. Okay. Donna, when you are ready, please take it away.
Good morning. So this item here is our final step in completing Objective C of Goal 4, which was that the bar review the lawyer referral service rules with an access to justice lens, with a goal toward eliminating barriers and increasing access to justice. We provided this committee an informational update at your August meeting, and then we brought the proposal to you in September with a request to circulate that for public comment. As a result, I'm going to present a very high-level summary, but I'm happy to answer any questions that you may have. To accomplish the objective of reviewing these rules with an access to justice lens, all of the lawyer referral service rules were reviewed under the following rubric. We asked, does the rule impede or discourage consumers from using an LRS? Does the rule impede or delay consumers in receiving a referral from an LRS? Does the rule impede or discourage attorneys from joining an LRS? Or does the rule unnecessarily impede an attorney from applying for certification as an LRS? If so, then we wanted to make an appropriate change to the rule. The agenda item highlights a number of changes that are proposed to the rule and that were circulated for public comment. Key among them include permitting the use of automated referrals. And because this is a new approach in California, the rule requires that the lawyer referral service employ sufficient quality control measures to ensure that the use of the referral doesn't reduce the quality of the referrals that are provided to those seeking a referral to an attorney. Following on a conversation that we had yesterday, the proposal eliminates the exception in the existing rule requirement that each LRS establish services for persons of limited means. And we put a list of examples, including modest means panels and in direct response to Justice Elon, limited scope panels, flat fee panels, and provision of free consultations. This clarification actually brings the rule more in line with statute. The rule proposal also eliminated the requirement for separate applications for each county that a lawyer referral service serves. And finally, sort of recognizing that we are no longer a horse and buggy state with the days of travel from county to county, with taking days for travel from county to county, and that we do have technology that makes distances a little bit less relevant. The rule proposal also allows an attorney to participate on panels for each county in which the lawyer referral service operates, so long as they can do so in a way that meets the client's needs. Think about the Bay Area. Your primary office location is in Contra Costa County. Under the rules, if the lawyer referral service also served San Francisco County, you couldn't participate on that panel. That doesn't make a lot of sense. That's not the way people practice today. As I said, we put this out for a 45-day public comment. We received 4 timely submitted public comments, which are described in the agenda item. One of the comments really was just a misreading of the proposal. The other comments were really in the nature of clarification requests. Really, how would I apply this change in particular to my lawyer referral service program? And the final comment was deemed not relevant to the specific rule proposal. We forwarded on to the Office of General Counsel as it was alleging antitrust issues. We also followed up with the commenter who made the untimely public comment, because from my perspective, the purpose of the public comment period is to make sure that we get everything right, and not just that we sort of hold people strictly to the timelines. That comment was also in the nature of providing clarification on whether or not they would need, that particular legal referral service agency would need to change their rules, and the answer for them was no, and so they were pleased that we followed up with them. The statute governing the lawyer referral service requires that all of the rules governing the certification of LRSs that the bar approves be approved by the Supreme Court. So this agenda item is requesting board adoption of the amendments and also board approval of submission of the items of the rule proposal to the Supreme Court for approval. And with that, I will answer any questions you have.
All right, does anybody have any questions for Donna? Any discussion? All right, can I have a motion? Okay, moved by Alan, seconded by Ruben. Jason joined us, so Dag, if you could take roll.
Here. Yes.
Lee. Abstain. Manning.
Yes.
Mendoza.
Yes.
Petula. Yes. Saleg.
Yes.
Dahl.
Yes. All right. Motion passes. Thank you. All right, on to item B. And I anticipate that item B can really serve to inform our discussions on item C. And so we will handle item C in due course. But I would like for the committee to review the 2019 Programs Committee Work Plan. If you could bring that up and kind of use that as a further aid to direct staff in what our goals should be and what we can do moving forward. So I would like to extend my thanks to Debbie, Hyland, and to Mark for all the work you did in our panels yesterday, and then for all the work that staff did, for our presenters, and coming before this body and really helping to shape a vision for this board and where we can go in these exciting areas of access and diversity. So today's discussion will hopefully be to put some ink on the paper. And I guess if we were a horse and carriage society, I would say ink to paper, but now it's what is it, digits to bytes? I don't know. Okay, we'll get away from that. But we had a short, or see, Dag, do you have that document we discussed? All right, so if you can draw your attention to the screen, we have some potential objectives to talk about. And before we get into that, yesterday we had a lot of questions of the presenters about the initiatives going on in California. But does anybody have any kind of general comments prior to kind of starting to march through the different objectives? Any kind of things that any committee members want this committee to keep in mind when discussing these objectives? Okay, Joanna.
The only thing that I would say is we heard a lot of passion, understandably, yesterday, and a great work that's been done. It's very hard for people to get their heads around the new bar and that we're a regulatory agency focused on regulation now. And I just think as we go through things, it's helpful to know or think of it in a concept of when attorneys are helping other attorneys, it's more a trade association function. And that's not our role. And so as we're looking at those things going forward, we need to kind of look at it in that structure to make sure that what we're talking about is not a trade association function.
So I guess one of the questions is, do regulators have the ability to regulate certain objectives? And two, I mean, is this something that we should be engaged in regulating? So I'll open that up for discussions. Jason.
I think to frame the discussion, I think we just have to look at the statutory language for what our mission is. So the legislature has provided us guidance. I don't think the discussion is whether the State Bar should be involved in this work. I think we are involved in the work. It's just more now, as Joanna has pointed out, it's just a distinction between is what's being proposed something that would be more rightly in a trade association like CLA or another regional bar association, or in my view, is this something the State Bar should take on because it has wide-ranging policy implications for, in this instance, diversity and inclusion throughout the state. I think that's how we frame it, and then go from there. I don't think it's worthwhile to revisit the issue of whether the State Bar should be involved in the work because clearly we are, and we've been empowered to do so.
If I could offer just sort of an additional thought for the framing, sort of beyond the distinction between the trade association and the regulatory body, it's my thought and belief that we will be far more impactful than we've been in the past if we adopt measures that are quantifiable, and against which we can assess our progress and be held accountable. I think that's one of the fair criticisms of our efforts over the last 20 years, and I don't think we should make that mistake going forward. So where we have choices to make, and this is kind of a long list of objectives, and I can tell you clearly we don't have the capacity to do all of them. So where we have choices to make, I would love to see, the board err on the side of choosing the types of objectives that we can measure and assess our progress against.
I would also just add, I totally agree with what Leah just said, and Jason as well. I think also going forward, as we consider these measures, we really consider the measures for which the State Bar is uniquely positioned to make an impact. There are so many organizations focused on diversity and inclusion, and rather than doing overlapping activities, we really focus on things where we are uniquely positioned and can really make a difference.
I'm going to go with the low-hanging fruit, which so there appeared to be wide consensus yesterday about the State Bar being a collector and aggregator of data, the analysis of that data, and the distribution of that data to stakeholders, either it being statewide or regional. I think that is, to Highland's point, playing to our strengths. I think it's something that we, under Leah's leadership, something that we're good at, and something that I think we'll continue to be good at. So I'll propose that as something that the State Bar should be involved with in this area.
I think what we'll see is, data touches on a lot of these objectives that are up on the screen. So when we get maybe when we get to the work plan review, we can figure out how to phrase that. Does anybody disagree with what Jason just said as far as the bar being in that unique position? Okay. See, wide spread, head nodding. Joanna? Okay. Including, for the record, including Joanna. Okay. All right. So let's, so kind of with those initial comments, let's start marching through the objectives. If we go back up to the top.
You have to take notes. Do you want me to run that? Sure. Okay, I'll run it because he has to take notes.
Okay. All right, so going up to the pipeline programs that we heard about, did anybody have any thoughts on those presentations and ways that the State Bar can come up with measurable objectives to assist in that?
Well, so one decision point that I think became apparent yesterday in listening to the presentation on the Pathways program, which again is funded by the Department of Education, not by the State Bar, but there appears to be a wish that the State Bar be engaged in gathering that data. To me, it seems more appropriate for the agency that is funding that work to gather that data. I think that there's a role for the State Bar to play in assisting in gathering that data, standardizing the types of information that we want to look at. And so I think that is an objective we'll have to discuss, whether the State Bar should take the lead on gathering that data or whether we should partner with the Department of Education to do that.
So yes, Josh.
I think I want to make a broader comment about pipeline and pathways, which is we spend a lot of time on, as a regulatory body, looking at discipline. And I don't know that we spend as much time as we could on the licensing portion, which is pretty clear in our mission. And so I think some of these, whether it's law school retention and pathways programs, some of the other programs we talked about, are ways for us to get more involved at the licensing level. And so not necessarily I'm speaking to pathways, but I just want people to keep that in mind and think about it as we work through.
Did I see a hand over here?
I think the value add the State Bar could bring to a partnership with the Department of Education is just knowing the field and helping them parse out the data. I don't have we reached out to the Department of Education or because there seemed to be this I guess the beginnings of an effort to collect information by the Pathways program by California law, but there didn't seem to be, I think they were looking at Donna when they were speaking about the actual effort and what is coming in. So what do we know? What is happening in that area and what we should be expecting?
Yeah, I wonder if the Department of Education is doing any sort of data collection at all, because I know that they know how to do that. So what are they doing?
So just a quick clarification. So the Department of Education's role would be in the partnership academies. They're funding that piece of it, the high school part of it, not the community college part of it. As I understand it, the answer is really at this point no. That California law is not getting any information from the California Department of Education. They partner with them in the program, so they certainly communicate. But the data, they're not getting the data from the department at all.
I think Donna's making an important clarification, because if we were going to embark on this path, I think it would involve more than the CDE, but the community colleges as well as the affiliated law schools. And my reaction is personally that I think this is important work, but if the board decided to take this on, even with us in an assist role, it would be quite significant, a significant amount of work. These are not small institutions to work with, and getting student data is not easy. So to just keep that in mind as we go through the list, there's also an option that we recognize that this is important, but it's not something that will make itself onto our strategic plan this time around. That's also an option.
Yeah, I think what I heard from the presenters yesterday is that they might be able to act as kind of that first point of contact in getting that data and then transmitting it to us. So if that were the case, would that alleviate some of staff's concerns about the use of our limited resources if essentially the programs that we're partnering with, they're doing a lot of that front end work? Or is it still the same concern?
So let me just point out as Leslie Cunningham noted, California law has explored some system options that would allow them to capture the data, not to capture the data, but to organize the data from the community colleges and the universities. So not the California Partnership Academies. They certainly would not object to the bar just funding them being able to get those platforms, so they would do that. So that is certainly, in theory, work that they could do, but it goes to, I think, the discussion, the way Jason raised it at the meeting yesterday, talking about the bar as the incubator of the program and sort of seeing it operate itself, and whether it makes sense for the bar to be funding the platform so they can collect the data. If they have the data, certainly I think we have a lot of in-house expertise to be able to manipulate the data and figure out sort of what everything means. But you would all need to determine if that's an appropriate use of bar resources.
Is this the program she talked about, Cronus or something, and it was like 14,000, they could have 400?
No, that was the mentoring program.
Oh, that's the mentoring program, okay.
Jason?
Well, if we as a board like the idea of an incubation concept, then I think it is incumbent on California law to come up with a proposal. If they do want funding, what that would look like, if they have an idea of the data collection, because if we were to abide by that model, once you started here and then found your home outside of us, then you really are an independent entity, and that you should come to us as a resource with the ideas of how to expand the work. But I mean, Leah does raise an important issue, which is the resources and the undertaking required to continue a relationship with an entity that has found its own path.
Perhaps this could be considered for the work plan with a direction to staff to ask California law essentially to put together a proposal. And in that proposal, they could outline the steps that they've taken so far to get information from really the three systems that they're working with, and then what exactly they'd be seeking from the bar. We could consider it.
Seeing lots of nodding and approval. Anybody have any objection to that? Anything to add? All right. Can we move on to B, law school retention? So as you can see on the screen, require CALs and registered schools to report demographic data, identify programs in place in law schools, and then use data to help identify successful interventions to improve retention rates. And then, so are there any comments on those kind of three broad topics? And I see, yes, I'll recognize Dean Brandy's here. Absolutely. Actually, here, wait till you get to the microphone there.
My name is Greg Brandis. I'm Dean of St. Francis Law School. My apologies for interrupting the meeting. I was not aware the committee would be discussing this particular topic today. I think the bars and the school's interests are very closely aligned with respect to retention. Obviously, we provide the opportunity for a lot of diverse kinds of folks to try to obtain a law degree, recognizing that some percentage of them are not going to be able to cut the mustard. Various structures in place cause us to not be able to allow them to graduate with degrees. And then, of course, they have relatively complex personal lives, at least in the populations that we serve, the adult populations for the most part. While we're all, I think, on board with the goals of retention, I think you'd find a couple of challenges with this particular item. One is that State Bar already has almost all the demographic data that we're able to give because we report the demographic composition of our classes to you. And we describe that data in our annual reports. Every time we admit a new class, we have to provide data about demographics. So there probably isn't very much more that can be provided, at least within our constraints with FERPA and the rest of it. We certainly share the same goals and would be happy to, I certainly would speak on behalf of myself that I'd be happy to work on it. But there are a couple of barriers there. And one of the most important to remember is these are opportunity schools. And that means that some people have a chance to start who we know are probably not going to finish. We don't know who. We just know that some percentage of them are not going to finish, and for good reasons that go to competence and the appropriate awarding of degrees to people with that skill. So when we think about what retention numbers ought to look like, it's important to keep in mind the historic mission and purposes of the alternatives to the ABA model. These are less expensive schools where people can kind of try things out. To a certain extent, that's part of our mission. That's part of what we do. So thank you very much.
Any other public comments on this? Okay. Right, seeing none. Okay, Joanna?
The one concern I have about this kind of dovetails from what he was just saying is that we don't have any control over the ABA schools. And the issue is clearly not just the unique population that go to the CALs, but the ABA students as well. And I'm worried about the quality of the data when we're only looking at the CALs as opposed to the ABA schools as well. I understand that we're in a unique position to collect data from the CALs. I'm not sure how much it helps us in this endeavor or not. And I'm wondering if there are better ways for us to determine how we can address the law school retention issue. This is my concern.
I don't see Carolina here, but just to clarify, the data that much of the data that was presented yesterday that she presented is ABA data. So we actually have more data available from ABA schools than we do non. And about half now, I believe, of our California law students are in non-ABA schools. So this is a very significant population for us in the state. And in terms of our ability to regulate, we don't regulate ABA schools, but I do think that there's this is a real opportunity for partnership with the law schools, because we have a very common and shared interest in addressing these pretty shocking, disparate dropout rates. And I think we can work from a place of our shared interest. So not as much from our ability to regulate ABA law schools, which we don't have any, but we do have that common interest. So, and the way this is worded, thanks to Donna, I think it really does clearly suggest kind of a partnership with the schools to determine what other data could be collected. So I just wanted to add those thoughts.
So as far as the data that is being collected, what can we collect now, and what additional data could we?
And pause that and get Carolina to come in, because I think we just don't have the same kind of data on dropout rates, on graduation versus enrollment.
As I recall, right, that's the issue. We have the enrollment data, but we don't have the graduation data. And when we were looking at the charts yesterday, that was where we saw, so how did Carolina, it was the disparity gap, that's what Carolina named it, the disparity gap growing was between law school matriculation and graduation, sort of across the whole spectrum of the pipeline. That's where it seemed to be increasing. And so having the graduation data that would be helpful in identifying the extent of the problem.
So is that something that would maybe more appropriately be handled with the CALs and the registered law schools and their working groups, I guess, whatever it looks like, based upon decisions this board's going to make a little bit later on today, but would it be better handled in those committees, those working groups?
So that may certainly be a place where we would absolutely engage these discussions, because that's, and we'll be talking more a little bit later today about what those groups would look like. But yeah, that would absolutely be a place to engage these discussions, whether it's through an ad hoc working group or through the CS bars that we are proposing to create. That, however, doesn't mean that it's not part of our strategic plan objectives. Who works on them should not be guiding that placement of the objective.
I'm less concerned about the what. We know there's a disparate impact, and there's a lot, people are not staying in law school like we would hope. I'm more interested in learning the why that's happening. And none of that data has come out. That's the data I think we need to be chasing, and I think we need to be chasing it from the ABAs as well as the CALs. And it would require follow-up with law students who have left, and we're going to need their cooperation. So I would prefer the data focus be on the why, and that maybe a working group with ABA and CALs to try and figure out a way to get that information would be appropriate. But I want to make sure the ABA is included, because we do have a different demographic and perhaps different reasons, and I think we need to study the entirety of the problem and find out why it's happening.
So I think we don't yet know the what, though. I think that was the point that Carolina and Donna were trying to make, is that the data that you saw yesterday with the disparity gap, those are the ABA schools' data. And we don't have similar data with respect to the Cal accredited schools. For me, it makes total sense to gather that what data to see where the disparities are. I think we can assume there's a disparity, but we don't have the data to back it up. And I think that having the data will help us in the future as we decide how to allocate our resources, especially when resources are tight. It can help demonstrate where the priorities are. and then we can get at the why. I feel like we need to get the what first. I agree, we need to look at ABA schools, but because they are not directly subject to the same sort of regulation, and because the data set for them is quite robust and there are associations that gather that data already, I would prefer to focus our efforts right now on first gathering this Cal-accredited school data.
And I would suggest that the why is encompassed in the use data to help identify successful interventions to improve retention rates. And because we're not going to know sort of what successful interventions need to could be employed without having a sense not just of what the data tells us, but the why behind it. Just add the B, identifying the programs in place. So with those 3 pieces of information, you can begin to evaluate and determine what strategies are effective and which aren't. Carolina just joined us. If you want to come up and just quickly share the differences in the data that we have available between the ABA schools and the non.
So we have demographic information. The ABA schools are able to break down law school applicants. Applicants, enrollment, and then graduation rates, all disaggregated by race, ethnicity, and gender. And I don't think we have that for the non-ABA schools.
But we don't have data on for ABAs with respect to why people drop out, correct?
In terms of reasons why the graduation rate is lower than the law school,
correct?
Enrollment, no. They I don't think they've done that level of analysis to explain the reasons or the factors that lead to the low dropout rate. Articles that talk about the challenges that populations of color have in graduating from law schools. It would be added value to the research to investigate those factors a bit closer and really, I think, raise awareness for some of the law schools that are also realizing that this is a problem too.
So because this issue affects the amount of attorneys that are able to take the bar exam and then go into the practice of law, I mean, is this something that we could ask the California Commission on Access to Justice to study? Is this something that we want to study ourselves internally here on the programs committee, or something that we might want to entrust to an outside, or not an outside, but a different entity to then report to us on their findings?
I really think this is ripe for a specialized working group that has the law schools working with us to try and determine the scope of the problem, what's causing it, and how it can be addressed. We're in a position to bring them together, I think, better than the Access Commission would be. And it wouldn't be a direct board responsibility. It would be reporting back to the board with recommendations.
So I apologize if I've already said this before, but I still think that we need to focus our limited resources on just the data gathering stage. The why is a real huge piece to bite off. There are studies out there that are not necessarily law school specific, but have focused on, for example, Harvard Business School and disparities in outcomes. Student performance has been studied also at Yale Law School, for example, and people look at things like how implicit bias plays out in the classrooms, things like stereotype threat and how that plays out and holds minorities and women back. how the environment of law school and business school make it difficult for women and minorities to speak up in class and how that impacts their access to opportunities. So this has been studied, not in as perhaps a systematic way as we would like, but I think it is a huge, huge ask to focus on that right now. And I think we should focus our energies first on the data.
And we can think about this as we're making amendments to the 5-year strategic plan, which concludes now in 2022 in 3 years. So we could think about adopting an objective for at least the first year that would center around data collection and analysis. And then when that's completed, we could take a look at adoption of an additional objective that might be more evaluation focused. So we can think of this sort of in terms of staging as well. And I think the productive mindset intervention results will be applicable here. Although they are focused on one high stakes exam, the bar exam, they really do get at the stereotype threat issue that Highland mentioned, which I think permeates, is sort of underlying the dropout rates as well.
Anybody else have any thoughts in this area? So I'm hearing broad consensus that we'll add this to the collect and aggregate data aspect of our work plan. Any objection? Okay. All right, let's move on to address bar passage. And I think we kind of covered that a little bit. Anybody else want to add any thoughts on this issue? Jason?
Leah, when is the productive mindset data going to be? I always forget.
I've been emailing the researchers asking. They promised me the executive summary by the end of this month. I had hoped to receive it prior to the board meeting, but they always said the end of January, and they meant the end of January.
I mean, I'd say that there is a lot of attention that's being paid on bar passage. So I think it's important for us to think critically about what we can do in the space. I mean, aside from the cut score, which the Supreme Court has made clear they control what that rate is, I mean, it's the next step to see the productive mindset intervention data and then take the next step as to, I mean, I'm hopeful that that seems a very straightforward program is going to be impactful. And maybe that is what we do in that field now, and then reconvene to see what the next steps are. I mean, I don't know what else is on the menu for this area, because I think the Supreme Court really has owned the substance of the bar passage rate cut score discussion.
Well, I think certainly the bar is in a position to continue to study this and continue to discuss the outcomes of these studies. So I can certainly be made a part of our working plan.
It already is, in the sense that we have, what is the last one, the last of 5 being due.
It's the first in a new cycle, the practice analysis.
Okay.
If that's what you're referring to.
Yes.
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 Yeah. The first in a new cycle of studies.
Okay. So it's ongoing work that we're doing. So I think we're just going to get a lot more information. I mean, we already have a lot more than we had before. And then we add the productive mindset. I'm not sure what else we should be doing, because I feel like we're doing a lot.
Anybody think we should do more? Okay, I don't see anybody. Okay, I'm sorry.
I think the way that's worded up there is that if we get a positive result from the study, that we expand it, and if we don't, then we revisit it. What do you think? Okay.
Yes, Josh.
Yeah, I mean, I think that we do need to look into what else we can do. I understand there's a lot being done. I think this is one of the most vexing and important issues that we need to take on. My comment earlier about licensing, licensing admissions, I think it's an area where not only do we need to look at why the bar passage rate continues to be at the level it is, and I know we have we are, but I think we continue to think of other ways that we can improve that, but also diversity and inclusion. I mean, some of the conversations from yesterday, I mean, this is a tool and something that I think we need to really focus on. And so to the extent that there are additional thought processes around it or working groups, I think it's more than just a productive mindset intervention. And I know we have the jobs analysis going also.
All right, anything else on this? Okay, can we move on to the retention and career advancement objectives?
Before we move off of that, one issue that a lot of the literature supports, and that my experience at my own law firm supports, is that diversity and inclusion is not really a priority until it's brought outside of a silo of just, okay, now we're talking about diversity and inclusion. But that real changes happen when you make it a part of the fabric of everything else that the organization is doing. And so one question I have is whether there's some objective or goal we can or can and should adopt that goes to things like when you're constructing the bar exam, when the bar examiners committee is looking at what topics get covered and how they get tested, how do we weave diversity and inclusion into that? I don't know how to word it, but I just wanted to throw that idea out for people's consideration.
It's really timely because we just had a staff a meeting about that, I think 2 to 3 days ago. There's a couple things. So the impetus for the meeting was a meeting that I attended in DC, the National Conference of Bar Examiners, was talking about some pushback they had from certain states. These are states using the uniform bar exam, the UBE states, on having same-sex couples in bar exam essay questions and PT questions. And, you know, coming from California, this was just really very surprising for me. But they were describing some pushback that they've had. But it made me think about our essay questions and our performance tests. And I made a very pointed remark, and I said, that's really interesting. You know, I wonder if we have a laquita, you know, in a bar exam question, a very typically African-American name. You know, I can't really imagine that we do. And so I called this meeting, we had a conversation about it, and I was really pleased to hear about the work that our admission staff has been doing to ensure that there are really diverse and a wide array of names in our questions. And same-sex couples and all of that. But it's really been the work of one woman and her staff. It's not institutionalized as part of the way that we do business. And so this is certainly work that we can undertake. In addition, staff brought to me, admission staff, that they would like to do some additional analyses of our questions, looking at whether there's disparate racial impact based on the subject matter of the question and the particular skills assessed. And so that was really, you know, I hadn't thought of that. So I just want to affirm what you're saying. And certainly we could work up a couple of objectives that relate to this body of work that we, again, just started to talk about this week.
All right, so going on to retention and career advancement. Continued development and implementation of program to collect demographic data about licensed attorneys through all stages of their career, and analyze available data to identify the particular obstacles to diverse attorneys' entry into and retention and advancement in the legal profession. And you know, one of the things we talked about yesterday was the survey that lawyers are now taking when they log into their My State Bar profile. I think that's going to yield a lot of data. Do we have kind of a a date where that data is going to be compiled and then presented to the board? Have we decided what we're going to do with that?
No, I don't think we haven't yet. We can certainly set one as staff. We just launched it 2 days ago, so we don't have that yet. Okay.
Is that something that that this committee would like to monitor, and then again act as kind of an aggregator of that data and decide what we do with it? Should that make it sway into our strategic plan? Jason.
Absolutely.
Thank you for that response. Any discussion as to this?
So is there an amendment proposed to the language that's written here, or? No? Okay. Do you want to?
Do you want to talk about that?
Yeah, we can.
Okay.
Yeah.
So Jason, did you want to talk about the mentorship?
Yeah, I mean, I think this is, to the model of this incubation idea, this seems perfect for that, in that there's COAF developed a program, has worked out all the details of how it should be implemented, found a vendor, the costs, and to sort of Joanna's point about should a regulatory body, I think you used the term, Joanna, like attorneys helping attorneys. That seems like a perfect vehicle for an entity like CLA to take on. Seems like right in their wheelhouse, and it's something that we have packaged very nicely and put in a lot of work. So I would say for that program to present it to them and work with them to implement it, or another interested trade association like body.
I would agree. We have done a lot of work, and the work started before we changed the organization. So we started doing, I was also on that task force, the mentoring task force. There were other issues associated with why the mentoring program was a challenge. There's no really big reason to get into that. It is well suited for CLA. Hopefully they will take it on. So I think that would be transitioning it to a statewide organization, because it's going to have to be somebody who can coordinate and work with all the affiliated bar associations to take advantage of it, I think is a good idea.
Joanna, do you want to take that on as far as reaching out to CLA? Sean? Okay. Yeah, Sean.
I'm sorry, can we go back to the last item, the retention? Just have that on the screen for a second. So I totally support this. I just wonder if it's a little, do we need to be more specific about who's doing what? Is this a staff project? Is this something we should consider a working group, forming a working group in this area? And maybe mindful of different types of practice areas. So I just throw that out, what the concrete action items are going to be for this.
I think for the first year, my recommendation is that you allow us to collect the data, analyze the data, and bring it back to the committee. I do believe that ultimately there will be implementation activities that would necessitate our reaching beyond the committee and staff and bringing in the community of lawyers and employers. But I think for an initial step, this is appropriate, and perhaps we could put some dates around this, that this is our 2019 activity, for example.
Okay, thank you.
So Leah, do you think that you would want to collect the data for this entire year, or collect it up into a certain point, maybe September, October, and then have a report at the end of the year?
Yeah, so the bulk of the data, I mean, we're going to get a lot of the data in the next few weeks for the career advancement piece of this. Retention, we haven't yet really begun the really interesting data analysis that we'll do when we launch the survey as part of the process that you have to go through to voluntarily transition to inactive status. So
And because that doesn't happen as frequently, I think we'll need a longer period of time to collect the data. So I would say my initial reaction is to give us 2019 to do something robust. We could check back in with the committee, maybe in not at its March meeting, but in May, to share with you what the data looks like so far. Do a progress check-in and see if it could be accelerated. And I would also note that because we launched it at the end of the billing cycle, we missed those who pay up front. And so if you give us December next year, then we may be capturing a whole lot of people that did not log on to my State Bar profile yet and may not log on for the rest of the year, because some people don't do it that often.
Brandon, I have a question. Leah just mentioned employer-based data and getting information from that that piece of the legal community. I'm not understanding what the vehicle for that is or could be.
I think I misspoke. I was talking about employers as being a potential group that we would share information with or communicate with or ask to engage in a working group with after we had done the data collection analysis. So the data is really only coming from attorneys at this point.
If I could, then just adding on to that, I think it is important for us to have a conversation about, is there a way to engage employers in these conversations? Because retention and career advancement is so often critically run by, and Hylin talked about this yesterday, and I'm a little biased because I've only been in firms my entire career, but I'm sure there are differences at the governmental level and in-house. But those issues are important to a young lawyer or even a mid-level lawyer's path and retention and happiness in the profession. So I just don't know how we get to that.
And I don't know if this is something where we put together a working group that approaches a conglomeration of larger firms to see if they are interested in expending resources to study that, because they would really be the ultimate recipients. And then the State Bar kind of acts as that collector with funding coming from outside sources. So I don't know if anybody has any. Is that a good idea, a bad idea?
My sense is that with respect to big firms, NALP already serves that role pretty effectively. The MCCA, the Minority Corporate Counsel Association, there are a lot of groups focused on private law firm data. I think that the State Bar's efforts to collect data, to the extent it starts to capture what sector people are working in, right? Do you work for the government? Do you work for a private firm? Are you in-house? That can help to generate the type of data that will fill in the blanks.
I think that's a great idea. Having, I guess, been fortunate to serve both in the federal government, at a private firm, and now in-house, there are unique challenges to all settings. So it's worthwhile to collect the data and then begin sort of the conversation of addressing those challenges.
Okay. Anything else on the topic that Sean just brought up? Okay, going down to, can we go down to statewide leadership? Anybody else want to talk more about retention and career advancement? Okay, so statewide leadership. So modify elimination of bias and CLE requirements and create subtopics, create State Bar mandated course. Let's kind of take that in a little bite-sized chunk. Anybody have any thoughts on that? Joanna?
I like it.
And then in the words of the Committee of Bar Examiners, discuss.
I would propose analyze something like along the lines of analyze or consider whether to modify requirements or whether to create subtopics rather than deciding to do it right off the bat, because I would like to see sort of where it is now and then figure out whether we should modify.
So one of the things the State Bar did was the 10-hour MCLE requirement. And we had a fairly significant working group that required a lot of staff resources on, in regards to that. So that was one of the issues that we did discuss, and we did weave elimination of bias into that mandatory 10 hours for new lawyers. So I don't know how much more of a recreating the wheel we would have to engage in looking at this. And Randy DeFantorum did a lot of the work on that. So I don't know if maybe we can have a report.
Well, there's a lot we could consider doing, because that's that new attorney training is really focused on implicit bias, which is really important. But if we wanted to expand this and consider the B under the A, so not so well structured there, but to consider the B part of this in terms of mandating it as a state bar developed course that you must take, that would be different. We could do things like how this impacts decisions around hiring and promotion. You know, you could develop very targeted subtopics of this topic. So I think we have a nice platform from the new attorney training module that we could build on, but there's quite a bit we could do here if we decided to embark on this path.
And certainly one of the things we discussed in the 10-hour MCLE is young lawyers oftentimes don't know what they don't know. And that was a big thing with the new MCLE, was saying, okay, this is what you don't know. And perhaps with elimination of bias, access to justice issues, maybe our MCLEs could be structured around showing attorneys what they don't know and starting the discussion from there.
Well, okay, so I will change actually what I just said and agree with Joanna that we should create a subtopic of MCLE that does require implicit bias training. I think it's awesome that we do it for new attorneys, but the new attorneys typically aren't the ones that are doing the hiring and promotion decisions. And so senior attorneys, much like new attorneys, also don't know what they don't know. And so I think there would be a lot of value to requiring senior attorneys to take that training as well.
So is this something that we can add to the strategic plan?
So I just want to make sure that we are explicit when we're talking about modifying the MCLE requirement in this way. What I hear us saying, and I want to make sure we're sort of all on the same page on that, is that we would expand the number of hours requirement for EOB training, which is currently 1 hour. If we are sort of modifying it, creating subtopics requiring implicit bias on top of or as one in addition to one other hour of the competence MCLE requirements that we currently have. I just want to sort of make sure that I'm understanding what you're saying and that we're all understanding what
I don't think it necessarily has to be more hours, but I think we're gonna, obviously it can go into the strategic plan, and then there'll be check-ins with the committee, right, as we come up with different proposals, because it could be structured so depending on what you do and what your role is, you take certain modules. Not everybody doesn't have to take the same thing. So and I think we'll have to bring back to the committee for sure the concept of whether or not this is going to be state bar mandated and promulgated, because there are, of course, for-profit businesses that provide these trainings as well.
Joanna says she doesn't care. Okay. Any other comments on sub A? Okay. Sub B, collect and analyze data, create meta-analyses. I don't know what that means.
Maybe we don't need it. I mean, we've talked about collecting data under retention and career advancement and.
Okay, let's move on to C then, annual report card on the state of the profession.
So what does that look like? I guess, what is that? Did we talk about that yesterday? No. Did someone sneak that in? No.
I think it's a great idea. It's Donna's idea. So you actually said it before I did, but you don't remember that. So
okay.
Yeah, no, I mean that isn't a
no
criticism. I just want to know. Did I miss it? And
this is going to be a dashboard.
So yes, this is not a qualitative report card. It is looking at the data that we are collecting on the demographics of the profession, and looking at that annually and seeing if it is improving toward what we will, after we complete this list, sort of go through and moving us toward what we adopt as our diversity goal, seeing how we're doing toward achieving greater diversity in all of the categories of diversity that we also identify are the ones that we're interested in studying.
And if I could add, there are some really good templates and models out there on annual report cards. I believe MCC, NALP, and other organizations have collected data to put these report cards available for other states. I'm sorry, for different sectors. So there's really great information there that we could use to develop a report card.
I think it's a great idea. I mean, it sort of puts us in an annual process of showing the data we've collected, and as we further the analysis, it shows the public what the State Bar is doing. To me, it's kind of a no-brainer. So thank you for sticking it in there.
Yeah, and it will also point for future year objectives, right? Looking at this, we will start seeing, oh, there is an increasing disparity gap here. We are improving here, and we are not improving in this way, in this sector, in a variety of areas, moving from associate ranks to partner ranks, sort of everything the data that we're capturing can tell us, and that will help us create future objectives to address specific issues.
Donna, do you want us to engage in any sort of policy discussion to kind of direct that at this point, or is this kind of this ongoing discussion you want to have?
So I think we can. I think we have the data. We have the fields of data that we're collecting now, and so I think as we. Maybe when we report back to you, I think Leo was talking about doing a report back to you in May on the results of the survey that we have. We can start talking about if there are any sets of the data that we're collecting that we wouldn't want included on this annual report card. I think in large part we're collecting the data because we think it's valuable data, and it is something that we should be looking at and reporting publicly. So I would imagine much of what we're collecting as part of this survey we would want to include in that card, but we can go through that in May.
Okay. Yes, Joanna.
I don't know if it's, I can't find it anymore on the website, but you used to be able to go on and see demographic data for the attorneys in the state with respect to age, geographic region, and so forth. So it wasn't just, the diversity issue. It went beyond that, and I think that is helpful because it would demonstrate, are we losing attorneys in the rural areas? Are we aging a lot? How is that going to affect us? So I think if it's not that hard, if we already have the data, if we can put it somewhere and show the trend, that would be really helpful.
Sounds good. All right, sub D, Leadership Summit, and don't let that throw our discussion off. But does anybody find any value in having a leadership summit or participating in one maybe that's headed by a trade association? To one of I forget which judge made this point, but it does really help for younger individuals or people who are looking to be involved in leadership. It does help to have them hear from leaders at the State Bar, leaders who have maybe taken different routes to get to where they're at and what's worked and what has not. So this is something that we find to be valuable as regulators in ensuring some sort of buy-in with the people that we license. Are we going to see a little bit more buy-in if we open up these leadership opportunities to them? So,
I think it's such a very good idea. And I will be very much supportive of that, and I would love to participate, especially for these young kids and giving them sharing life skills and developing leadership. And I think seeing that the board would be there, that provides more visibility to them, knowing that we are there too. And it's something that I think would be a very, very good effort for the board to participate in.
So I'm going to be a little bit of a contrarian on this one. I love the idea, having been part of the ABA's organization of professional success summits for diverse attorneys, various summits and conferences centered around diversity and inclusion. I have to say, it is a huge, huge drain on resources to organize these events. And at the same time, it's really hard to get people to attend them. It's just really hard. Everyone goes into it with the best of intentions. Often the programming is excellent. You have excellent speakers, but the drain on staff resources and the expense is significant. And the sort of return on investment, unclear. The ABA has tried mightily to really get traction with their professional success summit for minority litigators, and it has been really hard. So, word of caution. Right now where I am is I don't know that that's the best use of our resources.
I guess I remember back to when, during the days of the integrated bar, where the bar put on training for bar leaders, so local bar associations, and generally the state bar president would come and address those leaders, and there would be trustees in attendance. So this might be something as simple as the bar committing to maybe send a representative if, let's say, CLA or some other trade association had those sort of leadership summits already in place, that we would make ourselves available to share our expertise and our paths. Ruben.
I agree, and I think that it's important to remember that not only are we regulators, but we're policymakers, and in that role, we need to be informed. Whether it's CLA or NALP or the ABA, as Hylin says, there's plenty of stuff out there. We need to make the individual commitment to be a part of it, and it can't just be Jason. It should be Jason, but it really should be more of us, and ideally all of us at some point. There's many opportunities.
Leo, let me ask you this, or maybe staff. Is there kind of a staff person who receives any sort of requests for speakers or for input at different conferences? I don't even know if we get those sort of requests, but
We do. I think a lot of them come through my office. And we have a great relationship with CLA for sure, so certainly, and I think CLA has been quite clear about its desire and intention to do work in the diversity and inclusion space. And I think they will welcome our suggestions as to both mentoring and, a leadership summit. And I agree with you that, Jason, the chair, can attend, or other members of the board, but have us not be in the fore of putting that on.
So maybe as a way of going forward, sorry, Jason.
So as a first generation lawyer and never knowing a lawyer when I was growing up and getting into college, I think really the first time I ever met a lawyer was at around the time I decided to apply to law school. The idea of meeting other lawyers, other leaders in the profession was powerful to me. And in the course of my career, meeting other leaders, other diverse leaders, really shaped my path. So the concept of a leadership summit, I really like. But I also heed Hylin's caution about the resource. So I think there's a couple things that we should consider. First, I think California is a unique environment, and there are a lot of very strong ethnic, minority, and affinity bars that I think that can help us. That are very interested in this work. COAF already has a sort of a work stream in place relating to a leadership summit, so I think we should likely merge that with their thinking as well. I think CLA is the appropriate place for this, but given where CLA is at, and I think my comments yesterday about the credibility that the State Bar can lend to that effort, it's incredibly important at this stage that we partner with them and take a leadership role in the leadership summit. I think it's a worthwhile endeavor. It may be even if I was, I guess my favorite concept from these set of meetings is if this is something that we can incubate and push forward and eventually land somewhere else, I think that would be a great outcome.
I consider this the lawyers, helping lawyers area. Trying to get new leaders into bar associations was the whole point of the leadership summit. And I do think CLA is well positioned to do it. I think they're already coordinating with all of the affinity bars throughout the state. They've taken over the state bar used to do a bar leaders conference at the annual meeting every year. It would bring them all together. They've taken that on. So they're already in communication. I think we should, instead of doing it with them, I think we just need to ask them to please consider doing it going forward because of the value that it brings and the diversity that it would serve. But I don't think it's our role to be doing it, and I am concerned about resources as well. We have to pick and choose carefully what we're doing.
So I don't know if this, yes, Sean. Got you cut off.
All right, that's better. So I'm just listening to this discussion, and I mean, I understand Joanna's concerns. I guess I'm having trouble understanding, looking at this list of items, why A, B, and C, for example, would be within our purview, but D isn't. I mean, you could characterize all of this diversity and retention initiatives as helping lawyers, and so, but I think it's within our mission statement, and it's something that court and the legislature want us to pursue. So I think the resource issue is a very important one. If we can team up with CLA, that would reduce the resource issue significantly. Maybe that's a kind of a good compromise approach around this.
And I think maybe going forward, what we do is we have staff reach out to each individual board member and get an idea of how each individual board member would like to volunteer their time to reach out to these affinity programs, to leadership summits, and ways that we as individuals could assist in that endeavor. So that way, staff, when they receive a request, if Jason can't or would like to farm it out to somebody, then we can kind of come up with a strategy to get the best person.
I really like Jason's idea of bringing together all the various bar affinity groups. I agree that we are unique as a state in that we have so many very active bar affinity groups. And I think if we are to do it, to make it successful, we will have to get buy-in from all of those groups, from all these organizations. If we make it a really big deal, then I'd be into it. But I've just seen so many diversity events, so much energy goes into it for not a lot of return. But if we do leverage the power of those affinity bar groups, it could be something really great. And as a state bar, we are positioned to bring them together.
And I just have to caution that this is a tremendous resource investment, both staff time and money for a facility at which you're going to be able to host all these folks. And it's one which, when I think of my criteria, it doesn't meet sort of measurable outcomes. I think it feels good, but I'm not sure it's the best use of our limited resources. So, that's my 2 cents. Certainly, encouraging CLA to put one on, and they do, as Joanna mentioned, they've established a great infrastructure with the local and affinity bars. I was just on the call that they now hold, that we used to hold, the monthly call with the local and affinity bars. They've taken that over. So I think we could ask them to do it, and we could participate, or we can take it on. But I do want to be clear about the resource concern.
Let me propose an action item, which is that we have have a working group of 2 members of the program committee to work with staff to discuss this with CLA and come back with more concrete proposals. So again, Leah's comment about resources is really important, but I think we ought to be more concrete. The committee should consider a more concrete proposal, which is what the cost would be, what CLA is willing to contribute, or whether they're willing to do it on their own completely, and so on. But I think we should vet this a little bit more before the committee makes a final decision, because it's an important decision.
Sure.
Are there any volunteers? Alan did what you'd never do in the
No, I was going
auctions.
to echo Sean's thoughts, and mine was that we asked staff to consider our appropriate role in this leadership summit. Given the fact that we all have expressed the opinion that we are in a position that we would like to be involved, but there are a range of levels of participation. And given the resource consideration, I think we ought to have some kind of idea of how we could stair step and where we would fit in that, from merely suggesting the idea and getting some leaders together to, and then offloading it to somebody, or at the other end, putting it on ourselves. But there's a range.
So does anybody want to volunteer to take that on? Joanna? Okay. Anybody want to join Joanna? No?
I'll join Joanna. How's that? And we'll have a range of viewpoints reflected. Well, my viewpoint is wishy-washy, so but I'm open-minded on the whole thing. So anyway, I'm happy to work with Joanna.
All right.
What could be better?
And I apologize, I need to step out. I'm so sorry to miss the end of this discussion, which, as you can tell, I'm very passionate about, but I'm slated to speak at a symposium at UCLA Law School, so I got to get on the road.
We'll make sure we volunteer you for a bunch of assignments.
Thank
All
you.
right. Thank you for all your work, Hyland. All right, great. So we have Sean and Joanna taking that on, and so we'll add that to the work plan. Okay, perfect. All right, any other comments about this before we move on to judicial diversity? Okay, seeing none, we have as a suggestion, partner with judicial counsel to complete toolkit. Did anybody have any general thoughts before we get into that as to the state bar's involvement with judicial diversity and kind of what that looks like to you? Jason.
I just want to offer a sort of practical perspective, which perhaps could limit the time we spend on this. Lee has already laid the groundwork for a partnership with the Judicial Council to take on judicial diversity, and sort of it's meshing the longstanding work that COAF and the State Bar has done in this area with a dormant effort by the Judicial Council now come alive. So my expectation is that this partnership will take hold, and the court is committed to this work and is also committed to the Judicial Council essentially taking it on at some time. So my practical perspective is we have a body of work by the State Bar, by COAF, that should not be lost. That should be transferred at some definite point to the Judicial Council. The State Bar will always be present because, lawyers ultimately become judges, but this is an area that the Judicial Council is interested in taking on, and I think we should let them take the lead.
All right, anybody want to add anything to that? Okay, so
say 1 year and check in on how the partnership is going with the eventual transfer.
So are
Is
you
that-
saying don't include anything in the strategic plan, just perhaps on the work plan, have a check-in? Because right now, the only proposal is to partner with the Judicial Council to complete the toolkit, and that is something that would be done. I think the plan is to have that done this year. Are you recommending to just strike that and we just have a check-in every programs committee meeting on the toolkit progress? That is the transfer, is the toolkit, and then the implementation, which would be some kind of regularly scheduled trainings, regional summits in coordination with the local bars in those areas, the courts, and then the governor's appointments office, secretary. That's what we've been discussing with the council.
Right. I mean, I don't know how that ultimately would reflect on our work plan, but it's the idea that the Judicial Council will take the lead in this effort. I was saying the fact that the State Bar will in some way touch on it, but that we would not be expected to lead the charge. So however that is reflected, I mean, I know that the partnership is in existence and the toolkit is something to be done. So my expectation is that it will be done and that we have State Bar people on that working group. But to the next step, as you described, I think as Judge Brazil described, sort of the expansion of the Judicial Council's efforts in this area to continue that partnership with the idea that they would take the charge.
Okay. Should we, I guess I still don't know, do you recommend just taking that out of the strategic plan?
I don't know how that should look on the strategic, on the plan.
Because we can take it out and we can put some implementation steps in the work plan with the requirement that staff come back regularly to report on both the completion of the toolkit, because that's step one, and then later implementation activities. Or it can go in the strategic planning.
What do you suggest?
Well, I'm comfortable with it not being in the strategic plan, but I think it's really whatever the will of the board is.
I mean, I think it should be there, but the idea that it gets, that the transfer of responsibility eventually ends up with the Judicial Council taking the lead.
Okay.
Right. Right. Though I mean, we're still always going to be in the mix, but it's just isn't us taking the load 100%, which is what we'd have. Right.
What I get is that we're going to be coming back throughout this small increments to come up with objectives. Or you have them ready to go. Want them ready for the summer.
All right. Anything else as to potential objectives that we can take on? Or no, anything that was not on the screen that you heard yesterday?
I think one of the things we didn't do, the definition of diversity that we were going to, we sort of had it on the agenda, but we never really talked about it. And I know Donna has a couple of different examples of what we can use, like whatever the federal guidelines are, the things that we report on now, protected classes, which is just what definition do we want to use in our plan?
Proposal, I think, based on the government code.
Yeah, so this this
Up on the
language, and
screen.
I think this seems to me to make the most sense. This language comes from Government Code 12011.5, subdivision N. This is the language that this was actually the language that was referenced the other day in legislation that was enacted in 2006. That required the reporting by the governor, required the reporting of from Jenny Commission and Governor Jenny and the Judicial Council of judicial applicants, judicial appointments, and the state of the judiciary. These are the diversity categories that the demographic categories that need to be reported: race, ethnicity, gender, gender identity, disability, sexual orientation, and veteran status. Those were when initially enacted, several of those categories were missing, and they've added categories over the years to look at. And these are judicial candidates, not sort of obviously the entire bar, but in terms of information that we might be collecting and what our goal would be that we are seeking to ensure, when we get to that next, presumably, if we are looking to ensure that the diversity of the attorney population matches the diversity of the statewide population. Those are things that I think we can capture, we can measure. We're not currently capturing veteran status on our attorney survey, so if we do want to include that, we would need to add that definition. One of the other things I was looking at was the definition in FEHA, as well as our new Rule 8.4.1, which is the anti-discrimination rule, which would prohibit discrimination against various protected classes. And it sets out quite a number of demographic information that we simply don't capture, and that I don't know that we would be trying to match the diversity of the attorney population, their marital status, with the population at large. So this seemed to be the most logical template to use for a definition of the demographic information that we would want to capture, and what we would be defining as what we mean when we're talking about diversity and the diversity goals we're trying to achieve.
Is there any, yes, Jason?
I agree.
All right, any further discussion on this definition? All right, can we move on to the discussion and adoption of the 2019 Programs Committee Work Plan? And Dag, and I guess, Leah, what are your thoughts on that? Is this something that we should table until the next meeting, maybe refine a little bit during our 2-week working group calls?
There's a couple things we definitely need to add. The review of a proposal for funding and other support from California law. And our work with CLA, there's 2 items we want to approach CLA about: the mentoring program and a leadership summit. So those for sure we want to add. And then based on the board's action this afternoon, if additional diversity objectives are incorporated into the strategic plan, then those ultimately need to go into the Programs Committee work plan as well.
Okay. So is there any objection to tabling this item to next meeting? All right. Seeing none, it will be moved to next meeting. All right. Any other business? Okay. Programs Committee is adjourned. Thank you, everyone, for your work.
Do you want to break for lunch, or do you want to go until when? What time is XCOM supposed to be?
11:45, so a half hour ago.
Okay, we're going to take a 10-minute break, and then we'll come back into XCOM.
what's happening is
All right, 2-minute warning. So for those who are listening or waiting for the convening of the full board meeting, I just wanted to forecast what we're going to do on public comment. So we're going to take public comment at the beginning on anything outside of the Appendix I item. And then as we go through the Appendix I discussion, we're going to take public comment by topic. So the board has the benefit of timely public comment per topic. So just sort of as folks are thinking about where that's going to factor in terms of timing, that's the plan. All right, hi everyone. It's Jason Lee. We are going to start the executive committee meeting. If I could have the roll call, please. Here, yes.
Here. Oh, I'm sorry, here. Here.
I'm
So
sorry.
we are going to go immediately into closed pursuant to Government Code Section 11126A1.
Call his name?
Sorry, Jason, I didn't hear myself in the roll call. My name in the roll call.
Yeah, yes.
Yeah.
It says that.
That was why I was confused.
Yes, he is on. We anticipate close will be about 20 minutes.
Get out, Vanessa. So, well, Vanessa's leaving. This isn't all that secret. At the last meeting, we talked about for Leah's review that we were doing getting staff input, and we talked about a 360, and there was some discussion because we had agreed we would do a 360, and when we saw the 360 instrument, it was very unusual, just to remind everybody, because it basically had all the different goals, and then it was to ask everybody, either who worked for Leah, people in the legislature, the Supreme Court, did they think that she had met these goals? And as we discussed, one, that's a very unusual use of a 360. One, because not everybody's really in a position to evaluate all those goals, but it's not really the purpose of a 360 is generally for developmental feedback. So we had some discussion back and forth. We also talked about the risk of putting some of those questions out to some people who might give us feedback that we wouldn't be able to address, and the risk with that. So we went back to the consultant and we asked her to redo the survey and make it more around developmental issues as a 360 typically is, but that would go to staff. And we had some discussion with Leah. It's going to go to a fairly broader selection of staff than we might have. Well, that's fun. Good thing we did.
going to get started in a couple minutes. But again, to just reiterate the plan for those of you who are here for the full board meeting and how we're going to chart out the public comment. We're going to take public comment outside of Appendix I item first. And then when it comes to the Appendix I item, we'll then take public comment as to the topic. So law schools, Access Commission, and the Legal Services Trust Fund Commission. So that the board has the benefit of those comments during our deliberations. We are still in the executive committee meeting. Hi everyone. Again, it's Jason Lee. We are still in the executive committee meeting. If I could get a roll call, please. Here. Here.
Duran.
This is a call for public comment on anything on the executive committee agenda. Next up is the chair report. I have nothing to report, so let's move on to item 3. There is nothing on the consent agenda, so let's go to 3A, the approval of the 2019 board committee work plans. Kim?
Okay, this item presents the 2019 work plans of the board standing committees for approval by the board executive committee. These are the work plans that were adopted earlier this morning. Not included in this item anymore is the programs committee work plan, which will be presented at the next meeting. So the work plans presented in this item are audit, finance and planning, and the regulation and discipline committee.
Any questions, discussion? Get that? That's Brandon and Debbie.
Mm-hmm.
I cannot substitute roll call, so I could have the roll call, please.
Sure. Lee?
Yes. Oh, actually, I don't vote.
Oh. Steinbrecher?
Yes.
LeBron? Manning?
Yes.
Mendoza?
Yes.
Stallings?
Yes.
Duran?
Yes.
And Broughton?
Yes.
Okay.
Now moving on to item 3B, the approval and ratification of the revised board book. Again, this is going to be Kim, and I believe she'll be joined by Vanessa.
Yeah, we also have Suzanne Grant on standby in San Francisco. And just to clarify, sure, okay, no problem. So there's a modification to this item. We're no longer seeking approval of the item. It's just a status update, and we'll be soliciting board discussion on a couple items. So let's see. we'll just skip the guidelines. This committee has been updated on the status of the board book a few times at this point, and I will refer folks to the September update for the guidelines, really driving the revision, so the transition from the old board book, which is extremely detailed and a bit hard to follow, into a much higher level document. So I'll refer folks to previous agenda reports for those specific guidelines followed. What this revision does, and it's again no longer for approval or ratification at this meeting, but it will provide members with the approximate length of the revision, the approximate level of description. This is one of the biggest changes. Instead of an extremely detailed document, often with irrelevant information, it's a much higher level, and folks can see from the attachment. The exception to that is that we do, upon internal review, we thought it best to hold off on putting it forward for approval, so that we could look a little deeper into material that's in the existing board book and determine whether or not it should come over. So a little more detail on a few sections. Examples of those sections would be the offices of General Counsel, the ED, and Chief Trial Counsel. Also, at the next meeting where we intend to put it forward for approval, we should have completed all of the appendices. The appendices were not going to be presented in this meeting because a few of them weren't finished. They couldn't be finished because of some final Appendix I decisions. But by the next meeting, all the appendices should be able to be finished. There is also one of the items in the revised board book is a new email policy. If folks want to hear about it, we have during this meeting we have Suzanne on standby in San Francisco to answer questions. Otherwise, that item will just be detailed in the March item. Okay, so not hearing any questions, we'll move on to soliciting discussion on a couple items. Is everything okay? In having internal review and then reaching out directly to a couple board members, there were some comments on the amicus policy. Additions information folks wanted pulled over from the old item to the revision, and so we thought, since there were already a couple comments, we'd open it up to others to see if any other folks had some comments about the amicus policy issues that they feel like they should address. General Counsel's office will be working on this section of the board book, but this would be the time to bring up any concerns about the amicus policy. I know there were some issues in the past where folks really wanted to specify that sub-entities couldn't bring their own amicus briefs, and that had to be more coordinated. So this would be the time to bring up any concerns. Okay. The other item that we thought we would bring up is, so in the November meeting, the Appendix I item, one of the recommendations was that there would be a presumptive limit of 7 members on sub-entities. But if a sub-entity needed more members than that for a couple of reasons, either workload or need for increased representation, there would be a mechanism for that sub-entity to come forward and request that. One of the items promised in the November meeting that would be in the board book is a process for that, for justifying an increased size of the sub-entity. And if folks have thoughts on that, this would also be a time to bring forward some thoughts. It's not required, but if folks have thoughts on that, they could be incorporated.
Is there any sort of preliminary is there any preliminary thoughts on how that should be structured?
Well, I mean, the preliminary thoughts were pretty preliminary, just in that we could break it down into two different instances. One instance where a sub-entity was being created, and then another instance where a sub-entity was already in existence, but so not being created, but already in existence. So if a sub-entity was being created, it would be created by the board, and the board could decide at that time, well, there really would be a need for more people, so let's just go ahead and do that at the time of creation. So that would be pretty easy. But if a sub-entity is already in existence, how does that sub-entity come forward? And one thought was, well, that sub-entity could just provide a written request detailing the justification, and the justifications are pretty specific, workload or increased need for representation, and then present that written request to XCOM. XCOM could then make the determination for a recommendation to the full board. But really, those just one idea.
Maybe also consider that request going to programs. That seems like a natural fit there.
Or the relevant board committee, because some of these sub-entities report up to RAD. So the relevant board committee, and then to the full board potentially, or to XCOM.
Do folks have thought on that, to board or XCOM, or?
Well, I think we've come a long way in this process, and the limiting the number of members on a committee, I think, should deserve full board attention. So I guess where we're at is the request should go to the relevant committee. The committee then develops a recommendation for the full board, and the full board can either take action in consent or on the regular business agenda.
Okay. And what about making the distinction between sub-entities already in existence or sub-entities that are being created?
I think in either case, you'd need some type of matrix that identifies the relevant type of individuals you want on the committee, what role they fill, and then you'd have an idea going into it why you need a certain size, and if they need to add to it, it would be the same thing. How does adding somebody, what role is that filling, and why do they need it? But if having a matrix has been helpful with like the skills matrix that the board has, but if we could kind of convert that to a committee structure, that would be helpful.
And the matrix would be something that all requests would fall into, or
when you're establishing it, or when you're revising the size. Yeah.
Okay. Okay, I think that's helpful.
Any other comments? Kim, anything else?
The only other point I wanted to make was, so then the plan from here is that within the next couple of months, we'll coordinate the further areas of review, some with OGC, and partner with a couple board members who've been volunteered to help with the heavy lifting on this, the final review. So we make sure that some board members have really gone through it. And we'll also complete the appendices and then bring back for approval.
Great, thank you very much.
Thank you.
So with no further business before the executive committee, this meeting is adjourned. We'll be back in about 10 minutes for the full board meeting. Oh, I just have to get one. But all right, actually revise. We're just going to gather the board members and we're going to go immediately into closed, at which point we'll be in closed for about we'll say 15 minutes. So I'll estimate we'll be back into open at about 1:30.
Jason, just a quick administrative thing. We
1:35,
may want to, we may want to note for the record that there was no reportable action from the executive session, for the executive committee closed session.
So noted. Well, good afternoon, everyone. It's Jason Lee, Chair of the Board of Trustees for the State Bar of California. Oh, we're still in open. We're still in open. Yeah. 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 So the plan is that we're going to go into open for about 1 minute. We'll take the roll call, and then from there, we'll go immediately into closed. So if I could get the roll call, please.
Here.
Here. Here.
Mendoza. Petula. Saleg. Stallings. Steinbrecher. Here. Please.
Here. With that, we're going to go into closed session after estimate about 1:35 to come back into open, at which point in time we will take public comment for matters outside of the Appendix I, and then for the Appendix I public comment, we'll take it during that agenda item. So moving to close, this will be closed pursuant to Government Code Section 11126 through 11126.2. We're now in closed.
Are you ready, Joe?
Hello, everyone. We are back from closed session. It's Jason Lee. It's 1:52. We're back in open. Could I have a roll call, please?
Della? Here. Duran?
Here.
LeBron? Here. Manning?
Here.
Mendoza? Here. Petula? Here. Selig? Stallings? Steinbrecher?
Here. Thank you. On the report for closed session, I have nothing to report on any resolved items. This is a call for public comment, as I noted when I started the open session. We're going to take public comment on items outside of the Appendix I discussion now, and I believe there's one person. Billia, come on up.
Okay, good. I was actually able to make this work, considering what some of the other speakers have gone through and considering that I'm not great with technology. I was wondering about that. Hi, my name is Emilio Veronini. I'm the Vice President of the California Lawyers Association and our official liaison to the State Bar. It's been my pleasure being here over the last couple of days. Enjoyed you all very much discussing the issues and working hard for the protection of the public and for the profession itself. So I'm only here to issue you an invitation on behalf of the California Lawyers Association to all of you on the board, to the General Counsel, the Executive Director, and others at the State Bar who may be interested to attend the opening of our new Sacramento office. We are having a reception on March 21st. We're very excited about the new office. It looks fantastic. And we're very excited that here we are in our second year and thriving very well, due in no small measure to your support and the partnership that we've enjoyed with all of you. So we want to thank you for that support. And as part of our thanking you, invite you again to our opening reception of our new office on March 21st in the evening. So if there are any questions from the board, I'm happy to answer them. Okay, with that, thank you all very much.
Thank you, and thank you for the invitation. And again, congratulations on your continued success. Moving on to item 10, which is the adoption of the November 16, 2018 minutes. Any objection to adopting the minutes as is? Seeing none, the minutes are adopted. Item 30 on the chair's report. I have no report, so I will cede my time to the executive director who has the report.
All right, so I have a written report, but I'm also going to make some brief remarks. My written executive director's report is dedicated to our new performance metrics, and I encourage members of the board to review those carefully. Importantly, these metrics measure results or impact as opposed to simply workload. The metrics, which address every functional area of the bar, were completed pursuant to the strategic plan that you adopted. Yesterday, a member of the board made a comment, something to the effect of, she was surprised to see that we were actually an organization that was working our strategic plan. And while, of course, that should be the norm, I recognize that that has not been the case for the State Bar. In fact, there is an over 30-year history of reports and plans being written, recommendations being made, and little to nothing actually being done. But that was the old State Bar. In the new bar, you mentioned the new bar today, Joanna, and it warmed my heart. In the new bar, the board sets policy as manifested in a publicly available strategic plan. Staff is held accountable for achieving plan goals through regular reporting to the board. This might sound insignificant, but I can assure you that it is extremely hard work. And it's work that we are doing against a backdrop of an increasingly dire fiscal condition. The old bar might have faced such a challenge with insufficient planning, an unclear articulation of need, failure to adhere to an adopted strategic plan, and a cautious retreat from mission-critical activities. In the new bar, however, we have re-engineered and reduced costs well in advance of the pending fiscal crisis we find ourselves in.
As a quick reminder for the board, some of those reengineering measures include drastic reductions in our catering, temporary help, and non-information technology professional services costs, requiring executive staff and state bar court judges to contribute to benefit costs on par with non-executive staff for the first time in the bar's history, a transition to CalPERS Health, a decision which reduced our annual required health benefit contribution as well as our unfunded liability, a transition to electronic billing and payment for the annual licensee fee statement, something so surprising to not be in place in the year 2016 when it was launched. These reengineering efforts reflect a new culture of innovation at the bar. In fact, many of our efforts to re-engineer have made us both more efficient and increased accesses and services to the public and to the licensees that we serve. Think about electronic billing and payment and the launch of online complaint forms. You heard one of our public commenters earlier this morning remark on how pleased she was that you can now file a complaint online. More efficient and better service to the public. And there's more to come. On today's adopted RAD work plan, for example, there was an item that did not garner much attention, but it's very reflective of the new bar. We will soon be asking the board to approve a contract to explore the feasibility of the use of computational law here at the state bar in order to increase our efficiency and standardize outcomes in the intake process. Again, this is the new state bar. More exciting, though, even in a time of great financial challenge, we are doubling down on our mission. And this, of course, includes the new statutory components of our mission: access, diversity, and inclusion. Of course, we currently have two important access initiatives underway: the California Justice Gap Study and the Technology Task Force. In addition, not as highly touted, but incredibly significant, is our staff work to increase the interest rates paid on IOLTA accounts. I want to make sure that I share this news with the board. That work has, in conjunction with the improving economy, resulted in a 450% increase in IOLTA funding over the last 2 years, from $7 million in 2017 to slightly over $39 million this year, and our staff should be applauded for that. Unlike access, however, we have a dearth of diversity objectives. In fact, we have no diversity objectives contained in our strategic plan, a situation which will be remedied, I hope, today based on the board's actions. Significantly, I believe and hope that the board will select objectives that are measurable and upon which real progress can be assessed, ones that help us to make real and be accountable for this most important goal of diversifying the legal profession. So in closing, I just want to thank you, the board, for your leadership, and thank my staff for all of theirs, because we have done some incredible work in the face of significant challenges. Those are my remarks. Thank you.
Thank you, Leah. Really an incredible set of achievements. This is not a chair report. I'm just responding to your report. The work that we've done over the course of yesterday, but really the fine work that you and your team have put forth in a variety of areas, truly incredible. So thank you very much. So moving on to the consent agenda, and I want to note that item 54111 has been withdrawn, and there will not be a approval or ratification of the revised board book, and that will be revisited at hopefully the next board meeting. Any objection to adopting the items on the consent agenda? Seeing none, the consent items are adopted. Moving on to items, section 700, we're on to 701, which is the approval of the 2019 budget.
All right, good afternoon. I think I'm ready to go. So today's item 701 is the approval or adoption of the 2019 final budget for the State Bar of California. Let me see if this. Uh-oh, technology. Oh, there we go. All right, so today's presentation, I'm going to provide a brief overview on the 2019 budget, talk just briefly about 2018 and what the results look like currently. Certainly go over in detail the 2019 budget, bar-wide. I'm going to briefly talk about projected reserves and projected reserves based on fund. And then I'm going to go a little more in detail on general fund because of the status and fiscal condition of the general fund. Steve Mazer is with me to discuss an alternative capital plan that is also identified in the staff report. And then staff will be available for any questions and then the adoption of the 2019 budget. So with that, just some key points I want to point out. The preliminary budget was presented to the board in November of last year. The adopted budget will be submitted to the legislature by February 28th. The final budget that's approved will include a projection or a projected budget for 2020. Resources are allocated to the core mission of the State Bar, which is public protection. And then we talked about this a little yesterday. The challenges that face the bar, specifically financially, is the mandatory fee has not increased in 2 decades, and this will be our 3rd year of a projected deficit. So just looking back to 2018, 2018 had budgeted revenues of $153 million with the budgeted expenses of almost $180 million. Overall, bar expenses are projected to be under, mainly from salary savings of $6.3 million. Specifically, in the general fund, revenues from interest income are up almost $1 million, penalties 1.2, and personnel costs are approximately $4.7 million under budget. Oh my God! All right, so this is what I would call the 50,000-foot view of the overall budget for the State Bar. Revenues, $168 million for 2019, with an increase of $14 million from prior year. Expenses are $194 million in comparison to 2018 of $179. The State Bar actually had a reduction of almost 5 positions for a total of 582. And just talking about the use of reserves, reserves are very similar use of reserves this year as they were last year. Because of the challenges for the general fund in 2020, reserves are anticipated to be less used in 2020. Just a couple notable deficits, general fund at 15.8, admissions at 900,000, and of course the spending down of the bank settlement funds at 9.6 million to support legal services. So really there's only 3 notable changes since the preliminary budget to the board in November. These 3 changes are identified on this slide. The first one is we're a little late in starting our financial and HR implementation. There is the budget from last year that was unspent that's being added to 2019. At the board meeting in November, admissions fund had a deficit of $1.3 million. That actually pushed their reserves under the 17% target. Admissions fund and the admissions staff made reductions to their expenses to ensure that that they were above the target of 17%. And then as part of that process, they also made reductions in legal specialization fund. So this is just a side-by-side comparison of the 2019 budget in comparison to 2018. Just a few, notables on this table is really general fund expenses and the increase of almost over 7 million. This really has to do with capital and IT investments and salary and benefits, which I will cover later. Admissions did have a decline in revenues from projected revenues in 2019 compared to 2018. And then the other one is just as you see at the far right, the 9.552 million, which is the bank settlement spend down. All right, so the next slide, I'm just showing you bar wide. There's really five main categories for revenues for the bar. First one is mandatory fees, in which we show very modest growth, a little over 1% over the next, showing you 2018, 2019, and 2020. Volunteer fees and donations remain relatively flat. Exam fees are projected to be less in the admissions fund for 2019 in comparison to the budget of 2018. Grants do show increases, and then other revenue, I think Leah talked about the increase in revenues from IOLTA to support legal services. And that's really for bar revenues for 2018, 19, and 20. As far as bar-wide expenses, the top item is salary and benefits or personnel cost. We really only see a 2.1% increase between 2018 and 2019. But in 2020, because of the contractual MOU COLA increases for represented employees, we see a significant increase in that year, a little over 5%. Building costs remain relatively flat with a $500,000 increase from 18 to 19, but a slight increase in 2020. Services show an increase in 2019, but show a $1.2 million reduction in 2020. Grants again, these are the legal services grants with an increase from prior years. And you see all the other ones show declines over the years related to 19 to 20. This just shows the areas in which we spend money. Number one area, 34%, is access and inclusion, and these are grants provided. Next one is Chief Trial Counsel, which is one of the largest expense, which is. Thank you for that. Very technical. Which is where we have the most staff for the state bar, and they're almost at 20%. General services, 19 million at 10%, and state bar court at 7.5 or 4%. Come on. All right. So the next table just shows personnel for the state bar. Again, almost a 4 FTE reduction from prior year. Chief Trial Counsel has an increase over two full-time positions, but this is really the makeup of the bar, and you can see not almost half, but 255 are in Chief Trial Counsel. Just not working. With that, there are a few areas I wanted just to focus on. First is the strategic plan, and Leah talked a little about the strategic plan and performance metrics. These are 5 areas that there's funding for 2019 to meet those goals set forth in the strategic plan, about a little over $500,000 for those 5 items. Next, which is one of the larger expenditures within the general fund, is capital for 2019. Presented this in November to the board, almost $8.5 million. This would be funded from general fund reserves. And later in the presentation, we will have slides to talk about the capital plan alternative. So the next slide is really showing you projected ending reserves and for each fund for the state bar for 2019. The one I highlighted in red, really to draw your attention to, and we've discussed in the past, is the projected reserve levels for the general fund based on the proposed 2019 budget. That number is 6.6%, or just a little over $6 million. This is the only fund that would fall below the board's reserve policy and the target of 17%. With the budget, we're also projecting the 2020 budget for the state bar as part of the overall budget document submitted to the legislature. Based on the projections, there really then becomes two funds. Of course, the general fund would not have enough resources to support operations in 2020 without either reductions in expenses or increases in fees. The other fund I just want to highlight was the admissions fund. And the admissions fund in 2019 was just a little above 17%. In this projection, they have a $1.2 million deficit, which pushes their reserves to about 11%. So talked about the general fund, and even 2019 would have reserves underneath the 17%. And so I just wanted to simply focus on the general fund at this point. 2019 revenues have a slight, or overall, or remained flat. Other revenue declined almost $1 million. But expenses have increased $7 million. Personnel expenses increased 2.6, capital 4.5, and services $2 million. As I mentioned earlier, this is the third year in which the general fund would have a operating deficit. This is just a comparison of the general fund, just showing you the 2018 versus 2019. As mentioned, revenues remain flat. There is a 2.6% increase in personnel at $1.8 million. And then you can see the capital at $4.5 million, higher than it was in prior years. Again, ending balance, reserve balance would be $6.1 million, or 6.6%. This table actually shows 2019 and the projection for 2022. Yes. Time's up. Overall revenues actually show an increase at 2.9, but I will note that this does include revenue from floor 3 if the tenant improvements were made. Personnel at $5 million, almost $3 million of that is related to the SEIU cost of living adjustment that will be granted January of 2020. In most every other category, you see declines because of the available funding. Even with those reductions, the projection for 2020 would result in not enough reserves to support operations. So moving on, this is really the alternative capital plan that staff has been working on since the board met in November. This plan overall shows a reduction, a proposed reduction of the proposed capital plan of $5.4 million. And with that, I was going to turn over to Steve Mazer to cover a few slides about the capital plan.
So following a presentation of the November preliminary budget, we did go back and take a look at the building-related projects to see what potentially could be deferred. There are two categories of projects, both related to our San Francisco building. One is the infrastructure projects or capital improvements. The other is the floor 3 renovation. There were no projects for the Los Angeles building scheduled for the 2019 budget. So the alternative plan does defer $5.4 million for a budget ask in 2019 of $3 million. Turning briefly to the infrastructure projects, we believe that we can reduce in 2019 the projects from originally budgeted $4.7 million down to $3 million, not down to zero. These projects are they are interrelated projects. All of the larger projects that we talk about in the big buckets of HVAC and fire life safety and related things, they're actually comprised of many, many smaller sub-projects that are interrelated, have many dependencies. So it is very complicated to try to untangle them and just sort of lop off pieces here and there. But We do believe that the detailed plan we have already put in place for many years will ultimately get us caught up with 40 years of with many years of deferred maintenance from on our 40-year-old building. And once caught up, we believe we will not have to expend this level of funds at this high level of spending for quite a long time. So in order to achieve these reductions, we are deferring the standalone projects or discrete components of some of the interrelated projects that we feel it is reasonable and doable to defer, but we do feel the need to continue the projects that are straddling 2018 to 2019 and really is not reasonable to cut off, and other key projects that really are critical for the longer term sequencing. Any questions on the infrastructure projects before I will turn to the warm shell renovation and tenant improvement? So on floor 3, this is actually a much easier budget discussion in that the renovation of floor 3 is its own discrete standalone project. We can simply defer the entire thing with no significant impact except the deferral of the rental revenue that the floor would ultimately generate once it is renovated. It is useful to note that our current tenant, who has recently signed a lease for the floor 1, is interested in expanding into floor 3. They have signed already a letter of intent. They are prepared to sign a lease amendment whenever we are ready to do so. My expectation is that even if we defer this, they will likely still be interested in expanding when we have the funds to renovate the floor. Some questions have come up around the possibility of financing these projects in alternate ways. So I do want to touch on that briefly to make sure we're all kind of on the same page about the question. Okay, sorry. We'll explain there are two. Oh, sorry, I've been so busy talking that I forgot. Okay. Great. So for the warm shell renovation, excuse me, just lost my slide. There we are. So there are two components to the capital project, to the third floor. One is the warm shell renovation, and one is the tenant improvement. So when we talk about the warm shell renovation, what we mean by that is turning the floor back into complete code compliant base building infrastructure systems in place. That includes things like level floors, restrooms, and elevator lobby in building standard finishes, all the main HVAC, electrical, fire, life safety systems in place. So all of this is owner's work. There is really no concept of a tenant ever paying for any of these types of things. These are squarely within the work that a landlord has to do to have a floor ready to be in leasable condition. The second component is the tenant improvement. The tenant improvement refers to the build out of office space. A typical commercial leasing scenario has the owner providing a tenant improvement allowance or a turnkey build based on an agreed upon TI amount. It does happen sometimes that tenants will fund a portion of their TI above the TI allowance amount if they choose to have more specialized or fancy finishes. But other deal structures really are very, very uncommon and limited usually to larger tenants with internal real estate teams. So an idea of especially that has been asked a couple of times about a tenant potentially just funding the entire TI themselves in return for some kind of ongoing rent credit is really not something that is done very often, and it is not, in the view of our real estate team, it really is not feasible. Turning specifically to our experience already in this building, get this slide advanced, right? We did have about 30 tenants or so 30 prospective tenants tour the formerly vacant floors 1 and 3. All of them expected a typical TI arrangement. There really was no consideration in this large group of any of them fronting the money for the TI. And the current tenant on floor 1 that wants to expand to floor 3, their model is a typical TI or turnkey. So with that sort of live tenant on the line ready to go, there is no consideration there for the tenant funding the TI in exchange for some kind of a rent credit. And the final, thank you. It has also been suggested that we potentially explore taking a loan. We don't really consider that a prudent alternative at this point. The bar does currently have some outstanding loans related to the purchase of the Los Angeles building and to the renovations on the previous vacant floors. Any additional financing that we could get would require a debt service reserve account, so that would tie up additional reserves. So for floor 3, staff is recommending that we simply defer floor 3 for now and explore it later when our financial situation is a little more certain. Questions?
Thanks, Steve. Any questions? Sonia?
Yes.
But floor 3 would remain occupied, right? Or
Floor 3 is the vacant floor. Floor 3 is
so,
the single.
So it's really not generating anything.
Floor 3 is the last remaining vacant floor that we are talking about either renovating now or deferring.
But there's an LOI for that.
Correct.
Okay.
Sean?
So I have a question about John's presentation, if that's in order. So, John, your slides show a deficit in the admissions group and increasing slightly next year with the reserves going below our level. So is there a plan in place to fill that deficit? I mean, this is a self-supporting program, so I think either expenses have to go down or the fees have to be raised.
So when we brought it to the board and identified that admissions had a deficit that actually drove us down below the reserves, they went in and really looked at their expenses and were able to reduce, the 400,000. I think they're looking at different alternatives in 2020 related to where test taking is occurring and how they're doing that to try to reduce those locations, reduce costs there. And I think they're aware of the challenge going forward and are trying to figure that out for 2020. So they're more than aware of it. I think they have a good runway between now and the next few months to sort of prepare for 2020. So
thank you.
That's exactly right, Sean. They're looking at test locations. We're also on a little bit, I think, of a longer term basis, looking at transitioning to the use of technology for proctoring. So those options will be coming to the board in future months.
Any other questions?
All right. So I do have just, I think, just 2 or 3 more slides. So based on the alternative capital plan for 2019, we actually even projected out the 2020 alternative, which is actually part of the 2020 budget. And if you look at what I'm showing you is the first 5-year capital plan, 19 and 20, is based on the 5-year plan, where the alternative for 1920 is to your right, and it shows an overall deficit or overall reduction, I should say, in capital outlay at 8.6 million. And so with that, we did take. Why is this not? Right. Maybe it's a user error on my side. There we go. So, right there. So based on that alternative capital plan for 2019 and 2020, this is the revised reserve projections for the general fund. And so to your right, under alternative, you can see that 2019 would leave reserves at about 13%, which is still under the board target of 17%, but would have enough reserves if needed to support operations in 2020. Certainly, without a fee increase for 2020, we would certainly have to revise and relook at 2020 expenses to try to preserve as much reserves as possible. And it looks... John,
just give us a narrative of the numbers.
Yeah. Okay, so I think with the capital plan alternative, projections related to reserves would still leave us $500,000 at the end of 2020. Certainly, without a fee increase this summer for 2020, we would certainly go into 2020 budget development with that in mind to do our best to ensure that we preserve the reserves that we have in place starting January 1st. And so really, I think I have one more slide just to show those numbers. Board reserve policy, just for clarification. Use of reserves are for one-time uses, unexpected expenditure requirements, and multi-year forecast that shows ongoing structural gap. And so that sort of gives the board an idea of how to use reserves. It also requires, if the reserves are under 10%, that the board has to approve that use of funds that would push reserves under 10%. With the alternative capital plan, reserves would be at 13.2%. And then finally, just the summary, which is third year of the general fund having a deficit. We believe the alternative capital plan would defer capital, but certainly would preserve reserves for 2020. And without a fee increase, 2020 will be very challenging. So with that, I'm open for any questions.
Josh?
Steve, I'm still I'm struggling a little bit, and I understand why we need to do it with regard to the third floor. But anytime you have an asset that we are going to let sit and have the economy the way it is and leasing the way it is in San Francisco, is it possible to have your leasing brokers look for the needle in the haystack? I mean, there are some tenants that you won't be bringing the same number in. I understand it's not a lot of them that may come in and pay for those tenant improvements. And if they did, you could at least get your triple nets paid and a little bit of the building costs covered. Otherwise, and it may not show up, but I'm concerned that a couple of years are going to go. We're going to have another tenant empty out. We're going to be in the same position, double the amount of TI we need to put in, and the market may be different for leasing. So I would just be concerned about completely walking away from looking for a tenant in that space.
I mean, I would say anything is possible, and they're certainly willing to make the effort. Thing is, they have made significant efforts up to this point. The market, they're very well aware of, our brokers are CBRE, the same company that handles both property management and real estate brokerage and construction project management. So they're very aware of all of the tenants in the marketplace, and they're also very aware of all of the inventory in the marketplace, as are all the other brokerage firms. They just gave me a number. There's something like now of 46 tenants looking for full floors, and there are 111 full floors in the 10 to 20,000 square foot range. So they do have a tremendous amount of insight into what the market is, both in terms of supply and demand. So I do feel like we are in very good hands with them. And I did have further conversations about this topic with them in preparation for this meeting. They're certainly willing to try to do more than they have already in terms of finding the needle in the haystack, but their understanding of the market basically is that it was be extremely unlikely, just based on what they know, their insights into the market as it stands right now.
And Steve, there are really two pieces, right? There's the warm shell improvement, and then there's the tenant improvement. And while there are scenarios where the tenant picks up the TI cost, my understanding is that there are not scenarios where the tenant would fund the warm shell.
There is no scenario where the tenant is correct.
So Josh, if that's something you wanted us to pursue, the something being to find a tenant who would fund the TIs, we would need to include in the budget at least that component of the $3.7 million that's associated with warm shell.
Yeah, I appreciate that that there is certain generalities in the market. But I do believe there are tenants, when you sit down and look at what the costs are and what is warm shell and what's not and how far you take HVAC, I don't want to get into that conversation today. I just think that I was looking for a commitment that we would continue to look for opportunities to lease that, even if it meant that we needed some alternative financing, and when I say that, I don't mean debt financing, I mean tenant potentially financing. So we may offer a longer term of free rent, and I mean really long term, but the fact that they come in and they're willing to pay some portion, which would include the utilities and things around the triple nets, I think would be helpful. And my concern is really that if we let it go for a year or two and that building starts to empty out, we're going to be in a really tough spot when we have 2 or 3 floors or 2 floors. So I just want to make sure that we're still focused on looking for a solution.
Any other questions? All right, so let me recap. First, to Josh's point, it sounds like we can go back to our brokers and have them continue to look. They're not stopping.
No.
Okay. And they are exploring alternative options to find a tenant for that floor.
I mean, they are aware that we are interested in such a thing, so they have their feelers out. Although again, they do have insight into sort of what's happening now in the market. So at this very moment today, there's no viable option for that. But they are aware that it's something we're interested in.
Okay. So to recap, at our prior meeting, we were presented with a preliminary budget in which we presented to the legislature with a cover sheet that essentially, in substance, was a message that the Board of Trustees recognized the dire financial straits the agency was in. And we detailed a number of items that we had asked the staff to review for this day, which is a presentation of a reduction of costs and what seems to be the most material item, which is to delay the build out of the last remaining floor in the San Francisco building in order to save costs. And my read of it is, by doing so, we will barely eke out 2020, barring a fee increase. Is that right, John?
Yes, that would be the summary for the general fund.
Got it. So I.
Yes.
Right. Right. And we talked about that. Certainly the board has options as we get more visibility into the fee increase and into our continuing financial deterioration, what to do midstream. So if I'm to read this right, it's for us to decide whether we're going to adopt the alternative budget with the reduction of costs or remain faithful to the preliminary budget that was presented at our last meeting that did not have those reduced costs. So I think I am asking for a motion, and I'll just say from my own personal view, given the charge that we had asked the staff to do, that it seems prudent that we adopt the alternative budget, understanding that we would still proceed with finding options to rent out the last remaining floor, lease out the last remaining floor in San Francisco. So with that, oh sure, Joanna.
There's a proposed resolution in the memo that came, and I'm just curious, it references the budget as provided in attachment A. Is that the alternative budget?
No, it is not. It is the preliminary with those 3 adjustments. So if the board's action is to adopt a budget with the alternative capital plan, we would prepare the adjustments accordingly.
Okay, so we can't use this as drafted. Okay. But we still want to include the language about authorizing technical adjustments and so forth.
Can you just add in final alternative
budget? Final adopted budget as presented to the board today.
Add a resolution that staff is directed to to continue to make efforts to find a viable tenant for the third floor? No?
I don't know it's necessary as a resolution. Not for me.
Okay.
I'll make the motion as amended.
We have the motion by Joanna, second by Renee. Any objection to substituting a roll call? Matter is approved. Thank you. All right, we are moving on to item 702, which has quite a long caption, so I'm just going to call it the approval of the Omnibus Appendix I sub-entity review. As I mentioned at the beginning of this meeting, we're going to take it in pieces. The staff is asked to do a presentation relating to the first component, which is the law school component of the Appendix I review. And with that, Donna is going to come up, do the presentation, and then at which point I'll ask for public comment.
Just getting my papers in order. Good afternoon. At your September board meeting, along with a variety of recommendations on other sub-entities, the board acted on a number of recommendations regarding the work of the Committee of Bar Examiners. However, you deferred action on the law school engagement and accreditation at the request of staff, so we could engage in further discussions with the deans and bring the recommendations back to you at this date. We conducted 2 meetings with the law school deans, one in Southern California, one in Northern California. As a result of those meetings, we developed a proposal, circulated that proposal on law school engagement and accreditation to the deans, received feedback from consolidated feedback from 13 deans of the California accredited law schools, 10 registered deans, and we reviewed their concerns and questions and revised the proposal, which is what you will find in attachment E to today's agenda item regarding law school engagement. I'm going to highlight just a couple of the key proposals that relate to the proposed changes for law school engagement. First, I just wanted to identify that the goal of these changes that were proposed was to increase engagement by and with all types of law schools. By that, I mean ABA approved, California accredited law schools, and the registered law schools. So what's included in the proposal that you have before you today? The first thing is a modified structure for the Law School Assembly, Law School Council, and the Rules Advisory Committee. So first, starting with the Law School Assembly. Forget the notes. The Law School Assembly is an annual meeting of representatives from all law schools. What we are proposing to do is to continue the annual meeting, but to refocus the subjects of the meeting, really to develop the meeting with the input of the deans around issues that are of interest to all law school types. In recent years, the Law School Assembly has really been more nuts and bolts discussions of issues that frankly have been of more interest to the CALs and the registered law schools and the ABA-approved law schools. This is an area where we envision that we would have broad policy discussions with all of the deans in the room. This is where we maybe talk about dealing with wellness issues, dealing with diversity issues like we were talking about earlier. I'm really talking about some of these broad policy issues and figuring out what's going on in the law schools, where the state bar can help the law schools, and what information we can provide. One of the other committees that we currently have is the Law School Council, which is combined currently of a mix of the members of CBE, the registered, the CALs, as well as the ABA. We're proposing to limit the Law School Council to ABA schools only. And then then with regard to the RAC, or the Advisory Committee, I always get the name of this one wrong. The Advisory Committee of, where are my notes on this one? The advisory, well, they deal with the rules and guidelines for the Cal accredited schools. So what we're proposing to do is to change the composition of the schools, and as a result, change the name of the composition of the group as well. Change the actions that they are taking. We are proposing that they be comprised of CALS deans, unaccredited school deans, and 2 appointees from CBE, one of whom may be an outside expert on issues related to accreditation. We are naming this the Committee of, I'm going to do the name wrong again. Thank you. The Committee of State Bar Accredited and Registered Schools. I appreciate that, Dean Minnick. And their responsibility would be to provide input on both the accredited and the unaccredited rules and guidelines. Right now, they are limited to providing, their charge is providing input on the accredited rules and guidelines. And so the makeup would change and the mission of that would change. Also, they would be suggesting topics for ad hoc working groups, which we'll talk about in just a second. One of the things that staff has proposed that the consolidated group of deans who wrote in about the proposal has a concern about is how the members of this new committee, CS bars, would be appointed. The staff is proposing a process similar to the way we're appointing members and leadership of all of the other sub-entities. For the other sub-entities, requests come in and the liaisons, the appointment liaisons to the executive committee review and make selections. We were proposing that as a advisory committee to the Committee of Bar Examiners, instead of the letters of interest going to the appointment liaisons for XCOM, the letters of interest, the applications for participation would come to the chair and the vice chair of the Committee of Bar Examiners. And the Committee of Bar Examiners would receive the applications, receive letters of interest for the chair of this new CS Bars Committee, and would make their selection. The objection, we received an objection, the request from the consolidated group of the CALS deans and the registered deans who commented on the proposal was that they be able to select the members subject to confirmation by CBE. Staff believes that because the process we identified really is parallel to what we use for the other sub-entities, at this point we're not prepared to recommend a change from what we put forward in attachment E to this proposal. One of the things that we are recommending a change. And the reason that I'm sort of going into this level of specificity of clarifying what's in attachment E is because the resolution that you have at the back of this agenda item specifically asks you to adopt the proposals as set forth in attachment E. So we wanted to be clear. One of the items suggests that staff would be setting the schedule of meetings for this new committee. And we wanted to clarify that the proposal would read that the schedule of meetings would be set by State Bar staff in collaboration with the chair of CS Bars. Moving on to another key part of this proposal, it would be the ad hoc working group. We've touched on this a little bit before. We are looking at the idea of creating ad hoc working groups on discrete, specific topics. They would be time-limited working groups that would be created at the request of the Committee of Bar Examiners, State Bar staff, this new CS Bars Committee, or the newly comprised Law School Council. They would one of the first topics that we envision assigning to a working group would be having an ad hoc working group on moral character to help us develop guidelines to ensure the consistent application of the determination of whether or not an applicant for the bar possesses the requisite moral character. Again, sort of one clarification on what is included in the attachment. We want to be clear that the State Bar will consult with CS Bars and the Law School Council on the member selection for these ad hoc working groups. The only exception to that would be when time constraints make that consultation not feasible. And the final highlight from this proposal for law school engagement would be new e-newsletters where the State Bar staff, hopefully with the assistance of some law school deans who have interest in topics and authorship of such topics, will provide a periodic e-newsletter to the law school deans to improve the sharing of information with the law schools on a variety of topics to really improve the flow of information, to increase that communication. In addition to law school engagement, when we met with the deans back in October, we considered proposals for accreditation of law schools. At one point, staff was considering a proposal that would require that law schools would get accredited by a regional or national accreditor, like the Western Association of Schools and Colleges, WASC. What we ultimately propose is that we recognize national and regional accreditors in a similar fashion that ABA approved schools. We recognize the accreditation of the ABA. Right now, there are not statewide accreditors, but we could certainly consider the future possibility of also recognizing a state accreditor if one were to come into existence in California. We were looking at for these schools that we would recognize the national and regional accreditors, and one of the reasons, frankly, that we're looking at doing this, although it is not required, currently 6 of the 15 of the California accredited law schools is accredited by WASC, and 3 more at last count we're anticipating accreditation by the end of this calendar year. And so that would be the majority of the CALs would have WASC accreditation. So instead of having to accredit those schools, if they were accredited by WASC or another regional or national accreditor, then we wouldn't be accrediting them. We wouldn't be doing site visits, but there would be some additional requirements that we would hold them to. Those are as yet to be determined. We will task our CS Bars committee to come up with additional requirements that should be imposed on these schools that would no longer be subject to the California accreditation requirements, things such as minimum bar passage rate, additional required disclosures, required reporting requirements, et cetera. They would make a proposal of additional requirements that would come to the Committee of Bar Examiners and ultimately to the board for approval. For those others who are not accredited by a national or regional accreditor, we would continue the accreditation process that we have now, except that one of the other things that we are going to be tasking our CS Bars to do is to improve the current rules and guidelines for accreditation, really look at best practices, what some accreditation experts do, and really make sure that we can update our accreditation standards so we are really doing the best job that we can to make sure that we are accrediting the right things, that we are motivating the right behavior, and that we are achieving the results that we're seeking to achieve. The other part of this proposal, back in November of 2017, the Board of Trustees approved a consolidated proposal to seek statutory and approved also the rule changes to allow for the accreditation of distance learning schools. It was packaged with a requirement for mandatory accreditation. So all schools would be required to be accredited, and it would, for the first time, allow us to accredit, in this instance, require us to accredit online schools. We are proposing to tease those two pieces apart so we can start immediately with allowing the accreditation of online distance learning programs while staff is pursuing with the legislature the feasibility of the moving forward on the statutory changes for mandatory accreditation. Again, these rules and guidelines and statutory proposals were previously approved by the board, and we're just teasing them apart so we can move them separately. And that's the crux of the proposal. Happy to answer any questions after you take your public comment.
Thanks, Donna. So this will be public comment on the law school portion of the Appendix I subentity review. I do have a list up here, but often there are backroom deals made on who will go first or whether time will be allotted. So come forward and please introduce yourself. Given the number of individuals that want to make public comment today, if you could limit your comments to 3 minutes, I would appreciate it.
Absolutely. Thank you. My name's Jackie Gardina. I'm the Dean of the Santa Barbara and Ventura Colleges of Law and currently a member of the Rules Advisory Committee. I'm here first to thank the State Bar staff. I think a year ago, there was a lot of fear and I think mistrust about what was going to happen when it came to accreditation and law school engagement. And I want to commend the State Bar staff for hitting pause, engaging all of the stakeholders, listening to what our concerns were, and I think really coming up with an outcome that was a stronger outcome than where we started a year ago. And that's in large part because of the process that was engaged in. And I just want to thank Leah and Donna for the work that they did to come up with the proposal that's contained in the 2 attachments that you have before you. So it is only a small piece of that proposal, as Donna pointed out, that I'm here to speak to you about in terms of what we would like to see done differently when it comes to the nomination of members to the CS bars. I'm going to put aside the desire to brand it differently, but the CS bars group and the choosing of the chair and the vice chair, as we heard from Donna, there's an enormous amount of work that committee is going to be tasked with. What we have before you right now is a framework, but there's an awful lot of details that need to be filled in. And what we learned through this process up to this point is that procedure aids with the legitimacy of the outcome. So what we're really wanting is to ensure that the stakeholders involved have the opportunity to be fully engaged in the process of creating the guidelines that eventually, and advising the Committee of Bar Examiners, and then ultimately the Committee of Bar Examiners and of course the Board of Trustees are the ones who decide whether or not those guidelines are fit to be passed. And so what we did after we received the feedback from the State Bar last week was outlined just the small place where we saw something that we'd like to see different. And with permission, I'd like to just hand out what was the red line version, not of the entire thing, just of the small piece regarding the committee.
Sure. It looks like Sarah's going to come down.
Thank you. Right now, the Rules Advisory Committee, the chair of that committee is chosen by the committee itself, and the chair is recommended to the CBE. Likewise, those nominated to serve on that committee are chosen by the CALs as a group. As you may know, that group, or as Donna pointed out, is only Cal schools. This new CS bars will actually involve, I think, to the betterment of the group and its decision-making, both registered schools and Cal schools. So this would allow the individual school groups, registered schools, and CAL schools to put forward nominated parties to the chair of the CBE to be chosen for sitting on that. And the committee as a whole would recommend the chair and vice chair to the CBE for approval. And it mirrors what's happening with the Rules Advisory Committee now. And so we would just like that same process that we're using now to be the process that is used with CS bars. So it's a slight change, but one that the CALs felt was important, and one that I wanted to put forward now as a recommended change to the attachment that you're going to be voting on today. In the chance that this isn't something that you feel comfortable voting on today, then I just ask you to put aside the nomination piece of the attachment so that we have an opportunity to engage the State Bar staff more about our concerns and see if we can't come up with a proposal that works for everyone. So I want to thank you for your time. And again, I commend Donna and Leah for the work they did in helping us get to this place.
Thank you.
Can I raise a question with her?
Oh, sure. Jackie,
Dean
you have a
Gardenia?
question from Joanna?
I want to challenge you and whoever's coming up to speak on this issue. That a lot of the reforms we've made at the board level go to similar issues. We no longer select our own chair because there was a lot of politics involved with that. We no longer will have elected members elected by the body, that it regulates. So I see some comparisons there to what you're talking about that concerns me. I'm curious why the CALs and the registereds think that there's enough difference between them and the board and how we operate that we should make an exception. I would like to hear your thoughts on that.
Sure. I mean, as we talked about it, we saw the one difference between the other sub-entities within the board is that this sub-entity is a different sub-entity in that it is about engaging the stakeholders that are going to be deeply affected by the rules and guidelines that the Board of Trustees will eventually vote on and we would be subject to. So we just thought of it as different and distinct from the current sub-entity structures that are across the board.
Thank you. Do we have any other public comments on this particular topic? Welcome back.
Thank you. Greg Brandis, St. Francis School of Law. In these uncertain times, there is only one thing you can count on, and that is that if distance learning is on the agenda, I'll have to say something. You can count on that. I appreciate your time once again for considering those matters. As Donna laid out very ably, this has been a long process. It's gotten to a spot where I think everybody agrees how important this is to do. It's necessary for your approval of the separation of the mandatory part because it was deemed that was not something the bar wanted to pursue as a legislative priority in these uncertain times. But there's no reason to delay the other portions of it. I think it's fair to say that the schools in those categories have been performing to a degree that certainly rivals that of the accredited schools in terms of bar passage rate and the success of their students. So it's pretty easy to defend on the data standpoint as well, from the standpoint of the bar. It also forward-looking. I should say that at this time, California's actually fallen a little behind the national standard in terms of the accessibility of distance education in legal education. At one time, California, had it moved more quickly on this, would have been the leader. But actually, California is a little bit behind the national ABA standards presently. So this move also puts us in a position of a set of standards begins the process that's been discussed of evolving to a set of standards that is modern and very outcomes oriented and calls upon the schools to demonstrate why they teach in the way that they do, which should be a very productive process for the schools to actually improve their education, improve why they do it, how they do it, and the rest. And the standards today that you are voting on today would move the state bar significantly in that direction. Obviously, it's a little detailed to get into exactly how, but they would indeed do that. Let me also just comment briefly on CS bars. I think it's wonderful that the bar and the schools have reached a spot of agreement on almost all portions of this. I appreciate your consideration of what Dean Gardina raised in terms of one remaining matter, and I concur completely in her argument, her answer, Joanna, as to why that's important. This is an entirely different sort of group. The purpose of this group is, in fact, to gather input from the directly affected stakeholders. It's a very different sort of thing than a typical decision-making sub-entity or recommending sub-entity. So thank you again for your time. Thank you for your consideration of those proposals.
Thank you. Any additional public comment on this subject matter? Come on up. And if you could introduce yourself.
Good afternoon, and thank you, Mr. Lee and Mr. Steinbrecher and Ms. Holton and Leah Wilson and members of this board. I think it was about 45 years ago, in 1974, when I last addressed the Board of Trustees. It's been a long time. My name is Stanislaus Pulle. I'm the Dean of the Southern California Institute of Law, where I instruct constitutional law, and I've been doing so for quite some time. I hope you won't consider it a strike against me, but a couple of years ago, we sued the state bar on the basis that the state bar does not have the inherent authority to accredit law schools. The Ninth Circuit, in a 3-page unpublished opinion, ruled against us. They thought that you do have that inherent authority. About 2 years ago, there was a motion made to the California Supreme Court to adopt, as a part of its inherent authority, a particular rule relating to accreditation. There were 15 entities and deans in support of that rule. We were the only dissent. And my dissent to the Supreme Court began quite unequivocally and quite direct. Sometimes we scholars have a way of writing things that are far too direct. But my first 4 words to the Supreme Court was, to the Madam Chief Justice and Associate Justice of the Supreme Court, this you cannot do. And that was based on my version of constitutional law. The Supreme Court demurred and sent the matter to the legislature. We were the only dissent of 15. Today I come to you to discuss what is really a seismic event, because Dean Parker and Dr. Walton, who were commissioned by you to make a study, have now reported that you do not have the inherent authority on accreditation matters. It's like some Hindu deity with so many arms, but you carry out the functions of the core powers of the Supreme Court. Now you have an arm that does not belong to you. It belongs to a different sovereign. It belongs to the legislature. And I have before me, because I'm not technologically savvy, as you can see, I'm pretty arthritic and I can't even sometimes hold on to a book. But I have a short summary of my comments that I'd like to hand over to you. And then in your allotted 3 minutes, quickly reference to you why this dissent
Sir,
needs to be taken.
Your time is up, but we will circulate your materials.
Okay, thank you very much. Yes, you can give them to them.
Thank you for your public comment. Is there any additional public comment on this subject? With no further public comment, is there any questions or comments relating to this component of the Appendix I review? Brandon?
I guess my question is for staff as in regards to the language proposed by the CS, whatever the rest is, the alphabet soup. As far as their proposal, is that something that, I mean, is workable? Does that resonate with staff as far as engaging stakeholders and continuing the good work that both staff and these stakeholders are currently kind of walking down?
So it was certainly my hope that we would come to agreement on everything. We came very close, which if you witnessed the meetings that we had with the deans, it was quite an accomplishment. But I do have an issue because, for example, the recommendation, the board received, CBE received a recommendation a couple of months back for the, or the board did actually, for a temporary appointment of a reappointment of the members of RAC until this decision is made. That recommendation came from the Association of Cal Accredited Schools, a name that I guarantee you I've also gotten wrong. As I understand it, 13 of the 15 CALs are part of that Association of California Accredited Schools. And so that certainly is a concern to the extent that if a recommendation is coming from a group that does not include all of the CALs, would those who are not participants in that organization have the ability to present their name for appointment and have that considered by and that's why we were proposing the recommendation would go to CBE, the letter of interest would go to CBE, you'd apply, I'd like to be part of CS bars, and the determination would be made by them.
Renee?
I just have a question. Can you clarify for me when you say to advance? If you, I lost whatever you had up before. Can you go back? You said about advancing the online. I just don't know what is that? What is advance?
Yes. So the board approved back in November of 2017 the proposal that was a joint proposal for the online accreditation and the mandatory accreditation. What we are proposing is tease them apart because we can proceed with the online, the proposal for the accreditation, to allow accreditation of online schools. It does not require statutory change, is only rule and guideline changes, and effectively you've approved those rule and guideline changes, so we would set up a timeline to roll that out. Exactly. Right. Yes, roll it out, yes.
Joanna?
I understand public comments over, but I would be curious to get the reaction from the CALs regarding Donna's explanation about the concern that staff has with excluding those who are not a member of this association in the CS bars membership. Do you?
You know, Joanna, I'm going to make a very special exception for you.
Thank you, Jason.
Come on up.
And limit your comment to 10 seconds. No, I'm just kidding.
Now, that was just mean. Let me just thank you, Donna, for helping us clarify that. In this context, when we say California accredited law schools, they would all be entitled to participate in this selection. We have a nonprofit that is the Association of California Accredited Law Schools that the group gets to choose to join. And that group does a lot of policy work together. But to clarify, in this case, that would not be the group making the recommendation. This would be the technical standing of any school that's a California accredited law school would participate, not any, all would participate.
Okay. Any further questions, comments? All right, we're going to take this piecemeal. So up on the screen right now are the proposed resolutions relating to these issues.
Jason, if I may, I apologize. One of these resolutions might seem a little out of the blue with regard to the committee because we didn't discuss it right now. It is outlined in the agenda item. Actually, Dag, is that at a later point in this slide? Yeah.
So that's one of the final recommendations we placed there. It's been added in order to fit with the other rule changes.
My question is just, I'd talk about it now or later? Later.
All right, so the resolutions are up on the screen. Can I have a motion?
So I would make a motion as to attachment E with the changes as proposed by the CALs. So changing that limited aspect of how members are chosen. And that would correspond to the language circulated. Yes.
Do we have a second?
I don't know whether this was read for the record for people who were just listening along. It may make sense to read it just so it's clear.
Sure. Sarah, could you read it?
Resolved that the Board of Trustees approve the proposed approach to law school engagement set forth in Attachment E and direct staff to implement the proposal.
So Brandon's motion includes adopting this proposed language by the
Oh.
dean.
Okay. And so it would be to, for candidates for members shall be nominated by each respective group and submitted to the State Bar for confirmation by CBE Chair and Vice Chair. CS Bar Chair and Vice Chair shall be nominated by CS Bar and submitted for confirmation by the CBE Chair and Vice Chair. So that's Brandon's resolution.
Correct.
Thanks, Sarah. Do we have a
I'll
second?
I'll second it.
Joanna with a second. Any further discussion?
So I
Sean?
just have a question of clarification for Donna. Donna, you said, so we're voting on approving attachment E as modified by this proposed change, and there's something else also?
Yeah, so in the PowerPoint, as I was going through, there were 2 points where I had mentioned a clarification to the chart. One was the point where it said that staff would set the schedule for meetings of CS bars. That was changed to say that State Bar staff, in coordination with the language was on the screen, in coordination with the chair of CS bars would set the schedule. And then the other clarification was with regard to the ad hoc working groups. The attachment E says that that the State Bar would consult with the with CS bars when feasible on the membership, and that was changed to say that we would that they would get the input of CS bars or the law schools, whatever the proposal says, except if time constraints made that impossible. So making the default that, of course, we would be consulting with them on the selection of the members of the group.
Okay, thank you.
Okay, I have a question then. Joanna, you made a mention of how the Board of Trustees, we don't choose our chair, that the Supreme Court does. And you made mention, were you saying something in opposition to what this language is saying, or?
No, I was just trying to find out why it is they as a group felt that they were somehow different, from example, like the board, where we've gotten rid of elected and doing our own chair. I wanted to see from their perspective how they were different. And I think they've made, in my mind, enough exception. It's not a hill I think we should be dying on. They are different to an extent, and I think we should just see how it works out. If there's a problem going forward, we can revisit this, of course, but you know, I think they made enough of a case that we don't need to be worried that the same problems will arise.
Brandon?
So I appreciate staff's desire to be consistent and to have procedural fairness and to present fairness, or that there's a fair process in going forward in this Appendix I review, and I think that has been done. I was once arguing with a judge about a ruling, and I said, "But Judge, you have to be consistent with this other ruling," and he told me consistency is for the feeble-minded. And I was like, "Well, thanks. How do you recover from that?" I think that in our desire to be consistent, we shouldn't lose sight of particular nuances, and I think this this proposal does fall into one of those nuances where, we just got done talking about law school engagement and our strategic planning for the programs committee about addressing serious issues or perceived issues in the legal industry. And by us engaging at an even deeper level through this proposal, I think we continue to work towards that goal. So that's why I support the recommendation and then the modification.
Alan?
I think we may be spending a lot of time over something that isn't really all that earth-shaking, but since we are, I will throw my lot in with the feeble-minded and inform you that I'm going to vote no on the motion for the reasons that Donna has articulated.
Any further discussion? All right, so we have, Sean.
I just want to add one other point to this. I think Joanna's made the point about changes in how the board is composed, but I think we've sort of adopted a more general approach to this, that unlike the days of the unified bar when sub-entities would nominate their own successors, we have adopted a more general principle that the executive committee of the board carries out that process. So for example, when I was on COPRAC for many, many years, we would send a roster of proposed members to the board, and I think it was more or less rubber stamped. I don't know exactly what went on with all of the committees. So that was sort of a general principle of good governance. And so I would just like Leah or Donna to give us what's the best case against this piece of the motion? If you could just restate that so that we have it on the table.
So, that was the point I was trying to make, but clearly did not do so eloquently. Every bit of adrenaline has left my body. But that is exactly the point that I was trying to make, is that it is entirely consistent with the good governance that we've adopted for governance of all of the sub-entities. One of the global recommendations that was adopted by the board was the elimination of the nominating committees for all of the sub-entities. And in lieu of that, applications would be reviewed by the appointment liaisons to the executive committee to the board, and letters of interest would be submitted if you wanted to be chair or vice chair to the appointment liaisons to the executive committee of the board. What we were proposing was a parallel structure because of sort of the good governance reasons that the board adopted that for all of the sub-entities. And so I too, Alan, am feeble-minded, and I'm a rule-oriented gal, and I like consistency. And we thought that really was consistent with the direction that the board was moving in for overall governance.
And I would just add that, although not so applicable in this context, this is really important when we talk about diversifying our volunteer pool. When you have the nominating committees and sort of the group finding its own replacements, you tend to have like-minded people coming on and like people populating these groups, and we've seen that throughout the organization. So creating a process where there is intentional and broad outreach and a fair opportunity for all to achieve leadership positions is really important from that perspective as well.
And my apologies for calling everybody feeble-minded.
I don't think you'll be living that down anytime soon. Sean.
I just want to point out one more thing. I think I'm inclined to vote against the motion because of this proposed amendment. And this is already, as proposed by the staff, it's already a bit of a compromise because XCOM is not making the appointments to CS bar, it's CBE, so it's a little farther down the hierarchy, so to speak, and that's already an exception to our general policy. So that makes me lean a little further towards we're not even being fully feeble-minded, we're being partially feeble-minded because it's not totally consistent, and it is an exception.
All right, I think we're ready for a vote. Given what I'm hearing, let's do a roll call. Correct. Yeah, we have a motion by Brandon, seconded by Joanna, with the modification as that has been read into the record as suggested by Dean Gardenia. So that's getting typed up now.
Okay, Broughton?
Minded no.
Shan? Dylan? No. Duran?
No.
LeBron?
Yes.
Manning?
No.
Mendoza? Yes. Kurtula?
No.
Selig?
No.
Stallings?
Feeble-minded, yes.
Steinbrecher?
No.
Motion fails.
So
Do I have
may-
another motion?
Jason, I would move the original resolution.
Second.
All right, we got the motion by Brandon, second by Sean.
As modified by the two ways that we had talked about during the.
Yes, that's right.
Yes.
So as with Donna's two amendments.
Brandon just wants to get a motion done.
Yes, yes.
Oh, sure. The next motion was brought by Brandon and then seconded by Sean.
Broughton?
Yes.
Jen? Dylan?
Yes.
Duran?
Yes.
LeBron? Yes. Manning?
Yes.
Mendoza? Yes. Kurtula?
Yes.
Selig?
Yes.
Stallings?
Yes.
Steinbrecher?
Yes.
Motion carries. Thank you. Let's take a short break.
Okay.
Looks like on the evil side, huh?
We have some encouraging news about recent events.
Some help? Yeah. What happened?
I'm working with so I just got
Thank you. When we got talking about changing quality, there were a couple of bigger entities that they found places that did it. Okay, right. Yeah. I couldn't. The comment.
I think even my 6 o'clock is in danger. Yeah, even my 6 o'clock is in danger.
All right, everyone. 2 minutes.
Testing. This is a test.
Oh, we have one more motion.
Audio is muted. Audio is muted. This is a test.
We might have people listening in the conference room in San Francisco, so they might be hearing the audio. I don't think anyone.
Sir, I think we need to get the, we missed the motion. We missed the,
Donna, do you want to come up? Oh, I don't think so.
we could have, but the motion was only on one. That's why. I mean, if Ben had decided to be a little more efficient, then could have.
We think we need to start with the motion on accreditation. I don't think.
All right. We are, we're back. 333, Jason Lee. We do have to resolve or consider one more resolution relating to accreditation. We have one additional resolution relating to the law schools, and that relates to accreditation. The resolution as currently is further resolved that the Board of Trustees approve the proposed approach to accreditation set forth in attachment G and direct staff to implement the proposal.
I'll make the motion.
I got Brandon with the motion and Alan with the second. Any further discussion? Did someone just walk in? Or are we okay with substituting the roll call? All right. Any objection to substituting roll call? All right. So resolved. Thank you. All right, we are on to the second issue relating to the Appendix I review. This relates to the California Commission on Access to Justice. Donna, did you want to do a presentation first, or would you do
Either way,
public comment?
however you want to run it is fine.
Okay, let's do public comment. This is a call for public comment on the Access to Justice Commission. I see Amos coming up. Welcome. And with the other public commenters, if you could keep your comments to 3 minutes, we would appreciate it. Thank you.
Yes. Good afternoon. My name is Amos Hartston, and I'm honored to be a member of the California Commission on Access to Justice. I also participated in the working group, and I'm looking forward to working with the transition team. I'll keep my comments brief because I really want to just thank the Board of Trustees and staff and the working group for hitting the pause button last year and really engaging stakeholders to discuss the future of the Access Commission. I think the process really brought a lot of viewpoints to light and came out with a unanimous recommendation to separate from the bar, which I do agree with. I was one of the ones who really went into the process hoping and expecting that we could figure out a way to have the Commission on Access to Justice stay with the bar. It has worked for more than 20 years, and I think everyone agreed and had lengthy discussions about the important work of the Access Commission and how it should continue. And I think the issues really were that we just couldn't come to agreement on a way to make it work with the new efforts for oversight and control. And so I'm very much looking forward to having the Access Commission continue to work with and collaborate with the bar, especially on the access initiatives and parts of the bar's mission. But I did really want to thank the bar for having the working group process, and I also wanted to indicate that there are several parts of the recommendation that I think Donna will get into in more detail, that each of the parts are really necessary, including the appointment. I'm actually one of the members that would be rolling off if not reappointed by the bar. So I think one of the problems is because appointments haven't happened, we don't have the commission members and leadership to work through the transition. But I'm also happy to stay around and answer any questions that the bar, that anyone might have about the process or the considerations that went into the process. But I do think it was a full discussion, and I think it came out unanimous or with one abstention, 7-0. So thank you very much.
Thank you. Does anyone have any questions for Amos? All right. Well, it's good seeing you again. And for the one session that I attended, it was a very collaborative process. And I do appreciate you coming forward today and providing your comments. Any additional public comment on the Access Commission? Seeing none? Donna?
Thank you. I assure you I only have one more time to present to you after this one. So as we were going through the Appendix I process, it really brought to the attention of the bar staff and members of the board that there were some unique features of the Access Commission that made it distinct from all of the other sub-entities. They operated with quite a bit of operational autonomy. The breadth of their work exceeded, in some ways, the scope of what we were trying to get at a little bit yesterday, sort of what the appropriate scope for the state bar's work in the Access arena would be. And as a result, there was a use of staff resources to do the work that was outside of the priorities of the board in this matter. And this was simply because this was the authority with which the board vested the Access Commission when they created it. But these differences really came to light, and when we came to you in September with the recommendations for all of the other sub-entities, this was one where we asked you to create a stakeholder working group so we could further discuss the issue with the Access community and the Access Commission. You did create that stakeholder working group. We held 3 meetings during which the working group reviewed the current structure and operations of the Access Commission, looked at the structure of other Access Commissions, and discussed options regarding the future structure. This is the only slide, so I'm good. As Amos said, this was and Jason, as you said, this was a collaborative process. And despite really our concerted efforts of many people on this stakeholder working group to identify ways to maintain the Access Commission at the state bar, ultimately the working group resigned itself to the fact that we had 2 overriding conflicting objectives. The state bar's objective as part of its governance reforms to ensure that the state bar, the board exercised appropriate oversight over the sub-entities, and the Access Commission's overriding objective that they really have an independent voice on access that is not impeded in any way by the agenda of any of its appointing authorities. And we tried to make those 2 conflicting objectives fit together, and ultimately, despite our respective respect for each other's primary objective, we couldn't make that work. And so as a result, the working group unanimously, as Amos mentioned, it recommended to the board, the separation of the Access Commission from the state bar by the end of this calendar year. Recommend that the state bar reappoint those state bar appointed members of the Access Commission, those were members of leadership as well as non-leadership positions on the commission who termed off after September 1st to restore the Access Commission to its prior size. Also, the working group unanimously recommended that the bar provide the necessary support to the Access Commission until the transition, and that the Access Commission be authorized to take reasonable efforts to effect the transition. We have, in hopes that the board would agree with these recommendations, formed a small transition team and had an introductory meeting of the transition team to talk about what that might look like. What we are talking about when we talked about at the stakeholder working group would be that a way to provide some continued state bar support to the Access Commission through in their new home, wherever that may be, through a deliverables-based agreement. In such an agreement, CCAJ would be potentially supporting the state bar development of its annual access objectives. I envision them providing recommendations in the fall annually to the programs committee, which they would review for presentation to the board the following January for new objectives in the strategic plan. We also would expect that the deliverables-based contract would require the Access Commission to provide support and potentially do the work on some of these objectives that are adopted, things that where the concerns of the Access Commission and the bar do overlap. And so with that, we have a motion. And that is the motion that the board adopt the recommendations from the Access Commission, from the stakeholder working group that were adopted by that working group at their final meeting on November 27th.
We have a motion from Joanna, seconded by Mark. Any further discussion, questions? Seeing none, any objection to substituting the roll call? So adopted. Thank you very much. The next matter is the Legal Services Trust Fund Commission. I am recused. Oh. Okay, belay that.
One of the things that Donna had mentioned is that a big part of what we're bringing before you today are decisions that had been made previously and which we are now drilling down on and providing the finer detail necessary to effectuate the decisions that were previously made. This is especially true of the rule proposals. And the way we've structured this item is that we have appendices with the red line of the proposed rule changes. We have summaries contained within the agenda item itself of what is contained, the most important things that are contained in those rule proposals. And then here, what I'm presenting is a summary of the summary for those of you who are not up on exactly what's contained in Title IV, Division 1 of the State Bar Rules, just to try to be really clear on what it is that we're looking at here. So you'll find the full strikeout red line version in the appendices again, but the key highlights that I wanted to point to here, starting with Title IV, Division 1, these are the rules that are related to the admission to practice law in California. And the issues that we really wanted to highlight here relate to the codification of board decisions, clarifying the respective roles of the Committee of Bar Examiners, bar staff, and the board in particular. And this is an issue that Donna may want to speak to separately, but in particular, one of the items that we wanted to highlight and then we broke out a separate resolution related to has to do with the decision that moral character informal conferences will be conducted by bar staff. Although this is contained within the red line version of the rule changes, it was called out separately in a resolution that was not contained in the board agenda item, but that is here today. It's going to be presented to you because we really wanted to be fully transparent about this decision. We wanted to make sure that nobody said, oh, well, you buried it in the rules. No, this was a very conscious decision that we made. We engaged in a lot of discussion about this issue, and we just wanted to make sure that it was called out separately. We could go to, we have each one of these as separate resolutions, so we might go to that resolution now and then go to the next title division chapter on fee arbitration.
Are all the resolutions grouped together so we can see it?
They are. They're one after the other.
Okay, so let's do it all at once.
Okay, and that's probably a good idea because Title III, Division 4, Chapter 2 on fee arbitration is the elimination of a single reference to the Committee on Mandatory Fee Arbitration. However, because that is the only reference to the Committee on Mandatory Fee Arbitration contained within State Bar rules, that is, in effect, eliminating the Committee on Mandatory Fee Arbitration as agreed to at the September meeting of the Board of Trustees. So the Committee on Mandatory Fee Arbitration will no longer exist once these rules are sent out for public comment, brought back to the Board of Trustees, and approved at that at a later meeting. I no longer trust the clicker. The other resolutions here then relate to Title III, Division 4, Chapter 1. This relates to the Client Security Fund. And the main things that we wanted to summarize with regard to these changes are the reduction of the size of the Client Security Fund Commission from 7 to 5. We're actually going with a slightly smaller commission in this case than the recommended 7 because we've scaled back on the responsibilities of the Client Security Fund Commission. And they're effectively hearing what would look like appeals of staff decisions. And then the remainder of the changes to the rules clarify the authority of CSF staff. And most significantly, these have to do with issuing of tentative decisions by staff. It would then be the appeals of these tentative decisions that would be heard by the Client Securities Fund Commission. Title 6, don't leave out Title 6. So Title 6 is when you look at the red line, we're going to fix this up in what gets posted when we submit it for public comment, but you'll note there's a lot of text that doesn't, it looks like it's unchanged. That is actually brand new text. If you go online to the State Bar rules, you'll see that there's a space for Title 6, Division 3, which it says reserved. And there's a little bit of red line that's contained within the document, which was actually internal changes that were made prior to this item being finalized. All of that text is new. Anything that's there is new. And these relate to conflict of interest policies for sub-entities. It applies a conflict of interest policy to the Committee of Bar Examiners, California Board of Legal Specialization, Commission on Access and Council on Access and Fairness, Client Securities Fund Commission, Lawyers Assistance Program Oversight Committee, California Commission on Access to Justice, Legal Services Trust Fund Commission, and COPRAC.
Question, since CCAJ is severing from the bar, will we still include them in this? And so no longer be a sub-entity?
Well, I think it applies to CCAJ until they separate. That separation is no later than December 31 of this year.
The gist of the conflict of interest policy is that it is based on statute and policy requiring disqualification for decisions that have a reasonably foreseeable material effect on the financial interests of members of these sub-entities, and also requiring disqualification for personal non-financial interest that prevents the members of the sub-entities from being disinterested or loyal to the bar. There is also a provision within these rules to promote efficient operation. The policy requires the elimination of conflict or the resignation of a member when that member is disqualified from 25% of the votes over a 3-month period. So that concludes my summary of the rule proposals. These are being sent out again for public comment, and will come back after a 45-day public comment period to the board again.
Any questions, comments?
Jason, do we need to allow public comment on the pieces that Dag just summarized? Maybe I missed that.
sorry. I conflated. I thought you meant you would need to send it out for public comment, but you want to know whether anyone has
Yeah,
public comment.
right now, yeah. I
Yes.
think on this piece, we haven't done that.
Okay. Does anyone have public comment on the proposed rules? All right, I don't see any. Thanks, Sean. Any further discussion?
Jason? Just so that they know that we were fully aware, the Committee of Bar Examiners thinks we've made an egregious error with respect to moral character and want us to reconsider our decision. And so I imagine if you vote against it, you will have indicated a reconsideration of our position on this. But raising it here, you know, in this respect, they'll know that we recognize that they don't like what we've done, so.
Thank you. Can I have a motion? Oh, Mark?
No. It's not. That commit,
The
CS
CS
bars,
bars.
I don't know why it was not included. They're not a decision-making body, they're an advisory body.
Well, would the rule apply to all of the sub-entities of the sub-entities? You know, they have subcommittees.
Conflict. Is Brady still here? Is Brady still here? Okay, why don't you come up?
I mean, another way to do it, just to make it a little more complicated, but perhaps more elegant, is to apply the conflicts rule to any decision-making sub-entity or affiliated sub-entities of the bar, rather than naming every single one, and then identifying those sub-entities in the board book or some other document. That way it continues to live and breathe, even though, you know, as sub-entities disappear or as they are created, everyone knows they're still bound by the conflicts of interest rules.
That would certainly match the intent. And in answer to Joanna's question, yes, it applies, and there's even some language about, for instance, when calculating the number of votes from which a heavily conflicted member was disqualified, it includes votes of subcommittees. So yes, it does cover subcommittees as well.
Do you have any thoughts, Brady, on the application of the policy to the former RAC, which is a subcommittee of the Committee of Bar Examiners?
Not off the top of my head, I don't.
Okay, so let's think, we can think about that. I think we can, I would suggest we still issue this for public comment, and during the comment period, staff address that issue and potentially come back with an amended rule based on the outcome.
The intent was certainly to cover sub-entities other than Jenny.
Right. Could we revise it to read something like, to establish a standard conflict of interest policy for all decision-making sub-entities with the exception of the Jenny Commission?
But I think one of the questions is exploring whether we wanted to extend to recommendatory entities also, unless the board wants to decide that today.
I think the concern there is the same because for advisory sub-entities also, because presumably you would like advice that's untarnished by conflict.
Right. No, I'm sorry. I would agree that it should apply to all sub-entities of the bar. I was just playing off the desire, I guess, the distinction about decision-making, but I'm comfortable with applying to all sub-entities. Yeah, except for Jenny. Jenny, the reason why you carve out Jenny is because Jenny has a statutory conflicts already built into the...
We discussed not delineating these sub-entities in the rule, and you had a rationale for doing so, Brady. Can you?
We thought that there could be some clarity added just because it would be useful to see in one place a list of the sub-entities, but as you raised, Jason, that might be covered somewhere in the board book or somewhere else. For instance, this was not intended to apply to ad hoc sort of working groups that are just established for a certain purpose and a limited function. For one example, ADLs, we intentionally chose people who have an interest.
Are very financially
because we want their expertise and their perspective, and that group was intentionally put together to have a balance of perspectives, some of which might be technically a conflict under this rule. So I think we would want to limit it to permanent sub-entities, I guess might be the term.
I think that was the concern, that sub-entity is not a clearly defined term.
Got it. How about all sub-entities identified? Don't write this.
Jason, can I jump in here? I apologize.
Oh, yeah,
I'm
go
like
for it.
jumping at the bit. So the language that we saw on the screen earlier, that when we were discussing the basis for these potential rule changes, sounds to me like it comes straight out of the Political Reform Act, right? And if that's the intent, then I think we need to be very careful about distinguishing between decision-making bodies or individuals, because the Political Reform Act applies to any body or governmental or any public official who makes a decision or influences the decision of the government, right? That's the statutory standard. And so we might just say for public officials of the state bar, the conflicts rules shall apply, or, you know what I mean? So I want to hear from Vanessa and or Brady about what the intent was.
I don't want to get too deep into the weeds, but part of the reason we need to speak, because the Public Records Act only applies to the bar insofar as we've imposed it on ourselves.
Political Reform Act.
Did I say?
Public Records Act.
Political Reform Act, yes. We're not, employees of the state bar, we're not public officials as defined by that act. The board has in its own conflict policy incorporated some decisions from, definitions from the Political Reform Act, such as the definition of financial interest and some of the schedules for valuation of gifts and so forth, but it doesn't apply directly.
In other words, we self-impose, we're not bound. So that's what this body is to do, to determine what the scope, the policy scope is for different levels of participants, if you will, at the bar.
Okay, that makes sense to me, but I think that indicates we need to have a deeper, broader conversation. Has this been at one of the committees?
Has the rule come up through a committee? No, this rule, the genesis for it is the Appendix I review, because we don't have such a rule. And so as such, we brought it back to the full board to authorize to circulate for public comment. That's all that we're asking to do today.
Ruben, if you want to extend, which I think is the intention, to extend the Political Reform Act decides or influences, makes or influences, we would say it applies to all decision-making and non-decision-making, or whatever, we can incorporate the term decision-making or influencing bodies.
I'm okay with that.
So if I may just mention the committee that we were just talking about, the CS bars, as well as the Law School Council, might have a problem with this test, as they are sort of necessarily self-interested. So I just want to put that before you to think about how this would apply to them.
I guess it comes down to what is influencing mean. You know, recommendatory, is that influencing? It doesn't, the recommendation doesn't have to be accepted. So clearly it needs to be thought out, but it could also, that can happen in the process of public comment. It can go, something can go out and see what they say, and we will further study it. And I'd appreciate your further thoughts, Ruben, because you do this.
Sean?
So Vanessa, I take it if we frame the proposal in this broader way, and then later after further study, we decide to add more exceptions, would that require public comment again, even though we're making it more narrow? So no matter what we do, if we change it materially, we're going to have to do
That's the
public
problem. It will
comment?
be a material change. Out for another 30 days.
Okay, and then, thank you. And then Brady is our Jenny accepted also? Is that considered part of Jenny for this purpose?
Yes.
So I wonder if we should specify that too.
We should.
I thought it was in the materials, but it's not in the resolution. It's in the rules, okay.
Well, the draft rule just covers the
It specifies which
enumerated entities.
Yeah. Could I
Just-
make the motion?
Oh, sorry, Sean
I
and
have,
Joanna.
Okay.
I have an idea, because I don't want to, the public comment process can make this become quite lengthy if we have to do it again. Can we send two, maybe we should consider, as we've done in the past, publishing for public comment, two versions. One would be the original, and the second would be this broader version, and that way we'd be in a position to adopt the original one for sure. And then if there's some nuances around sub-entities that weren't in the list, that might go out to further public comment, but at least we would have implemented the conflict of interest for most of the bar's sub-entities.
And I think that if we did that, it might be wise to leave CS bars out because of the concern that Donna raised.
Yeah, so
Out of
we
the
would-
enumerated version.
Yeah, so alternative one would be the original proposal as originally written.
Right.
Alternative two would be what's on the amended version on the screen. And I'll make a motion to so adopt.
What about the other one, the other public comment? There's like
But we have a couple, yeah, we're gonna group.
These are all grouped together. Yeah, this is part of the 5 paragraphs or whatever.
So you're doing a.
Yeah, move the whole package with these changes.
And then
yeah.
with the changes here.
Yeah.
All right, everyone understand what's on the table? All right,
It's all the rule proposals with the addition of alternative 2 for the conflict of interest policy.
Sarah, can we see the other resolution so everyone knows what we're voting on?
This is an implementation step that we discussed, that staff would work with the Office of General Counsel to effectuate the implementation of the conflict policy with respect to each sub-entity. I don't know that it actually required a resolution. It's not requesting anything to go out for comment. It's just an implementation step. And in fact, it's premature because right now we're just sending things out for comment. So
let's strike that.
Let's strike that particular resolution.
All right. So we have Sean's motion. Everyone now knows what we're voting on. Do we have a second? Joanna with a second. Can I substitute roll call? Right? No objection? Adopted? All right. So now we're on the Legal Services Trust Fund Commission. Thank you for your patience. I have a conflict and am recused from any substantive discussions concerning the Legal Services Trust Fund Commission, and have been since the entire process has been undertaken. So I'm going to turn this over to Alan, who will lead the discussion.
All right. We have a recommendation from the Legal Services Trust Fund Commission Stakeholder Process Working Group, and we have 9 recommendations, and we have a staff report that questions 3 of those recommendations. The way I'd like to proceed is as follows. I know there are some people who I believe want to make comments during the public comment period. I have, I believe, 4 on a list. Is there anybody who wants to comment on the Legal Services Trust Fund recommendations who has not signed up on this list? Okay, so I'm assuming that we have the 4 then. Before we go to public comment, I want to note that there were 2 members of the Board of Trustees on the working group. Debbie Manning was a co-chair, and Sean Selig was also on the group. I believe that Sean has a few comments to make, and Debbie may as well. I'm going to begin by having Sean make his comments, then ask Debbie if she has anything in addition, and then I will take the public comments, and then we will get the staff report. Okay? Sean.
Thank you, Alan. So I want to try to set the table for you. What is in front of you is the product of an extensive set of meetings, 6 meetings, 5 in person, well over 25 hours. And you'll be glad to know my comments are not going to take 25 hours. I've just tried to distill it down for you. But this is a very important topic, and so I'll have a fair bit to say about it. One of the most important part of our operations and our mission is to facilitate representation, legal services programs for the poor, and we do that by distributing IOLTA funds, equal access justice funds, and other funds, including the bank grants. It's our statutory duty to manage distribution of those funds, and by our duty, I mean the board. For many, many years, the board has relied on the Legal Services Trust Fund Commission, which the board created to carry out this function for us. But the board has really not been involved in the commission's decision-making and policy-making processes. And the working group has reached a consensus that some changes need to be made in this area, so the board is more attentive to this aspect of our duties and to make sure that legal services programs for the poor are funded as they ought to be and in the best possible fashion. So as you can see from the materials in front of you, the working group came to consensus on a number of important recommendations. The first being a package about the board's role here, that the board needs to be more involved in this area, needs to be more informed of how these funds are being distributed and what the rationale for that process is. The working group also had a consensus that really wasn't controversial, that the board needs to have final say on policy matters, and that the commission's role going forward will be to recommend policy to the board rather than operating as essentially as a freestanding entity, as it has for many years, and I will note, with the board's acquiescence. The second most important reform that the working group has recommended, in my opinion, is to change the current practice of the commission that involves certain procedures that I would say are informal or ad hoc. There was discussion during the working group meeting that the commission in some instances follows an oral tradition of guidelines and rules for considering grant applications. And there was also discussion of the commission looking at what they call sticky issues, which mean difficult policy judgments to be made about particular applications. And one of the recommendations is to change this by making it a more formal process, a more rule-driven process with written rules and guidelines approved by the recommended by the commission and approved by the board to enhance fairness and uniform application of these rules, and also transparency, so that everyone knows what the rules are going into the process, both the public and grantees. So these package of changes they're very significant, and in my opinion, they're very sound. And I'm glad to say that they're not controversial because the working group has recommended them to you, staff has recommended them to you, and I commend them to you as well. Another important set of both changes and simply documenting existing practices was what came to be known as the matrix, which is something that staff prepared, spent a lot of time on, and similar to our examination of other sub-entities, tries to go through in a very methodical way to document the division of labor or responsibility between staff and, in this case, the commission. The working group approved a portion of this matrix, a relatively small portion of the matrix, and that's included in their report to you. Staff has recommended the adoption of that matrix, as do I, but I do part from the working group recommendations on one aspect of this, which is whether to continue studying the remainder of the matrix, because and which I think should happen, and that will facilitate a more formalized, rule-bound process for the commission. And so I think that's something that we should not take the working group's recommendation on, to accept the status quo other than is in the small version of the matrix, but to continue studying that area. Now, there are at least two remaining items that will be subject to discussion by you, which really relate to whether certain matters should be the subject of more study. You're not asked to make a decision on them today, other than that review and study of these issues should continue. The first of these two areas is the size of the commission. The working group formally opposed any changes to the commission and would like the board to today make a final decision that the size of the board should remain the same. There are currently 24 positions on the commission, 3 of which are non-voting. It's a very large group, much, much larger than the default number of 7 the board has adopted, which, as we just saw earlier today, is not necessarily a rule for all seasons, but is a number that can vary by sub-entity. In this particular case, what I think we need as a board is a functional analysis of the commission's work, how it does its work, and how many people are needed to carry out that work in an effective fashion. So staff has recommended, and I agree, that we should conclude that the size of the commission should be subject to further study, and that the working group be reconvened to consider and work through the issues of this, what the appropriate size of the commission should be, and bring that back to the board in March. A related point is that the working group recommended that all of the existing vacancies on the commission be filled at this meeting. And I want to report to you that this was a cause of great upset and concern by many members of the working group. Debbie and I abstained from the vote on this particular topic because we thought it best to wait to take a position until we had the opportunity to deliberate among you and to get some more information. As you can see from Leah's report, staff recommends deferring appointments for these vacant positions until the March meeting, at which time the board will make a decision, I hope, about the size of the commission. We will then know how many vacancies there are, and XCOM will be in a position to fill those vacancies. Leah has convinced me that this is the right way to go with a factual, on a factual basis. It's in her report, and I'm going to defer to her to explain that herself when the time comes. The second area of, I would say, controversy about whether matters should be studied in the future is whether funds are being distributed in a way that corresponds with geographic and demographic equity. So one of the things we were presented by staff with in the working group process was some very rough statistics that suggest the Latino population might be underserved, as are rural areas. There was criticism of these statistics for various reasons. Let me give you an example of one of the criticisms. One was that if you have a Latino client of one of the grantee organizations that is assisted with a housing problem, in eviction, et cetera, and that client is successfully maintained in housing, that affects the entire family. So that could affect not just one person, but 4 people, 5 people, whatever. So there are some real issues raised with the statistics. The issue is whether to do further study to see if we can get data that is more telling, more reliable, and would suggest policy changes. There was no formal finding by the working group on this area because there was an objection, sort of a procedural objection, to considering it in the working group's final phone call, which was a meeting. I don't really think we need a recommendation from the working group to think that this is an area that should be studied. It's important. We have a fiduciary duty over how these funds are handled and distributed. And there's no reason, in my view, that it should be controversial to merely study an issue like this and see what more can be found out about it. Another area of consensus was not to pursue statutory changes at this time, but I think it's something the board needs to be informed of so you can make your own informed decision. There were at least a couple of areas where I would say there was consensus in informal discussion, or at least serious, or something resembling a consensus, that certain aspects of the statute might be reconsidered. And I think most importantly is the use of the federal poverty level as a measure of which organizations are eligible for grants. There's a lot of concern that that figure is too low given the high standard of living in California, and then it should be 175% of that figure, 200%. There are even pro bono organizations that go up to 300 or 500% in California and in other high expense areas. The second area was that, as the statute is currently written, the service population for these funds, which is really principally supposed to be indigent persons, however you define that, as I just alluded to, there's an issue there, is also older clients. Certain older adults are allowed to access these services with no means testing whatsoever. The discussion during the working group led me to believe that this probably is not a substantial problem, that there probably are not a substantial number of clients accessing these services who have substantial means, but we don't really know for sure. There is a concern about opening a Pandora's box by pursuing legislative changes at this time, because as everyone knows, that's a complicated process, the outcome of which is never certain. And so I'm prepared to defer to the consensus of the commission members and the grantee organizations, including public commenters who came to the working group, that we should adopt the working group's recommendation not to pursue statutory changes. Let me sum up. One thing in summary, I do want to give you a flavor of this. I mentioned that there was some upset in the working group about certain issues, and there was a lot of passion around this. We are looking at significant changes to an entity that has operated with, as far as I can tell, virtually no supervision or oversight by the board for many, many years. That is a major change that has caused concern and upset among a number of members of the working group and some of the people we heard from the public. Notwithstanding that, I think there are important reasons that the board should improve its performance in this area, become more involved. And I am hoping that we can work with the commission members and the grantee community to a point where this will be a process that everyone is comfortable with, and that we can be ensured that the board is carrying out its duty to manage the distribution of these funds. So that's really all I have to say. After we hear public comment and comments from others, and Alan is ready to entertain motions, I will move to adopt the staff recommendation as I've just summarized.
Thank you, Sean. Debbie?
Yes, I do have just a few comments, and thank you, Sean, for your report. What I wanted to say is, as co-chair, I want to take the time to thank everyone who participated in the Legal Services Trust Fund Commission Working Group. I'll say that 4 times fast. Starting with my co-chair, Rich Reines, who I believe is in the audience, with his extensive knowledge of the commission and its work. Each person on the working group had something to contribute and add to the discussion. I want to acknowledge the work of the bar staff. Their professionalism was appreciated and invaluable to the process. Thank you to witnesses and speakers. Speaking for the bar, I want to recognize the time commitment of each task force member. I realize such commitment is disruptive to your regular life. Your dedication to serving the people of California is commendable. Again, I just want to thank you all.
All right. We will now go into public comment, and I don't know among the people who would like to speak on the Legal Services Trust Fund Commission issue, whether you've chosen someone to begin or whether I should just go in order of the signups. Mr. Reynes, you are going to lead off. Welcome.
I didn't volunteer to lead off. I was forced into this position.
Well, so much in life occurs that way, doesn't it? I'd like to ask you to see if you can limit your comments to 3 minutes, and I will wave my hand or otherwise interrupt you if you start to run over. And for anyone else who talks after that, we are getting late in the afternoon. I just appreciate it if we didn't repeat points already made and limited ourselves to original content, if you will. Thank you very much.
I'll do my best. When the IOLTA legislation was passed in 1982, the legislature identified the state bar as the appropriate conduit for those funds to flow through. And over the years, millions of dollars have come out of the IOLTA program to legal service providers and through them to great services for California's needy. In 2019, as I reported to you in September, our grants amount to $60 million. If you put that in terms of private foundations, which is one of the worlds in which I operate, you'd have to have a corpus of $1,200,000,000 to make an equivalent gift. A private foundation with a corpus of $1,200,000 would have an enormous staff and dedicated board members in the grant-making process. I'm pointing this out to you because it focuses, I hope it will help you focus on the issue of the size of the commission, which is one of the very contentious issues that we discussed. And I think you also are very much where you ought to be of the very complex system of statutory state bar rules and guidelines that are utilized in the grant-making process. This is complex for a reason. Unlike a private foundation, you're dealing with the public's money. And that, to me, causes there to be a heightened level of scrutiny as to what has to occur. And the rules that are in place, statutory and otherwise, are complex for a reason. They are there to see to it that the funds are distributed as they were intended to be distributed. And they're carefully thought out. The layers that have been developed over 37 years aren't there by happenstance. The intent is to be certain that the funds are used for their intended purpose, and it isn't easy. The result of this statutory scheme is that there are sticky issues, I think Sean used that term, but I couldn't quite hear in the back of the room, that the commission is asked to resolve frequently. I'll get to that in more detail later on. But I want you to understand that to navigate through this system requires a great deal of experience. And that experience is on both the side of the grantor and the grantee. The mechanism of dealing with the state's money, people's money, into the hands of legal service providers is self-funded. The self-funding aspect of the Legal Services Trust Fund Commission and the process through which it goes is something that isn't mentioned in Appendix I. And I think it differentiates this particular sub-entity from other sub-entities. Now, I want to talk to you about Appendix I as we go through this, but you understand that no final conclusions were reached about the Legal Services Trust Fund Commission because there's been a considerable amount of pushback, and I think that Debbie and Sean and I will attest to the fact that there was a great deal of passion expressed by not only the public who came forward with very important commentary, but from the commission, the working group members as well. The working group members, if you look at the list of people who are attached to the report materials, are experts in the legal services field. These are not simply stakeholders. The people who are on the working commission possess a tremendous amount of expertise. Those experts whose years of experience with this program concluded 9 points that Sean discussed and are listed for you in the materials that you have in front of you. In all, there were 15 voting members. And those 15 voting members overwhelmingly supported all 9 of the recommendations in front of you. 3 of them have become controversial. From the outset of our work as working group members, a relatively benign debate began. Some expressed the view that the working group was assembled as a solution in search of a problem. After all, 37 years dispensing millions of dollars to over 100 grantees has resulted in the delivery of legal services to the poor without incident. So it's working. What's the problem? The answer to that, which was astute, I thought, was what's wrong with examining the system to see if we can improve it? And both parties were right. Unfortunately, that debate devolved in a way that was unpleasant, and it's certainly worthy of pursuit to think about change. But in the devolving of this debate, members of the public raised other issues about money. First issue is an easy one, and it's addressed in point number 9 of the recommendations made in the report. And that is there isn't enough money to go around. There should be no debate about that. Whatever the State Bar can do to increase the amount of money that is ultimately delivered through the IALTA program should be done. But the second question was very troubling, and that was this working group process some sort of an undisclosed agenda whereby the State Bar had the intent of repurposing IALTA money? And that raised a great deal of passion and was immediately discounted. The assurances that came to us from members of the State Bar were vehement. So in the process of doing this, the level of tension increased substantially. But I want you to understand that in the end, all of us came to certain agreement, and that agreement was overwhelming that the 9 points in front of you be adopted. Ultimately, what these 9 points demonstrate is that the status quo should not be upended without a showing of some significant need, and that the Commission serves a useful purpose that cannot be served either by the staff or the Board of Trustees. Now, in your staff management report, there's a recommendation as to items number 3, 4, and 5, and I want to address those. Were you to follow that staff management report as to these 3 items, it would be in opposition to the overwhelming majority of votes of experts on this topic. I want to focus on these 3. The working group and you have been presented with a staff management matrix of functions. When it was originally presented to the working group, it caught us by surprise, and it was the subject of some debate. I personally disagreed with the entries that were made in some of the columns that are in the matrix you'll be studying. But putting aside differences as to what functions are performed by which of the 3 bodies that are of interest here, the matrix formed the basis of a great deal of discussion, and we followed that carefully on at least 2 occasions in our 6 meetings. The idea of this is to search for opportunities for improvement, and the result of that was to preserve the status quo, except as the matrix attached as Exhibit A to the working group report demonstrates. We'll return to the matrix in just a minute. Early in our 6 meetings, Sean made a point which was reiterated today, that the issue before the board is one of fiduciary duty. In fact, you have a fiduciary duty to see to it that the funds are used for their intended purpose, and the separation of the board from the grant-making process over the years has been more than acquiescence. It's been an unfortunate development that needs addressing. There wasn't any debate about this issue whatsoever amongst the working group members. The board needs to be more informed. One of the things that I tried to insert into these discussions and into the final report, which was rejected, was the notion that it's not simply the staff's responsibility or the commission's responsibility to keep the board more informed. It is also the board's responsibility to become more active and to attend the meetings and to ask more important questions. But there is no debate about this. The board needs to be better informed in order to exercise properly its fiduciary duty. There was a suggestion by staff management, however, to make more significant changes in the dispersion of responsibility away from the commission to staff. This resulted in a debate that moving greater responsibility to staff would reduce oversight. That oversight is provided by the commission. It's oversight work that has been delegated over 37 years to 21 members of the commission and 3 non-voting members. That delegation can use improvement, but you cannot dispense with it. If you were to do so, it seems to me it is completely antithetical to the notion that you have a fiduciary duty with respect to the public's money and how it's dispersed for this purpose. Giving greater autonomy to staff simply puts the grantee much closer in proximity to the staff, and that raises the risks of anomalous behavior. And I want to touch on that in a few minutes. I think you have been presented by Sean and by the staff with recommendations that items 1 and 2 and 6 and 9 are going to be supported by staff. So I won't get into those. Now let's discuss the size of the commission. This is related to the matrix discussion, as the notion of shifting responsibility from commission to staff might mean reduction in the functions of the commission and an opportunity to shrink its size. The issue of size is one you should consider in light of these 4 points. First, it was raised in Appendix I, the issue of size, where a statement is made as to the optimal size of a sub-entity. The support for that statement came under scrutiny and did not survive review by most of the members of the working group. I suggest that you read the report which exposes the weaknesses of that argument that was submitted by Professor James Meeker, who was a special advisor to the working group. I know that's been distributed to you now. You will also note that almost every other IOLTA program in the United States uses a similarly sized body to the Legal Services Trust Fund Commission to oversee grant making, and California is one of the largest states when it comes to grant making. We make a tremendous amount, $60 million of grants to over 100 different bodies. Secondly, the volunteers who work on the commission devote many hours to its tasks. The staff management report makes reference to absences, but the absences it refers to are the full commission meetings, not the subcommittee meetings, which is where the heart of the work occurs. Were you to reduce the size of the commission, you would be asking the remaining members of the commission to take on more work. These are volunteers. We're lucky to have them. They do tremendous work. To ask them to take on greater functions is unfair, in my view. If you were to downsize it to what is allegedly an optimal number of 7, you would render it ineffective. It would be tantamount to terminating the functioning of the commission. Third, there's no cost issue here. This is a self-funded program, so you're not going to be saving the State Bar any money by reducing the size of the commission. And if you do, it's minimal. And lastly, there are 21 voting members of the commission. This number allows lawyers, judges, judicial administrators, non-lawyers, bankers, representatives of rural and urban communities, academics, and most importantly, clients to serve on that commission. If you were to reduce the size of the commission, it would reduce diversity on the commission. I don't think there's a possibility of reducing it without reducing diversity. For these and other reasons, the working group concluded overwhelmingly that evidence did not support downsizing of the commission. This is the issue raised in working group item number 4, challenged by staff. As to the questions of item 5, the OGC representative on the working group opined that the State Bar rules, which require the commission to be of its present size, do not require vacancies to be filled at any particular time. In other words, that opinion would support a pocket veto of commission size. All you have to do is sit on filling the vacancies, and you have tantamount rule that the commission should be reduced in size. I suggest that this is a backroom type of decision-making that's unworthy of your consideration and certainly does not embrace the notion of transparency. In an effort to support the downsizing proposition, staff management presented as an example the Minnesota program. This is a program where there is a statutory oligopoly of grantees. In other words, their commission must grant money to a certain number of and specified recipients. That is not at all what our program does. And in my judgment, the Minnesota program was hardly applicable to what we were doing. And you should note that the way funds are granted in the state of California allows us to deal, and our grant recipients to deal, with unanticipated needs of the poor. In particular, things like immigration problems, wildfire problems, homelessness. These are issues that come and go, and we have the flexibility that doesn't exist in the Minnesota program. And I want to hit on a final point here before I conclude. The state bar was politely accused of having a monetary agenda in the proceedings. That was defended, as I mentioned before, with a remark about the bar's fiduciary duty. And there is a duty, to be certain. The trustees are entrusted with the people's money. The distribution of that money requires oversight, prudence, vigilance, and adequate information to exercise these obligations. In 2018, one of those 75 annual recipients of our funds, and you'll see in your material that it's been pointed out that a significant percentage of the annual distribution goes to the same grantees every year. Only a small percentage goes to other grantees. Well, in 2018, one of those 75 annual recipients advised the staff that it had made material accounting mistakes, and it agreed to repay the bar for monies it should never have received. By receiving those funds, it deprived other worthy grantees of the use of those funds for delivery of services to the poor. These issues don't occur once in a blue moon, they occur frequently. Staff alerted the legal service provider that had committed these accounting mistakes about the irregularities and brought it to the attention of the commission. The reaction was the appropriate reaction for an oversight body. The commission ordered that action be taken immediately to remedy the problem and asked staff the tough question that you're probably asking yourself now. Why didn't the staff catch the accounting mistakes before the monies were distributed? That is the sort of oversight the board can't provide. So the commission's existence is vitally important to the distribution of funds, even to 75 regular recipients. If one incident occurs, you understand how tentative the legal service program and the IALTA program may be. It is subject to abuse. The oversight function is vitally important. When you look at the matrix, the question that you'll be asked is, can we move responsibilities from commission to the left, to staff, or from the commission to the right, to the Board of Trustees? The purpose of that inquiry is to come up with a means by which the commission can be downsized. I've already, I think, advised you my view of and the view of the experts on the working group as to why you should not reduce the size of the commission. But I want to emphasize to you that if you were to do that in a way that hampered the work of the commission, instead of exercising fiduciary duty, you'd be abandoning it. We don't want to see any issues raised in terms of misuse of these funds. Oversight is vitally important. I urge you to keep your eye on what has been a terrific program for 37 years and the delivery of services to California's poor. That terrific program is the prize. If you adopt the commission's, the staff recommendation not to support items 3, 4, and 5, I suggest to you that you put at risk the oversight function that's performed by the commission. And when you put that at risk, you put the IALTA program at risk. I'm happy to answer any questions.
Thank you. Any questions for Mr. Reynes? Well, I want to thank you for all of the time and work you put in as a co-chair of the working group. I know it's a lot of time, and this was a very important exercise, so we thank you very much.
Thank you.
Is there anyone else who would like to speak on this? I'm sure you will all note that I did allow Mr. Anus to complete his remarks because I thought it was important that we get a complete and comprehensive overview on behalf of the other members of the working group. So, but now I'd like to return to the 3-minute. Okay.
Mine will be shorter, don't worry. And in fact, in light of the late hour and all of Rich's comments, for the most part, I'll just say me too. So I'm Selena Copeland, the Executive Director of the Legal Aid Association of California. And like Rich, I also served on the working group. And very briefly, thank you so much to the Board of Trustees for, as Amos put it earlier, putting everything on pause to actually take time to establish a working group and take public comment. I thought that process actually worked really well. I just want to talk very briefly on one of the points that are actually a disagreement is, again, Rich said, the size of the Trust Fund Commission, and offer perhaps a suggestion. My main concern with the size of the commission being shrunk at this point in time is that we only have one client-eligible representative on the Legal Services Trust Fund Commission, with the shrink from 21 to 14 voting members. And unfortunately, to the death of a sitting Legal Services Trust Fund Commissioner last year, we only have one client-eligible member. And although he's very active, I think it's perhaps unfair to assume that he will attend every single committee meeting or subcommittee meeting and every single commission meeting. So in effect, if he's unable to make any of these meetings, there's no one in the room who actually comes from the eligible population that these funds are meant to serve. So I know that everything is put on pause in terms of considering those vacancies, but I would urge you to consider, at a minimum, perhaps opening up opportunity for appointment for that one public member position, and in fact also encourage you to open up the appointment process so that you could have nominations ready to go. If the efficiency report actually is submitted to you all in March, I would love for you to be able to have for your own nomination and appointments committee a candidate pool ready to appoint in March, so we don't have to again wait until the next Board of Trustees meeting and open it up for further time for good candidates. So thank you so much for your time.
Thank you, Sarah. Any questions for Ms. Copeland? Is there anyone else who would like to speak on behalf of the Legal Services Trust Fund issue?
Hi, my name is Lauren Klein. I'm also with the Legal Aid Association of California, though I was not a member of the working group. I am LAC's directing attorney, and in my role, I regularly communicate with and educate and coordinate legal aid organizations throughout the state, and I played that role during this working group process as well. So I just wanted to briefly comment not on the substance of the recommendations that are before you, but rather on the legal aid community's engagement with the stakeholder input process. I made sure that the entire legal aid community was informed about what was going on with the process and able to consider the implications of the various proposals that were made, including those that maybe they were not as excited about, and made sure they were aware of all of their opportunities for input. And representatives from numerous organizations responded by fully engaging with the working group. They reviewed and analyzed voluminous materials, attended all of the working group meetings, provided extensive public comment, and responded directly to questions and requests for information from the working group itself. So I essentially just want to tell you from my firsthand experience that the recommendations presented to you by the working group are a result of a thorough stakeholder input process. They were carefully considered, and they truly do represent a consensus, not just of legal aid organizations, but of the whole community. So I would urge you to adopt the recommendations of the working group. Thank you.
Thank you, Lauren. Any questions for Ms. Klein? Thank you. Anyone else? Mr. Lash.
Thank you, everybody. My name is David Lash. I have been in and around the Legal Services Trust Fund Commission for about the last 25 years. So I come to you today wearing several different hats with several different perspectives. One is that for many years I was the executive director at one of the largest IOLTA grant recipients in the state. Later on, when I returned to private practice, I served as a member of the Trust Fund Commission, and after that, I served for 3 years as the co-chair of the Trust Fund Commission. So I've seen the Trust Fund Commission work from all of these different angles, and the role it plays in the delivery of legal services to the poor is absolutely critical. And I had, as both a recipient and a member of the Trust Fund Commission, the opportunity to work very closely with the staff over those 25 years. And that relationship between the commission and the staff has always been excellent. There's a real symbiotic relationship, and there have been instances, admittedly few, but absolutely crucial instances, where the commission deviated from the recommendations of the staff based on the commission's unique, diverse expertise and perspective. And that happened in just a couple of very critical instances. So when I first learned that there was going to be a recommendation to the board that the Trust Fund Commission be eliminated, I was extremely heartened when the decision was to embark on this working group process and to examine the effectiveness of the Trust Fund Commission before taking any action. And I have to say that I attended several of the meetings, I listened in to several more, and the process was excellent. It was very, very thorough. It was deliberate. It was careful. It was informed by thoughtful public comment from a wide variety of stakeholders and interested parties and experts. Good questions were posed. There were helpful and good and thorough exchanges. There was a wide swath of input. And what resulted from this really excellent process was a very well-informed decision and a series of recommendations that were detailed, that were the result of detailed discussion and examination and expert analysis, and it covered very many important topics. One of the key decisions that was made, and I think the working group unanimously agreed, was the critical important role that the Legal Services Trust Fund Commission plays in the delivery of legal aid to the poor. It's literally life-saving services, and the role of the commission was evidenced by a parade of witnesses and testimony and evidence about its important role.
David, about 1 minute.
Okay, so the result of that excellent process was 9 recommendations. And as a lawyer, forgive me for this, but as a lawyer, I look to the evidence. And the evidence that the working group voted on was overwhelming. And in fact, in many of the instances, there was no contrary evidence testified to or delivered or even suggested that would undermine any of these 9 recommendations. The vote was fair, it followed great deliberation, and it was overwhelming. And so if we look at the big picture, it was a very excellent process that led naturally to several important conclusions, and I think that that excellent process and those excellent conclusions need to be respected. That was what the community testified to. It was what the evidence presented. It was what the working group overwhelmingly concluded, and I would just ask that this body have honor and respect the process and the people involved in it and the evidence that was presented, and respect the overwhelming vote of the working group and all of the fantastic work that was done. So thank you.
Thank you. Any questions for Mr. Lash? Thank you, David. All right. Public comment is closed unless there is anyone, and I don't think there is, joining us on the telephone. Is there anyone in the ether who has any comments? All right, then the public comment portion is closed, and I would like to get the staff report from Ms. Wilson.
So I'm going to speed through anything that's not directly related to the divergence between the stakeholder working group report and staff recommendations. This slide here gives a bit of background and context. Again, the review of the Trust Fund Commission was initiated as part of the overall Appendix I sub-entity review. Initially, staff was going to bring forward a recommendation to the board to eliminate the Legal Services Trust Fund Commission. Under that structure, all policy decisions would be made by the board and staff would implement policy. And that initial recommendation really was with the recognition of the importance of our grant-making function central to our mission, and my strong belief that the board should have policy oversight for such a critical piece of our work. However, that recommendation was not pursued, and instead the stakeholder working group process was established. It is important to note that the working group itself was comprised primarily of commission members and existing grantees. In contrast, again, to provide some context for the board did act on 5 sub-entities at its meeting in September of 2018. And I say this just to remind you of the range of actions that you've taken previously. You voted to eliminate the Committee on Mandatory Fee Arbitration. You voted to significantly restructure the responsibilities of staff, the Committee of Bar Examiners, and the board, another sub-entity separately and independently funded from our general fund. You took many of these actions in opposition to the desires or the interests of existing sub-entity members, but you made those decisions because they were in the best interest of the board. In each instance, the sub-entity was afforded the opportunity to provide input. Staff also submitted a recommendation, and the board acted. Also in September, you adopted global recommendations applicable to all sub-entities, and we've discussed implementing rules as related to some of those earlier this afternoon. So with respect to the Trust Fund Commission Stakeholder Working Group process, there were 6 meetings, as has been mentioned earlier. We addressed 3 broad main areas. One, the IOLTA statute itself. The other, non-statutory allocation and grant administration issues. And the third, governance. With respect to the statutory formula, and as Sean indicated, there are a number of issues there. I attempted to very briefly outline some of them in my staff report because I do feel a responsibility to make sure that the board is informed fully, both of the conversations that were had by the working group and of the serious policy issues that are implicated by the statute and the fact that it has not been modified since it was adopted. However, no statutory changes are recommended at this time, and I'm not recommending that we pursue that now. In addition, as Sean mentioned, there were significant non-statutory issues that were raised during the course of the working group process. One of those, again, as referenced by Sean, has to do with the potential that there are ethnic disparities in terms of the distribution of the dollars and the clients that are served. This issue was greatly contested by many members of the working group. And, as Sean indicates, it's something I feel strongly that it's important for the board to know that the issue was raised. However, you can see in my own staff recommendation, I am not recommending that the board take action on that issue at this time. So that leaves us with governance. The recommendation to eliminate the Trust Fund Commission was never vetted by the working group, and it really has been taken off the table since July of last year. Instead, we reached consensus on a number of issues, including the fact that the board is responsible for and will set policy. We will eliminate the practice of unwritten and informal policies and guidelines covering or in this very important area of our grant-making work. As you've heard through public comment, disparate views remain regarding the size of the Trust Fund Commission and the need to fill current vacancies. I want to talk a little bit about size and make clear that it's clear what it is that I'm recommending. I'm not recommending that the Trust Fund Commission be reduced. I'm simply recommending that the board take no action regarding size or appointments until the March board meeting. Selena's comments are precisely in line with what I intend to do, ensure that we have an applicant pool ready to go for March should the board take action to continue to have a 21-person sub-entity. In addition, that outreach will include specific efforts to identify potential members who meet the indigency standards as outlined in the current rule. So I fully intended to take the approach that Selena outlined so that based on the board's action in March, additional appointments could be made. With that in mind, the basis for my recommendation to not take any action on size at this meeting is that the board has adopted a default sub-entity size of 7. The board has determined that sizes greater than or less than 7 should be based on a functional review. And I emphasize a functional review is one that is based on an understanding of the work of the sub-entity and the amount of time that is required for members of that sub-entity. A functional review should not be based on politics or averages. The functional review that we speak of with respect to the Trust Fund Commission has only just occurred as part of the working group process, and it's really manifest in the matrix that you've heard several folks speak about. And I think, Sean, I'd just make a slight correction to your comments. The matrix that is attached to the working group report does comprise consensus agreement about the delineation of responsibilities between staff, the sub-entity, and the board. And there are really only 3 areas for which consensus was not reached. And so my recommendation with respect to this issue is simply for the board to direct staff to work with the commission to finalize the matrix and resolve the distribution of work between staff, the sub-entity, and the board with respect to only those 3 outstanding issues. In terms of the commission, as you've heard, 21 voting members, 3 non-voting members, 7 current vacancies. Additional considerations for the board to have as it thinks about whether or not to approve staff's recommendation. Staff who work directly with the commission have given me a calendar of the activities of the commission. The commission typically does not meet between November and April. This year, there's a meeting on Monday, primarily designed to discuss the Appendix I issues. The bank grant meeting, the bank grant process is the set of activities that will initiate the commission's work for 2019. That work will really begin once the RFP for the bank grants is issued. The board will be asked to approve that RFP at its March meeting. So there is no way that there will be any activity based on responses to that RFP prior to the board's March meeting. In addition, the bulk of the work associated with the commission's work is associated with the partnership grants. And the partnership grant cycle does not begin until August. So in sum, making a decision regarding the size of the commission, filling any vacancies, will not impact the work of the commission, it will not impact grantees, and most importantly, it will not impact the poor and low-income Californians who benefit from state bar grant dollars. So that's it. We could put up my recommended resolution and take discussion.
Yes. Okay, does everybody have a chance to look at the proposed resolution? All right.
I guess on this question of size, one thing that would be helpful if we come back in March, I understand we set 7 as a sub-entity number. I'm not exactly sure how we arrived at 7. Not sure that there has to be a one size fits all either. That seems somewhat arbitrary. I understand the argument for smaller versus larger. 21 feels like a lot of people. Having said that, this matrix doesn't really, I can see that there's a certain number of activities, and maybe Sean and Debbie, you have a little bit more color from this from being on the committee. I can see there's a lot of activities, but it's a little hard to get a sense of the volume of what's entailed by them, right? Just saying like, oh, here's the matrix doesn't really get me to like it's 7 or it's 21 or it's 50. So what can we do to get a little bit better sense of the volume and understand why the current group feels so strongly about the need for 21 versus staff's opinion for 7?
So before you answer, I just want to say one of the things that I asked staff, the staff that actually staff the commission, not at the executive office level, to do was to delineate, based on this functional review, the work of the commission. And what they've done, and it's posted to the commission meeting agenda for Monday, is to create just one spreadsheet with each of the commission subcommittees, the number of meetings that those subcommittees have annually, the estimated amount of preparation time necessary for each of the subcommittees, the number of the hours of actual meeting time annually for each of the subcommittees. So they laid that out for each of the 3 subcommittees of the Trust Fund Commission, as well as the commission as a whole. So that's posted for Monday's agenda. This will be an opportunity for the Trust Fund Commission to review that, to say, no, this is right or this is wrong, this is not how much time we spend. I also asked staff to give their thoughts as to the types of experiences that they thought important for commission members to bring to the table. The commission will also review that on Monday. This is staff's perspective on, we need practitioners with this type of experience, or we need folks who have this kind of relevant background. So the commission will review that on Monday. The working group is going to be reconvened to also review that. So that's the kind of information that ultimately helps you arrive at an actual number. The functional analysis feeds into that, and then you have it laid out in terms of this is how much time that translates into for each subcommittee and for the commission as a whole. That work will begin on Monday. And again, there is a document posted for Monday's meeting that begins to outline that.
Okay, thanks. I just want to make sure we have that and have what I think we need to be able to make an informed decision as opposed to an emotional decision.
Sean?
Yeah, and let me just, Leah has said it better than I can, but that's why I agree with you, Renee, we don't have the factual evidence in front of us. We would need to make that decision, and there were a lot of opinions expressed at the working group, and very strongly held opinions, but not really, in my view, not sufficient facts to really judge this. Let me just offer a couple of other comments. I'm not going to respond to everything. Rich said a number of things that I don't agree with, but I want to point out a couple of high-level things to the board, which is that the commission's oversight role that Rich talked about is not really being changed, in the sense that there was consensus that when staff processes these applications and puts them in front of the commission, there are some that are to which the commission is alerted to pay special attention, and on a regular agenda. Then there's something similar to a consent agenda, and they look through those as well. And if someone wants to pull it off for discussion because they see an issue, problem, whatever, they can do that. We're not proposing to change that process. We are proposing, and the working group agreed, that these informal ad hoc sort of procedures should be codified into written rules. I think ultimately that will reduce the commission's workload, but as circling back, we don't have really the kind of factual evidence we need about the actual workload as it exists today.
Other comments or questions? If not, the acting chair will entertain a motion.
I will move adoption of the staff recommendation.
Okay, moved by Sean, seconded by Debbie. Is there any further comment?
Leah, I don't think that last paragraph on the screen is part of your recommendation, is it?
Number 9?
No, I think because the matrix should be subject to further study.
It should say that staff is directed to work with the commission. I'm not sure what happened with that language. Yeah, so it should say that staff is directed to work with the commission to finalize. Can we vote? Can you vote on all the others, and I will see if I have the correct resolution already written up.
Sure.
I thought that I did.
So the motion is to adopt all of the recommendations 1 through 9, with the exception of 3 through 5. So 1, 2, 6, 7, 8, 9, and the following language further resolved, but not the last paragraph, which is being researched at the moment. Is there any discussion at this point? Is there any objection to substituting the role? Hearing none, the motion is.
Do we need to note Jason's recusing himself?
Oh, yeah.
Oh, that's probably true. All right, thank you. Let's call the roll then.
Broughton,
Yes.
Chen, Dellen,
Yes.
Duran,
Yes.
LeBron, Manning,
Yes.
Mendoza, Bertula,
Yes.
Selig,
Yes.
Stallings.
Thank you, Joanna. All right, do we have anything further on that last paragraph?
We do.
So get rid of this. Get
So
rid of
we
this.
can say, no, don't get
No,
rid of all of
okay.
it. So the Board of Trustees adopts the following staff recommendation. Adopt the matrix approved as, provided as attachment A to the working group report.
Let me see. Here it is.
And then an and here. Direct staff and the LSTFC
I'm sorry.
and the LSTFC to work together to finalize proposed rules of staff, comma, the LSTFC, comma, and the board with respect to those functional areas of the matrix for which consensus was not reached. And we can delete further. Yeah.
It needs a little cleaning. Yeah, there's a.
Alan, when we're done with voting on this, I'll have one more thing to say.
All right.
Be very brief.
All right, we need a motion. Debbie moves. Oh, Sonia, second. Okay. Is there any further discussion? Having excluded Sean that first time around, I think I can. No?
Jason.
I mean, Sean. Jason. right? I can
Yes,
substitute the rule.
yes.
Is there any objection to substituting the rule? It's adopted. Okay, Sean, you had another item?
I don't, this is not something we need to vote on, but I just want to clarify. So Leah didn't put in front of us a specific proposal about the equity issues that I mentioned, but I don't believe the board's action today is intended to rule that out in the future. Maybe something that requires more study.
All right, so we have one more resolution, we believe, on moral character. Donna, do you want to come up quickly and present that?
Yeah. Yeah, just one more.
Okay.
Here it is.
Yeah, it's just one more. All right.
Donna.
Thank you. So as Joanna mentioned earlier, at the December meeting of the Committee of Bar Examiners, the committee, by a vote of, I don't have my paper in front of me, but 14-1 with one abstention, I think, voted to respectfully request the board to reconsider the decision that it made at the September 2018 meeting, in which the board acted to transition the informal conferences that are conducted of moral character applicants from the committee to staff. The committee requested that that function be returned to the Committee of Bar Examiners and taken back from staff. Staff believes that that was the appropriate division of labor. It's consistent with the approach that we really have taken throughout all of Appendix I, which is to elevate the work of the committees and commissions, the sub-entities, to more policy-level work. They set the policy, what are the guidelines for determining requisite moral character, and then staff administers that. Staff make virtually all of the determinations on moral character right now. There were, I think, 182 informal conferences last year out of 6,000 applications. So it's so it's only those 182 that were currently going to the committee. Those were obviously the ones with sort of the most concern, or anywhere we were going to deny the moral character. But we believe that staff is the appropriate place to house that decision making, and that there would be greater consistency in that decision making if that's performed by staff. So staff asked the board to confirm the action that you already took in September. We thought that it was important, because the committee did take a formal motion on that, to bring this to your attention and have you take an affirmative action to confirm, if that is your will, to confirm the action that you took in September to transition the moral character work to staff, the informal conferences to staff.
Sean?
I mean, it's very appropriate for you to bring this to our attention, and I appreciate the concerns. I believe we voted on this already today by voting on item 702.
On the rule.
So I don't, unless a board member wishes to move for reconsideration, I don't think we need to take action.
I think Donna felt it would be helpful to have a separate resolution, so if the board wouldn't mind voting. You did effectively do that when you approved the rules.
Right, it was implicit in the rules that would change the moral character. I had put it on for an explicit.
Just to avoid confusion, then I would say confirm the action taken at the September 2018 board meeting and again at today's meeting. And with that, I will move the amended resolution.
Second.
Ruben with the second, Sean with the motion. Any further discussion? Can I substitute the roll call?
No, you were recused.
Broughton.
All right.
Broughton.
Yes.
Chen. Dellen. Duran.
Yes.
LeBron. Manning. Mendoza. Pertula.
Yes.
Selig.
Yes.
Stallings. Steinbrecher.
All right, my intention is to get through the rest of the agenda in 5 minutes. So can I have a motion to adopt 703, which are technical changes to the state bar rules?
Second.
Any further discussion? Can I substitute roll call? All right. Can I have a motion on 704 to delegate to 2 board members to study whether a waiver of the licensing fee late payment is necessary given today's news relating to the 3-week reprieve and the opening of the federal government?
To study, and if it's determined that it is warranted, they have the authority to approve implementation of any kind of response.
Yes.
I will move that, but in a slightly amended form. So we authorize 2 board members to be designated to work with staff on considering whether late fees can be waived for federal employees affected by the shutdown and fees of any kind deferred until they receive their pay.
Yeah, can't we just do it?
Well, we can go ahead and approve staff's recommendation. I think Jason.
There is a more detailed I think Jason's just trying to speed it up.
Yes.
There is a more detailed resolution that Donna has a slightly amended version of this. She and I talked about it. We could put it on the screen and adopt that instead.
Can we just leave it up to the?
I was trying to follow our chair's
to the
leadership.
trustee members who are on the, I think it's the member liaison committee that reviews all those applications anyway?
Right. The delegation to the board members who are charged with reviewing waivers.
The waivers.
Yeah. Let's do that because they can take that into account anyways, right?
Yes. So Donna, does it work for this issue to be delegated to the 2 board members who deal with the waivers? Or 3?
3 board members who deal with waivers to avoid a tie vote. And so, yeah, sort of. So certainly for the licensing fees, one of the things that we wanted to do was to be able to assure the federal employees who were impacted by the shutdown that they wouldn't be assessed a late penalty if they're unable to pay their fees. And so knowing that the process that you're proposing wouldn't allow that assurance to the federal employees. One of the other issues is things that we don't yet know about that could come up. So for example, we had on January 15th, the last day to register for the bar exam, we had a federal employee who wanted to register, didn't have the funds to do so, and asked if there was a possibility of deferring the fee. So there may be things that come up that we just can't think of right now that will need a more instantaneous response. So that's why what Sean and I had worked out had us deferring waiving the late penalty and deferring the payment, and at which point we could then consult with whether it be the 3 members who deal with the waivers or the chair of finance and planning to address further action going forward.
I think you had me at assure. So can everyone just take a look at the resolution up there and to take Renee's cue? Can I have a motion?
So moved.
I will withdraw my motion first, and then my motion is withdrawn.
Thanks, Sean. Brandon, with the motion to adopt the resolution on the screen, can I have a second? Sean with a second. Substitute recall. Any further discussion? All right, adopted. The last one, 705, a motion to adopt the diversity inclusion goals that we had discussed and put on the screen earlier today in programs. We're going to see if we're going to find them really quick. We're going to find them. Put them on there. Any further discussion? Can I substitute roll call? All right, it's adopted.
Congratulations.
Sorry? You want to scroll down on the second page?
I don't think it's on this document. No. Oh, it is. Diversity definition, not modification to goal 4. You can take modification to goal 4 out, Sarah. We haven't vetted that. The language below it as well, not diversity definition.
All right, so with no further business, I will adjourn the meeting. Thank you, everyone.
All right.